You talk about it. No, don't do this. No, sorry. See, there's a limit for idiocy also, mister. In an ejectment suit, you want the owner's. What is this? So you argue the matter on merits. You owner ಗೆ ನೀವು ಈ ತರ ಎಲ್ಲ ನೀವು ಬ್ರೈನ್ ಮ್ಯಾಪಿಂಗ್ ಟೆಸ್ಟ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರೆ ಏನು? Sorry, please argue. No, sorry. You are, mister, you are very, very unreasonable. You are very, very, very unreasonable. Yeah.
ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ ಎಲ್ಲ ಆಗಿದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೆಂಡಿಂಗ್ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಿದ್ದೆ ಗಮನ ತಮಗೆ ನಾನು ಅದಕ್ಕೆ 2050 ಇಟ್ಟು ಬಿಡಿ
sorry
2050 ಇಟ್ಟು ಬಿಡಿ ಔಟ್ ಮಾಡ್ತೀನಿ.
No, rejected. Yes, next career. ನೋಡಿ ತರಿಸ್ರಿ ಅದೇನೋ ಫೈಲ್ tomorrow
suit for eviction compromise tomorrow.
My lordship, RFA 3 times notice serve agide but our respondent ತಗೊಂಡ್ತಾ ಇಲ್ಲ. Same parties condemn petition file ಮಾಡಿದ್ದಾರೆ coordinate bench. So direction ಅವರು ಕೊಟ್ರೆ.
Your lordship, serial number 6, your lordship.
Yes, career adjournments.
Yes, sir. Adjournments phase wise. Page number 13, serial number 29. Page number 14, serial number 30 to 34.
My lords, serial number 32, my lords.
32.
I am appearing for the appellant counsel, my lords. Today we received the TCR by the parties, my lords. Next week, one date quarter will argue on the merits. I have informed the Prasanna Shetty, sir, also.
Learned counsel for the appellant seeks time list on
27th March.
Please.
Page number 15, serial number 35 to 39. Page number 16, serial number 40 to 45. Page number
44 ಇದೆ.
RFA 527 of 26 connected matter ಇದೆ. ಇದು ಒಟ್ಟಿಗೆ
list along with RFA
527 of 26.
527 of 2026. ಯಾವತ್ತು?
Next month.
Next month.
sir. Court next year end of the month.
Date put next week could. Next date ಯಾವತ್ತಿದೆ ನೋಡಿ? Next Thursday, working Thursday.
26th March. Page number 17, serial number 46 to 50. Page number 18.
Why Krishnamurthy? Ejectment suit ಏನಿದು? ಡಿಕ್ಲರೇಷನ್ ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೋದಲ್ಲ? ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಸರಿ, ನಮ್ಗೆ ಇರೋದು ನಮ್ಮ ರಾಸ್ಟರ್ ಇರೋದೇ 2023 and onwards. Learn counsel for the respondent. Please intimate the other side. Learn counsel for the respondent number 1
last week any date may be done. This month last week my
list on date
26th March. Page number 18, serial number 51 to 55. Page number 19, serial number 56 to 60.
My lord, serial number 56. My lord, appearing for the appellant, I seek for short accommodation, my lord.
Learn counsel for the appellant seeks time list on so and so. Yes.
My lord, interim order may be extended, my lord.
Interim order is extended to the next date.
Grateful.
Please intimate the other side.
Please, my lord.
If you don't intimate the other side, I will take it up when the matter is called.
Please, my lord, we will.
Your lordship, serial number 6, your lordship. Notice
number
6, your lordship.
Please wait.
List number 1 for order, serial number 1. V.
Prabhakar. Third counsel for the appellant submits that he has paid the cost. Ready, na?
Paper book file ಮಾಡಿದ್ದಾರೆ. I have not given the e-copies. I have been asking him to give permission.
ಅವ್ರದ್ದು ಕಾರ್ಪೊರೇಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅವ್ರದ್ದು ಮೇಲೆ ಏನು ಇಲ್ಲ, ಅದು ಕೊಡ್ತೀನಿ.
But our party entitled. Learned counsel for the appellant is directed to furnish a complete set of the paper books to the learned counsel for the respondent number 3. List on. Admit ಆಗಿದೆಯಾ?
ಇದು ಫೈನಲ್
List on so and so for final hearing.
26th March.
26th March.
Page serial number 2,
M.A. Gowda,
Goda and
learned counsel for the appellant submits that cost of rupees 2000 is paid. Ready? Tomorrow? To pay. For appeal, you will file a statement of objections. Huh?
There is no provision to file.
Then?
I will argue because I don't have TCR.
Now, shall I take it up tomorrow?
Because I don't have TCR. There is no.
Learned counsel for the respond number 1 seeks time list on date code.
26th March. Page number, serial number 3, Jairaj DS.
After service of notice to response 1 to 4.
No, I have already entered appearance.
Huh?
I have already entered appearance.
For 1 to 4.
Oh, inactive.
Mr. Dinesh Rao, N. Dinesh Rao has submits that he has entered appearance for response 1 to 4. Office is directed to show his name in the cause list.
Name is shown me.
As counsel for response 1 to 4. Yes.
I want to find my objection today.
Yeah, objection.
So delay is almost 1 year delay.
Ah.
And moreover, I want to see that it's settled because now that the
Learned
original
counsel for the response 1 to 4 seeks time to file objections to IA 1 of
one, and you have to give me copy of IAS 2 and 3.
1 of 24. 24.
Yes, sir, 1 of 20.
1 of 24 for condemnation of delay. Learned counsel for the appellant is directed to furnish copies of IA
2 and 3.
2 and 3 of
24.
24. Yes. List on date code.
26th March,
25th.
25th ಬರಲ್ಲ, criminal petitions ಬರಲ್ಲ. 27th,
26th.
serial number 4, Abhinay YT.
A memo is filed reporting the death of appellant number 2 and that appellant number 1 be treated as the LR of appellant number 2. In view of the memo, the appellant number 1 is treated as the LR of the appellant number 2. Counsel for the appellants is directed to make appropriate entries in the cost title indicating the death of appellant number 2 and that appellant number 1 is the LR. What about process?
Needfully done.
The learned counsel for the appellant submits that process to issue notice to the unserved respondents is already paid. So office is directed to check, verify and issue notice to the unserved respondents. What about not claimed respond number 8, address notary?
Steps 2. Yes, sir.
My lord, in this case, only respondent one is a contesting respondent, my lord.
Address check ಮಾಡಬೇಕಲ್ವಾ ಎಷ್ಟು ಸತಿ ಹೇಳು. Not claimed ಅಂದ್ರೆ ಏನು? ಅದೇ ಅಡ್ರೆಸ್ ಇದ್ರೆ ಯಾಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು? Same address, huh? The notice issued to the respond number 8. Sorry, the address of the respond number 8 mentioned in the cost title corresponds to the address mentioned before the trial court. Hence, notice to the respond number 8 which is not claimed is held sufficient. Office is directed to show the name of respond number 8 in the cause list and also indicate that notice to him is held sufficient. What about non-filing of acknowledgement for having served copies to the advocates before the trial court?
We'll file it today.
My lord, there is no pending of trial court matter. There is no pending, my lord. Matter is not pending in the trial.
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಲಾಯರ್ಗೆ ಕಾಪಿ ಶುರು ಮಾಡಿ ಅಂತ ಹೇಳಿದೆ.
My lord, I'm for the respondent one. I'm a contesting respondent. So 381 days is delays there.
ಆಯ್ತು.
Interim order.
Only interim order is not there, my lord.
Learned counsel for the appellant undertakes to furnish an acknowledgement for having served the advocates who represented the respondents before the trial court during the course of the day.
My lord, regarding maintenance.
Yes, non-compliance of office objections. What is this? Non-compliance of office objections raised on IA 1 of 26 for amendment.
Well, it was it will
Copy
comply
ಕೊಡಪ್ಪ. ಒಂದು IA copy ಕೊಡು.
during the course of the day.
Learned counsel for the appellant undertakes to furnish copies of IA 1 of 2026 to the learned counsel for the respondents during the course of the day. Hence, office is directed to put up IA 1 of 26 for consideration. Full stop. Non-filing of non-compliant office raised wakalat by Vishwajit party name does not tally with appeal. Yes.
My lord.
Vishwajit andre yaru? Who is this Vishwajit? ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ನೋಡೋದಿಲ್ವಲ್ಲಪ್ಪ?
They are not,
You don't see the cost list? What is his last objection?
Last objection was regarding the wakalat filed by the AS Vishwajit.
ಯಾರಿದು?
Advocate sir for R2, sir, R32, sir.
AS ವಿಶ್ವಜಿತ್ ಅಂದ್ರೆ ಯಾರು?
Advocate for R32, sir.
R32.
Yes, sir.
ಯಾರದು?
Advocate.
ವಕಾಲತ್ ಟ್ಯಾಲಿ ಆಗಲ್ಲ ನೋಡಿ. ಟ್ಯಾಲಿ ಆಗದೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ.
they are not contested in the trial court, in the FDP proceedings.
Sir, we are not on that.
Yes, ma'am.
R32 ಯಾರು ನೋಡ್ರಿ?
Yes, sir.
ದಿವ್ಯಾ ಕಾರ್ಪ್ ಪ್ರಾಪರ್ಟೀಸ್. ನೋಡಿ ವಕಾಲತ್ ನೋಡಿ ಯಾರು ಹೆಸರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಅದು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರೋದು ಏನು ಕೇಳಿ? ಅದು ಕ್ಲಿಯರ್ ಆಗ್ಬೇಕಲ್ವಾ? Office raises objections and puts up before the court so that it can be cleared. Prakul Tadi, respondent. Prakul Tadi ಅಂದ್ರೆ ಯಾರು? KC Ashok. Managing Director. I, Prakul Tadi, respond number 32 in the present proceedings, retains so and so, so and so. There is nobody called Prakul Tadi. Prakul, the wakalat filed by Mr. A.S. Vishwajit shows that he has entered appearance for one Mr. Prakul Tadi. However, the cause title does not indicate that respond number 32 is respond number 32 in this appeal is Prakul Tadi. Hence, the wakalat filed by the learned counsel for filed by Mr. A.S. Vishwajit is rejected. Any objections?
I already filed, my lord. 381 days delay is there. So during pendency of the partition suit, they purchased the property 14 guntas. So they are not contested. I filed the FDP. After they are not appeared, after drawing the decree and I filed the execution, only 3 guntas has been allotted in my favor in the FDP. Now they challenge after lapse of 381 days. They are now seeking a permission to.
Suit is contested by the other family members.
Other family members, only 2 members, my lord. They are not challenged at FDP, RF.
ಹೇಳಿದ್ದೇನು ನೀವು ಹೇಳ್ತಿರೋದೇನು? Whether other family members have contested the suit.
Yes, my lord.
ಯಾಕೆ ಅರ್ಥ ಯಾಕೆ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ? Why do you run around with a bulletproof head?
They are contested the suit.
They have contested the suit.
Yes,
so now this person is a purchaser.
Purchaser.
Yes, Mr.
My lords will argue this on point.
And counsel for the appellant seeks time to address arguments on IA 123. List on ಯಾವತ್ತು ಬೇಕು?
My lords, any date of except 18th.
26.
List on ಯಾವತ್ತು ಬೇಕು?
7th March.
27th.
Much. Entry order may be extended.
Entry order is extended to the next.
Appeal number 5, Ravi Shankar R.
The substituted service,
carried out paper publication with respect to respondent number 3.
Substituted service of notice to the respondent number 3.
Sri B.K. Gopal Shetty, Sri B.K. Gopal Shetty, Sri B.K. Gopal Shetty.
Is taken out in Kannada Prabha Kannada Daily and Deccan Herald English Daily. The respondent number 3 is called out, he is absent. He no, she no?
He, my lords.
He is absent. Hence notice to the respondent number 3 is held sufficient. Officer directed to show his name in the cause list and also indicate that notice to him is held sufficient. List on
date
admission ಬರ್ಬೇಕಾ?
Admission. Date
on date for admission.
Yes. 26th March.
26.
Serial number 6, Shankarappa.
What about this hand summons, Mr. Ravi Shankar? What about this hand summons?
Non-filing of.
That was issued to R3.
Yes, my lords. We were not able to find the counsel. He was not present in the.
Then return the hand summons. You at least return the hand summons. It's a court property, mister. It's not your property. The learned counsel for the appellant undertakes to return the unserved hand summons to the respondent number 3. This list on so and so for admission.
Serial number 6, Shankarappa.
Appear for the appellant, your lordship. Notice has been issued and not yet been served on the respondent 4 to 10. And I request you to grant 2 weeks of time, your lordship.
List after receipt of TCR. And after service of notice to respondent number 4 to 7.
4 to 10. 4 to 10, lordship.
4 to 7
For sure, lordship.
Yes.
After 2 weeks, your lordship.
Serial number 7, Telecast SV.
My
Don't
lord,
mention
serial,
orders matters at 10:30 for adjournment.
Sure,
Don't do this before any other court.
apologies, lordship.
my lord, serial number 7, appearing for the appellant, my lord. We have served on R2 and R5, my lord, and it has returned as refused. It may be held sufficient, my lord.
I appear for respondents 4, 6 and 7, my lord.
Please wait, there are a host of office objections. One page fully the office objections.
Several IAs were filed.
Steps to be taken in respect of R2A.
My lord, we have taken steps for R2A and R5, my lord. It has returned back as refused.
So far as
We have taken several steps, my lord.
refuse ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಅದರಲ್ಲಿ one submission I want to make. So far as R5 is concerned, she is unable to bedridden and not able to even to speak. At that time I filed an affidavit and memo. Now my lord, they filed an application to appoint guardian. That is the son. I have filed a now memo saying that I am agreeable to be a guardian and take notice and filing wakalat for 5. So that objection serial number 4 to 6 ಇದೆಯಲ್ಲ ಅದನ್ನು I think based on my submission your lordship may be able to close that.
Where is that your application for appointment of a guardian?
ಇದೆ serial number ಇದು ನೋಡಿ IA. It's already they have filed.
You have filed some memo along with some affidavit.
That is because refusal was not there. She was bedridden and she was not been summoned. But I think now it is all cured because I am filing wakalat voluntarily as a guardian for her.
For R5.
R5. The guardian application is nodi.
ಎಲ್ಲಿದೆ application?
The application is filed to appoint a guardian under Order 32. It's also listed, my lord. IA 2 of 25 ಅಂತ ಇದೆ ನೋಡಿ. 2 of 25.
Direction. IA 2 of 25 for direction, sir.
ಅದೇ ಡೈರೆಕ್ಷನ್ ಅಂದ್ರೆ ಅದೇ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಗಾರ್ಡಿಯನ್ ಅಂತ ನನ್ನನ್ನ ಗಾರ್ಡಿಯನ್ ಆಗಿ ತಗೊಳ್ಳಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ನೋಡಿ ಬೇಕು.
IA 2 of 25.
I think that's ನೋಡಿ ಒಮ್ಮೆ
filed by the respondent number 6.
5.
Filed by the respondent number 6 alva. How can 5 file when he is in the bedridden?
Correct. ಅವರ ಗಾರ್ಡಿಯನ್ ಆಗಿ ನನ್ನ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. That is a son. I filed a memo saying that she is unable to do that at that time. Please see the IA, my lord. So I am agreeable to accept as a guardian for the purpose of the case. So that service 5 will be held sufficient in that view, not refusal. On their application for appointing guardian, I am agreeable to be a guardian, son. Please, sir. Am I right? The number? Memo ಹಾಕಿದ್ದೀವಿ ಇಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ
IA 2 of 25 filed by whom?
By the appellants, my lord, saying that I may be appointed as guardian if I am correct.
Filed by the appellants.
IA 2 guardianship ಇದು ನನಗೆ
filed by the
ಗೊತ್ತಿದ್ದಾಗೆ IA 2 of 25.
Please, my lord, it was
2 of 25.
Sir, ಅದು ಯಾರು ಫೈಲ್ ಮಾಡಿದೆ ಹೇಳಿ ಸರ್.
Appellant has filed.
ಅಷ್ಟೇ ಹೇಳಿ ಸರ್. Yes, madam.
My lord, we had filed an application to appoint R6 as the guardian for R5, my lord. Previously, statement of objection was filed for that, and now he is agreeing to be the guardian on behalf of
IA 2 of 25. I don't know why you people, why do you get lost, sir? We are still in preliminaries, sir. Preliminaries, why you are not helping the court to clear the preliminaries?
Problem ಆಗಿದೆ ಅಂದ್ರೆ 2 of them died. ಅದಕ್ಕೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಆಗಿದೆ. That is what has happened. And this IA 5 ಇದು respondent 5 ಏನಾಗಿದೆ ಅಂದ್ರೆ she lost her memory and bedridden. ಹಾಗೆ ಆಗಿರೋದ್ರಿಂದ ರಿಫ್ಯೂಸಲ್ ಆಗೋದಿಲ್ಲ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಗಾರ್ಡಿಯನ್ ಆಗಬೇಕು ಅಂತ ಆಯ್ತು.
25 is filed by the appellants. to appoint the respondent number 6 as the next friend to prosecute this appeal on behalf of the respondent number 5. It is stated in the affidavit accompanying the application that the respondent number 5 is bedridden and is not in a position to
ನಾನು ಹಾಕಿದ್ದು ಅದು
he is bedridden and
ಅದಲ್ಲ ಇದು ನಾವು
he is bedridden and is not in a position to
He's
take
reading
steps
IA.
to contest this appeal. It is also stated that the notice issued to the respondent number 5 is returned unserved with an endorsement refused. Full stop. In view of the fact that the respondent number 5 is bedridden, the appellants request that the respondent number 6 be appointed as the next guardian, next friend to contest this appeal on merits. The respondent number 6 has no objection to be appointed as a guardian of the respondent number 5.
As
In
next
that view of
friend
the
ಅಂತ
matter,
ಇದ್ದಾರೆ ಅವರು.
as next friend of the respondent number 5. In that view of the matter, IA 2/25 is allowed and the respondent number 6 is permitted to represent the respondent number 5 as the next friend and contest this appeal. Full stop. Mr. YK Narayan Sharma, office is therefore directed to show the name of Mr. YK Narayan Sharma as the counsel representing the respondent number 5 also. Next, what is this other appeal?
And the R1 regarding the memos, my lord.
IA 4/25 is
ಅದೇ
filed for more.
IA ಇದು ನೆಕ್ಸ್ಟ್ ಸ್ಟೆಪ್ಸ್ ಟು ಬಿ ಟೇಕನ್ R5 ಅಂತೂ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಹೋಯ್ತಲ್ಲ, ಅದ್ರ ಜೊತೆ ಮೆಮೊಗಳು IA 2 ಮತ್ತು ಮೆಮೊ ಆ 4 ಐಟಮ್ ಒಟ್ಟಿಗೆ ಹೋಯ್ತು ಇವಾಗ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್.
IA 4 ಏನಿದು for bringing the LRs of deceased R1.
ಅದು ಬೇರೆ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಒಂದೊಂದಾಗ ಹೋಗೋಣ.
ಆಯ್ತಾಯ್ತು. IA 4 bring the LR of R1 ಅಂತ ಹೇಳಿದ್ರಲ್ಲಿ they filed an application that there is a foster son. He has to be appointed as the LR or he must be brought on record as LR. I said that foster son has no right. If he is a son adopted or otherwise he can. That's all objection I have raised.
IA 4/25 ಎಲ್ಲಿದೆ?
Purvi.
That is R1 ಸತ್ರು ಅವರ ಪರವಾಗಿ ಗೊತ್ತಿಲ್ಲ. ಹೆಸರು ನೋಡಿ ಅದೆಲ್ಲ ಸೀರಿಯಲ್ ಇಡಬೇಕು ನೀವು.
IA 3 ಇದೆ
ನೋಡಿ, ಒಂದು ಬಂಡ್ಲು ಅಲ್ಲಿದೆ ಹಿಂದೆ, ಅದರಲ್ಲಿ ನಾನು ಮ್ಯಾನೇಜ್ ಮಾಡ್ತೀನಿ ನೋಡೋಣ. ನೋಡಿ ಫಾಸ್ಟರ್ ಸರ್ ನೋಡಿ ಹೆಸರು ನೋಡಿ. ಒಂದು ಮಿಸ್ಟರ್ ಚೇತನ್ ಕುಮಾರ್ ಅಂತೇಳಿ ಫಾಸ್ಟರ್ ಸನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನೋ ಚೇತನ್ ಕುಮಾರ್
ಅಂತ
ಏನ್ ಹೇಳ್ತಾರೆ affidavit ಅಲ್ಲಿ?
IA 4 ಅಲ್ಲಿ ನೋಡಿ, ಪೇಜ್ 3 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಹೆಸರು ಅಡ್ರೆಸ್ ಎಲ್ಲ.
Yes, who appears for this appellate? Yes, madam. How can a foster son be brought on record as a LR?
My lord, my senior will be addressing for that part, my lord.
May you please bring your senior.
And there is there's some
Madam,
death
this
in his house today, my lord, so he won't be able to attend.
Counsel for the appellant seeks time to address arguments on IA 4/25, 3/25. And 1/24. List on date.
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4, 5 ಇದೆಯಲ್ಲ, ಅದು ಇಟ್ ಈಸ್ ನೌ ಕವರ್ಡ್ ಬಿಕಾಸ್ ಆಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆರ್ಡರ್. ಆ ಮೆಮೊ ಹಾಕಿದ್ದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೆಲ್ಲ.
View of the above order passed on IA 2/25. There is no need to take steps in respect of the unserved respondent number 5.
ಅಷ್ಟೇ.
My lord, R2A also is refused, my lord.
Full stop. Since the notice issued to the respondent number 2A is refused, notice to the said respondent is deemed is held to be sufficient. Office is directed to show the name of respondent number 2A in the cause list and also indicate that notice to him or her or not is held sufficient.
Him,
Him.
ಮಗ ಅವ್ರು ಅಲ್ಲಿಲ್ಲ ವಾಸ ಇಲ್ಲ. Very, I am not representing them.
Yes.
Serial number 8.
I appeal for
Public.
appellant, my lord. In this case, my lord, respondent one died. Then office objection is, Kiran Kumar, we have served the copy. Then respondent died, he filed NOC before this honorable court. Then Vasant Kumar appeared. In the meantime, he died on 27/10. Then we filed an application IA. And my learned friend has filed Wakalatnama for legal heirs. That IA too is pending. So office objection has to be overruled because caveator is no more. We have served the copy to Kiran Kumar. Kiran Kumar has retired from the case. And my learned friend Vasant Kumar filed Wakalatnama. And now our respondent one is no more.
Any objection?
I have no objection for
Therefore,
that.
IA 2/25 is filed to bring the legal heirs of the deceased respond number 1 on record.
I have already filed
Heirs of the respond number 1A. The learned counsel for the respondent 1A to D has no objection to allow IA 2/25. Hence, IA 2/25 is allowed and the LRs of the respond number 1 are ordered to be brought on record. Counsel for the appellant is directed to amend the cause title. Yes.
What has happened on 4th, the matter was advanced in the actually.
Possession ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಅಂದ್ರಲ್ಲ.
Possession ತಗೊಂಡು ಇದಿದೆ. But again, he gained the re-entry. No, my lord. Order passed. Order passed.
If he is not in, if it is not executed ಅಂತ ಬರ್ದಿದ್ನಲ್ಲ.
It is fully executed, but he gained re-entry forcibly. Not so, my lord.
Yes.
ಅದು 5 ಗಂಟೆ 5:15 probably my learned friend has given the communication that is matter is state.
ಆಯ್ತು ಇದು ಅಮೀನ್ದ ಇದ್ದಿರಲ್ವಾ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇರಲ್ವಾ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆಯೋ ಇಲ್ಲ ಅಂತ.
Fully execute ಆಗ್ಲಿಲ್ಲ.
ಇದೆ ಅಮೀನ್
report ಹಾಕ್ತೀನಿ. Amount report, I couldn't get the report.
Learned counsel for the respondent submits that after the interim order was granted by this court, the appellant has forcibly entered into the premises. That is his submission, sir.
No.
This submission.
Yes, my lord.
Can I record his submission?
No. I have
Can I record?
My lord, that is.
Mister, why don't you
I
understand?
understand.
Can I record his submission?
No. Your lordship is liberty. Your lordship is at liberty.
Huh?
No, that submission can be recorded. But
that is what I am doing.
But
Please
my
allow
submission
me.
is.
Please allow me to record his submission.
ಆಗ್ಬೋದು. ಅದು ಅಮೀನ್ ಅವರು 95% ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಯಾವುದು ವಸಂತ್ ಕುಮಾರ್.
Into the premises.
Take it legally ರೀ. ನಾವು you ask for the key, ನಾವು hand over ಮಾಡ್ತೀವಿ, but not by violence ರೀ. ಮತ್ತೆ ಯಾವಾಗ ಕೊಡ್ತಾರೆ ಕೊಡ್ಲಿ ನನಗೆ. ವಾಟರ್ ಸ್ಪ್ರೆಡ್ ಮಾಡಿದ್ರೆ murder will take place. ಯಾಕೆ ವೈ ಪೀಸ್ ಲವಿಂಗ್ ಸಿಟಿಜನ್ ಯಾಕೆ ವೈ all these things should happen in our India. I can understand the Islamic countries something happens, we should not in our India. Our policy is live and let live. Let there be not a violence, and we will never. Your lordship will kindly see. It was not executed. The client was very much there. Let him produce the copy of the Amin.
Can I record what you said? In Islamic countries, this can happen. Barila adana.
ಇಲ್ಲ ಅದು ಆಗ್ತಾ ಇದೆಯಲ್ಲ.
No, can I record that?
ಇಲ್ಲ, I have no objection.
Can I record it?
Your lordship will kindly see. That country happens. Not in India. We are a democracy.
ಅಸಂಬದ್ಧವಾಗಿ submissions ಮಾಡಬೇಡ್ರಿ.
ಇಲ್ಲ. No.
This is a court of law. This is not a marketplace. This is not your office.
No. Your lordship is right.
KG Road.
ಇಲ್ಲ, ನಮ್ಗೆ pain ಆಗತ್ತೆ ಸಾಹೇಬ್. We feel pain. This thing incident.
Argue the matter on merits, mister.
Yes, we will argue the matter. ಈ pain ಆಗತ್ತೆ ನಮ್ಗೆ ಇಂತ ಇದು taking by force when matter is pending before your lordship.
He therefore submits
for argument.
He seeks time to place on record the bailiff's report to indicate that the possession of the premises was already taken in execution of the decree.
ಆಗಿಲ್ಲ ಅಂತೆ 95% ಆಗಿದೆ. then gained the
bailiff report ಇರಬೇಕಲ್ಲ ಸರ್.
ಅದು ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು ಬೇಕು?
I will file the bailiff report. ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ.
ಯಾವತ್ತು ಬೇಕೋ
for
whichever date you want to please take.
Next week in it.
List on so and so. Yes.
My
R2 and
lord.
R3, they are not necessary parties.
They are the tenants. Your lordship may stay back.
R2 and R3, they are necessary parties alone.
Necessary, they are the tenants. They all suffered. They are not challenging it. This only third different. ಅವರೇ ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅವರು. They are necessary.
Yes, next.
My
Stay mechanism.
lord, if I
Order dated so and
may
so.
be permitted to.
Order
Apologies.
dated so and so is extended till the next date. Yes,
You have dates every court officer.
date code.
2nd April.
Aye.
Serial
That
number
is Maitrey Krishnan.
Krishna.
My lord, if I may be permitted to make a submission, my lord.
Madam, please wait for your turn. Your case is
My lord,
over.
it's serial number 7, my lord.
Yes, next, Maitrey
For the
Krishnan.
appellant, my lords.
Ah.
Lord says await notice
List after service of notice to response 1 and 2.
obliged.
Serial number 10, Sundaram K.
Lord, apparent. I thank you for the respondent. Lord, this matter, your lordship, my lord, had asked the other side to file their.
The memo of calculation, lordship, sought, it
calculations.
has been filed on.
I have received it, my lord, in response, my lord, I'm
What is this
filing my
memo
lord.
of calculation?
I have filed it.
Memo of calculation filed by appellant advocate. This is regarding the back wages.
Allah, regarding
What has
that
happened?
subsistence allowance
He
which my
said
lord.
that there is a due of a substance allowances we have paid.
My lord,
I have
according to
provided.
him, my lord, his statement
now-
says 5 lakhs.
My friend is submitting, giving a copy of counter today, my lord.
My lord, 27 lakhs is what's its due.
My lord, I oppose my lord. He's been unnecessarily prejudicing that 25 lakhs. We will write to argue. This MFA itself is not maintainable. He has filed one more suit.
Then, my lord,
pending
I'll
case.
address
He has
my
filed one
arguments
more
on
suit
merits.
Before the trial court. He's been, I'll have to file a contempt against him, my lord.
Yes, you do whatever, you are
I
free
will
to do
it.
whatever
That is,
you
I will
want.
not
I
seek
am
a-
not
My lord,
restraining
he's
you from
giving
doing
a-
so.
After bench, he's giving a copy now. He said, I have filed the memo of calculation. He should have given it earlier. And what has happened, there is no due to lordship may be here.
No,
The
Mr.
maintainability of the
Please
MFA.
file
my
a
lord.
memo of calculation.
Yes, I filed it, my lord.
If you want to file your reply, you file it.
Yes, my lord. I will file, my lord. He is given just now, my lord. I will file it.
Turn counsel for, ask clearly.
Sumna, contempt,
ಇಲ್ಲ,
you
ಅವರು-
don't unnecessarily.
No, what is it is disturbing me,
Sukumaran.
my lord. Simply is prejudicing
Please.
that 5 lakh, no 5 lakh, 2 lakh,
Please.
everything we paid.
Please don't identify yourself with your clients.
Absolutely.
No, my lord, I am
This
not,
is-
I only
Please
just said
generate,
it. I have-
please generate light, not heat. Please don't generate heat in the court. Generate light. Don't generate heat. ನೀವು ಸ್ವಲ್ಪ ಜೋರಕ್ಕೆ ಹೋಗೋದು, ಅವ್ರು ಜೋರಕ್ಕೆ ಹೋಗೋದು,
ಇಲ್ಲ,
ನಾನ್ ಜೋರಕ್ಕೆ ಹೋಗೋದು.
What has happened, I only just said it, what I have filed it. And he has given a counter, we'll file it, there is no due. That's all I wanted to make a submission. And what has happened?
You
it is-
say
as your lordship rightly said it, don't take personally. I am doing, discharging my professional. His client has been writing an anonymous letter alleging against the lawyer.
Sir,
But
they write
That I will deal it
again, my
separately.
learned friend
They
is
write
going
letter.
out
I am
of.
just telling it. My friend, I discussed with my friend
They
also.
write
I am
letters
not
against
bringing into this court.
judges. They write letters against judges.
No, I'm just,
So
what,
therefore-
no, my lordship has said it, I just making it to note of it, that's all, I'm not, anything in, not that, that will deal.
After after they argue the matter, when the matter is reserved for judgment, they write letters to the Supreme Court, they write letters to the Chief Justice, because in the course of argument, ಸ್ವಲ್ಪ ತಡೀರಿ, in the course of arguments, we would have told, ಈಗ ಯಾಕೆ, ಹಿಂಗೆ ಯಾಕೆ, ಅದು ಯಾಕೆ, ಇದು ಯಾಕೆ ಅಂತ ಕೇಳಿರ್ತೀವಿ. So they make an assessment, oh, judge ಹಿಂಗೆ ಬರೀತಾನೆ. So write letters. So don't be under the impression that you are the only one person who has been
No,
at the receiving end. Even judges are at
But
the
I-
receiving end.
that is.
Once you're in public life, you can't help it. All these things will come. They will call you by names. They'll call you whatever they want. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? You can't help it. Don't take it personally.
No, I am not taking it. I just brought you the notice since your lordship has said it, not personally. If you have to personally, I won't this thing. I am doing a discharge of my professional.
Barkoli.
Yes,
The learned counsel
We'll
for the
file counter.
respondent seeks time to file objections to memo of calculation filed by the learned counsel for the appellant. IA 5 of 25 will be considered along with the main appeal. IA 5 of 25 and the affidavit by way of rejoinder filed to IA 1 of 25 shall be considered along with the main appeal.
When the LCR was called, they said they will file a paper books. It is not
IA
been done.
2 of 25. What is this permission for? When permission ಏನಿದು?
ಅಲ್ಲ, ಅವ್ರು ಹಾಕಿರೋದು.
IA 2 of 25, IA 1 of 25 shall also be considered along with the IA 4 of 25 shall also be considered along with
Most
the
of
main
these
appeal.
IAs will not
All
survive,
these
my
IAs
lordship.
you
Once
filed
your
it.
lordship hears
My
it.
lord, they have filed those IAs, not me.
Yes.
number 5 only.
IA number 5 only I filed by me. my
Yes,
lord.
I'll consider all this application along with the merits of the.
Yes, my lord.
Next, list on yavat ಬೇಕು.
Next week because arrears ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
ಒಂದು ಡೇಟ್ ತಗೊಳ್ಳಿ ಯಾವತ್ತು ಕೊಡಿ. ಪ್ರಸನ್ನ VR.
Serial number 11, Prasanna VR, notice await lords.
List after service of notice to respondent.
Matter lords. Second matter lords, the same, between the same parties, with respect to different survey number. Interim order expires lords in the second matter lords.
Serial number 12 ಅಲ್ಲಿ list after service of notice to R1. Is there an interim order?
Interim order is operating lords.
Interim order granted release extend till the next.
Please.
First matter ಅಲ್ಲಿ ಇಲ್ವಾ 11
ಅದರಲ್ಲಿ
ಅಲ್ಲಿ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ emergent, ಅದು admit ಆಗಿ
Next,
notice.
ನರಸಿಂಹಯ್ಯ.
13, Narsimaya K.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಅಪಲೆಂಟ್ your lordship.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಆಗಿ
Mediation report to be.
ರಿಪೋರ್ಟ್ ಕೂಡ ಬಂದಿದೆ. ಇವತ್ತು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 1 ಬಂದಿಲ್ಲ ಇವತ್ತು. ಶಿ ಇಸ್ an aged lady.
ಹಾ?
Aged lady, she has to sign on the order sheet for this lordship.
ಕೊಳ್ಳಿ. The defendant number sorry, plaintiff.
It is a plaintiff appeal.
Defendant number 4 ಇದ್ದಾರೆ.
Defendant number 1 and 2 also. Defendant number 4 is not a party to the appeal.
No, I don't know. Defendant number 4 is also arrayed as an appellant in this appeal.
Yes, he is an appellant. He has become an appellant. Brothers. own
Therefore,
brother.
ಅದನ್ನೇ ನಾನು ಬರೀತಿರೋದು.
Own brothers.
The
R1
plaintiff
is
and
the mother.
defendant number 4 in OS number 7021 of 2005 on the file of the 17th additional city civil and sessions judge Bengaluru have filed this appeal challenging the judgment and decree dated
9/10/2009.
9/10
2009.
9/10/2009
Yes, ma'am.
2009.
Delay condone ಆಗಿದೆ sir.
The-
Court bench ಅಲ್ಲಿ.
This appeal was referred for mediation and the parties have settled the dispute and have filed a memorandum of settlement which reads as follows, copy moved. The terms of the settlement is perused and since the same is just and proper, the same is accepted. Consequently, this appeal stands disposed of in terms of the settlement arrived at before the mediation. Full stop. Office is directed to draw a decree in terms of the settlement. Parties idara?
ಅದೇ ಒಬ್ರು R1 ಒಬ್ರು ಬಂದಿಲ್ಲ. ಇವರು ಇದ್ದಾರೆ. appellant ಇದ್ದಾರೆ. ಇವರು ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
ಇಲ್ಲ ಅಲ್ಲಿದ್ರಲ್ಲ mediation ಮುಂದೆ ಇದ್ರಲ್ಲ.
ಬಂದಿದೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದಾರೆ.
Next.
Serial number 14 person Sri Anand, V Anand, filing.
Memo for withdrawal.
A memo is filed by
Along with memo for refund of court.
the appellant to withdraw this appeal. Huh?
Settled out of court.
Good thing you have done, Anand. ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡಿ.
ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಬೇಡ. Court fee.
Good memo is filed with the appellant to withdraw the appeal. The memo is taken on record and the appeal is dismissed as withdrawn. An application is filed for refund of court fee on the ground that the parties have settled the disputes outside the court. In view of the judgment of the apex court in the case of so and so, the refund of court fees is, full refund of court fees is ordered.
One submission, please. My learned friend has agreed to vacate the premises on or before 27th of this month. That can also be recorded.
No, anyway, if he doesn't vacate, you can always execute it.
Published.
Serial number 15, Rasita DJ.
For the appellant in this, my lord, respondent to 4, 6, 8 to 13, notice is refused by them, my lord.
ಬರ್ಕೊಳ್ಳಿ address correct ಆಗಿದೆಯಮ್ಮ?
Please, my lord,
Have you
same
checked the address of the
as same as per the trial court.
the address of the respondent number 2468 mentioned in this appeal corresponds with their addresses mentioned before the trial court. The notice issued to the above respondents is returned unserved with the endorsement refused. Hence, notice to the said respondents is held sufficient. Office is directed to show the names of respondent number 2, 4, 6 and 8 in the cause list and also indicate that notice to them is held sufficient. What about R14?
R14, my lord, fresh steps have to be taken. but he was placed ex parte before the trial court.
Since the respondent number 14 was placed ex parte before the trial court, notice to the said respondent is not necessary. Hence, notice to respondent number 14 is dispensed.
Please.
The respondent number 1 has filed 2 applications. Because the respondent only the plaintiff.
Declaration suit
Declaration.
Declaration.
Then vacating model.
But I have sought permission. What has happened? I have actually dug the borewell to a certain extent. That's what they say. That after decree, I have dug the borewell. What requirement is that? I want to actually dig further this one. That's the permission I have sought for.
ಏನಕ್ಕೆ?
Water.
To install pump and motor.
Building ಇದೆ. ಅದು ನೀರಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Building ಇದೆಯಾ ಅಲ್ಲಿ?
Lord, it is vacant. I have the photographs.
ನಮ್ದು full building with vacant ಇದೆ. They are claiming vacant portion. A portion of it.
Appellant property, my lord, that is vacant, 60/40. The other portion, plaintiff, we are not concerned.
120 into 40. ಅವ್ರದ್ದು 60 into 40. ಬೋರ್ವೆಲ್ ನಾನು ಡಿಗ್ ಮಾಡಿದ್ದೀನಿ. ಸ್ಟಾಪ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಇವಾಗ. Only permission is that allow me to actually dig the borewell. Tomorrow they
allow me to
dig further.
Dig further.
ಇನ್ನೊಂದು 300 ಅಡಿ ಹಾಕ್ಬೇಕಂತ.
ಅದೇ ಅರ್ಧಂಬರ್ಧ ಡಿಗ್ ಮಾಡಿದ್ರಿ?
ಅಷ್ಟೊತ್ತಿಗೆ ಸ್ಟೇಟಸ್ ಕಾರ್ಡ್ ಅದರ ಸ್ಟೇಟಸ್.
Then let it be remain. ನೀರ್ ಸಿಕ್ಕಿಲ್ಲ ತಾನೆ?
ಅಲ್ಲ ನೀರ್ 300 ಅಡಿ ಹಾಕಿ ನೀರ್ ಸಿಕ್ಕುತ್ತಲ್ಲ.
ಸಿಗುತ್ತಾ? ಏನ್ ಗ್ಯಾರಂಟಿ?
That's what the guarantee they have given. They have already spent so much.
No. ಬರ್ಕೊಳ್ಳಿ. ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಅದು?
IA.
Lord, it is IA 1 of 26.
IA 1 of 26 is filed by the respondent.
One. ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇನೆ because he is actually contemplating to sell the property.
That I undertake. We will not sell the property.
ಆಗ್ಬೋದು.
IA 1 of 26 is filed by the respondent to vacate the order of.
Vacating ಕೇಳ್ತಾ ಇದ್ದ ನಾನು. Taking permission.
No, vacate interim order.
ಏನೋ ಹೇಳಿದ್ರು to please to vacate the interim order ಅಂತ ಕೇಳಿದಿರ ಇಲ್ಲಿ. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಹಂಗಿದೆ. To vacate the interim order dated 10/12/2025. Full stop. It is stated in the affidavit accompanying the application that ಇಲ್ಲಿ ಬೋರ್ವೆಲ್ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಹೇಳಿದ್ದೀನಿ. ಒಂದು ಫೈಲ್ ಅಲ್ಲಾಗ್ಬಿಟ್ಟಿದೆ.
Stated in the affidavit accompanying the application that the respondent number 1 is facing scarcity of water and therefore he had made arrangements to sink a borewell on the northeastern corner of the plain scheduled property. Full stop. He contends that the borewell is sunk up to a depth of 300 feet, but
$800 feet. Para 14.
800 feet. However, it did not yield any water, and therefore the respondent number 1 intends to dig further, to further drill the borewell. And the interim order is coming in the way. Interim order dated 10/12/2025 is coming in the way. Full stop. It is also contended that there are 8 tenements constructed on the western portion of the plain scheduled property, and due to scarcity of water, the tenants are facing extreme difficulty. It is also claimed that some third parties are dumping waste on the western portion of the plain scheduled property, and therefore it is prayed that a compound wall be permitted to be erected on the eastern side. Full stop. Next para. Appeal admit agidya?
Not on 10-12 formally it is.
Admit ಆಗಿಲ್ಲ, interim
Admit
Interim
agidya?
order.
Full stop. Next para. Since the appeal is yet to be taken up for admission, comma, it is not appropriate to vacate the interim order granted by this court as the relief sought for in the suit was for declaration of title to an immovable property. Full stop. Allowing the respond number 1 to sink a borewell or construct a compound would alter the status quo. Consequently, IA 1 of 26 shall be considered after the appeal is taken up for admission.
ಇನ್ನೊಂದು they have given undertaking not to alienate the property.
No,
IA
we
2 of
won't alienate,
26 is
madam, by
filed
undertaking
by the
will be
respond number 1 for an interim injunction restraining the appellant from alienating or transferring or encumbering the suitable property pending disposal of this appeal.
Schedule mentioned in the application, property mentioned.
Of the property mentioned in the schedule to the application. Full stop. The appellant, the learned counsel for the appellant submits that the appellant has no intention to encumber or transfer or alienate the property mentioned in the schedule to the application. Full stop. In view of the above, IA 1 of 26 is allowed and the appellants are restrained from alienating, encumbering or transferring the property mentioned in the schedule to the application pending disposal of this appeal.
Date may fix for admission.
List on so and so for admission.
Yeah, second order of litigation.
27th March. 27th March.
DN Manjunath.
16. DN Manjunath.
Office objection.
Defendant's appeal, a suit for partition.
Yeah.
The suit has been decreed. No, this is posted on a council note before this honorable court.
Suit is filed by the daughters.
No, by the sons.
Widow and sons.
That was filed by the widow and her daughters. But now the appel is filed by the sons of the deceased B.K. Krishna Shetty, who are the defendants. Now, the valuation of the properties, my lord, even item number 1 situated in Avenue Road, to the extent of 1/3 share.
Let the final decree proceedings go on.
Please, please.
Let the final decree proceedings go on. We'll consider this application. Workful. Admit call for records. Sorry.
Actually,
The office objection.
my only submission is the pecuniary jurisdiction will exceed this court's jurisdiction.
Yesterday the valuation nearly.
Although even 1/3 share of the appellant's property in Avenue Road, it works out to 21,52,294.
Take a property value kotilva. Trial court ಅಲ್ಲಿ ಏನಂತ
Kottilla
value
ಅವರು.
ಮಾಡಿದ್ರು?
They have not furnished.
Measurements were not.
ಬರ್ಕೊಳ್ಳಿ. The office has raised an
It has to be
objection
placed before the division bench.
that the appellant had not furnished proof, had not furnished the valuation of the suit for the purpose of considering for the purpose of jurisdiction. Full stop. The learned counsel for the appellant has filed a memo indicating that the guidance value of the A schedule item number 3 exceeds the jurisdiction of the learned single judge of this court. Full stop. He therefore submits that the appeal be listed before the division bench. Full stop. The learned counsel for the respondent has no objection for this appeal to be listed before the division bench. In that view of the matter, office objection regarding valuation is overruled. List this appeal before the division bench. Learned counsel for the appellant is directed to furnish a second set of the appeal memorandum. Copy ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ?
Serial number 17, H. Pawan Chandra Shetty.
Lord, office has raised the objection
ಹಾ.
under section 19 of the Karnataka.
ಎಷ್ಟು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ವ್ಯಾಲ್ಯೂಯೇಷನ್?
My lord, it is 16,000 lakhs, my lord. Your lordship may kindly peruse the order sheet of the trial court. Court office. First page, my lord. Just marked in the, my lord's pencil mark.
ಅಲ್ಲ, what is the valuation of the suit property?
That is, my lord, 16 lakhs. I have marked in the, my lord, the pencil side, bottom para.
What is the share of the plaintiff?
That is 1/3 share he has asked. Suit came to be, I am the defendant.
1/3 ಅಂದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
1/3 ಅಂದ್ರೆ 8 lakhs ಚಿಲ್ಲರೆ ಆಗ್ತದೆ.
8 lakhs ಹೆಂಗಾಗುತ್ತೆ?
according to them, my lord, plaintiff.
ಕರೆಕ್ಟ್ ರೀ, ಒಂದ್ ಥರ್ಡ್ ಇಂದ ಇಷ್ಟ ಆಗುತ್ತೆ. 16 ಲಕ್ಷಕ್ಕೆ ಒಂದ್ ಥರ್ಡ್ ಇಷ್ಟ.
1/3 ಅಂದ್ರೆ ಹೇಳಿದ್ರೆ 6 lakhs ಆಗುತ್ತೆ.
ಹ್ಮ್.
But according to plaintiff, my lord, 8,55,000.
5.5 ಲಕ್ಷ ಆಯ್ತು, 5.25 ಲಕ್ಷ.
But your lordship may kindly peruse, my lord, the Karnataka Civil Courts Act 1964, section 19, my lord, subclause 1. May I read, my lord? To the district court, comma, when the amount or value of the subject matter of the original suit of the proceedings does not exceed 10 lakhs rupees. So here, my lord, it is exceeding 10 lakhs
But
rupees.
your share is only 5.5 lakhs.
But total suit value.
Total suit value.
That is what, my lord. That is what, my lord, I have filed, my lord. Otherwise, I will straight away approach the district court, my lord.
Better approach the district court.
Value of the share claimed, my lord, and my lord, not value the entire property. That is what the office has
Correct, you have
considered.
to value your share.
Value, my lord, I am the defendant before.
Correct, plaintiff share has to be valued.
Valued. But here, my lord, as per section 19(1) of the, my lord, Karnataka Civil Courts Act, my lord, the definition is different, my lord.
Defendants counter claim ಏನ ಮಾಡಿದಾರ?
ಇಲ್ಲ. No.
Defendants counter claim ಏನ್ ಮಾಡಿಲ್ಲ. Then
that is what, my lord, I may permitted to read again, my lord, section 19(1), my lord.
Both.
The lordship may kindly peruse, my lord.
Yes, please.
To the district court, comma, when the amount of the value of the subject matter of the original suit or proceedings in bracket does not exceed 10 lakhs rupees.
What is the subject matter of the original suit?
That is 16 lakhs. That is what.
Subject matter of the original suit is your share. Subject matter of
If
the
it
original
is my share is concerned, my lord, 1/3.
Correct.
If it is, my lord, value of the suit is concerned, my lord, then RFA is maintainable. That is what the spirit of the spirit and language of the provision, my lord.
Subject matter
What
of
I
the-
understand.
Subject matter of the original suit ಅಂದ್ರೆ whatever the plaintiff's right is concerned in the suit property. Obviously.
Under your lordship is very much right.
If
Under
you-
the Karnataka Court Fee and Valuation Act ಅಲ್ಲಿ ಆ ತರ ಇದೆ. But under the Karnataka Civil Court Act ಅಲ್ಲಿ it is different, my lord.
Yeah.
That is what, my lord, I have read, my lord, just now.
Correct.
Civil
Mr.
Court Act ಅಲ್ಲಿ total pecuniary jurisdiction value of this suit.
Yes.
Under the, my lord, Karnataka Court Fee and Valuation Suit Valuation Act 1958 ಅಲ್ಲಿ section 35 it says share of the value of the share of the plaintiff.
Yes.
So that, my lord, that is the difference. So that confusion, my lord, I have filed, my lord. Otherwise, I don't have any problem.
Go before ಬರ್ಕೊಳ್ಳಿ.
My lord, may
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅಲ್ವಾ?
ಅಲ್ಲ ಇಲ್ಲಿ ಈ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಹೋದ್ರೆ
There is one judgment of this
there are
court.
number of judgment, no doubt, my lord.
There is one judgment of this court.
Yes, my lord.
Whether the subject matter means the whole or the share of the plaintiff ಅಂತ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ಇದೆ.
ಇದೆ.
ನಾನು by understanding, my lord, plain reading of this act, that is Civil Court Act, my lord, whole has whole.
Yes.
The valuation has whole. So that order sheet is speaking of the learned trial court, my lord, 16 lakhs as per the, my lord, valuation made by the plaintiff. So when it is a 16 lakhs, my lord, RFA definitely maintainable. If it is, my lord, comes under the, my lord, Karnataka Court Fee and Suit Valuation Act 1958, section 35 says, my lord, 1/3 of the valuation of the property.
I'll give you an example. Suppose
Please, ma'am.
you make a statement that the value of this property is, for example, about 50 lakhs. 50 ಲಕ್ಷ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರಲ್ಲ, ಜೂನಿಯರ್ ಡಿವಿಷನ್ ಮುಂದೆ ಬರಲ್ಲ.
Senior division.
ಕರೆಕ್ಟಾ? ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಮುಂದೆ ಹೋಗ್ಬೇಕು. If it is 50 lakhs and above, senior division ಮುಂದೆ ಬರಬೇಕು. If you say that your share is less than 5 lakhs, then you will go before the munsif or the civil judge senior division, junior division.
Correct.
So therefore, when it is convenient for you, go before the munsif. When it is not convenient for you, you go before the civil judge.
May I make an example?
Oh, no.
May I give an
Subject matter of the
illustration,
suit
my
is-
lord? If, my lord, for the civil court is senior division, the jurisdiction is, my lord, above 5 lakhs, there is no end for the zero. There is no, even, my lord, 1 million crore, it is the lies before the civil judge senior division only. Here, my lord, this is only, my lord, with respect to the 2 lakhs difference, so that, my lord, the appeal is lies before the, according to the, my lord, this provision of law under section 19 of the Karnataka Civil Courts Act, it is goes to district court. So that, my lord, my humble submission, my lord, what I understand, my lord, has whole under this act is concerned different, my lord. That is what, my lord.
the office has raised an objection that the appeal is not maintainable before this court in view of section 19 of the Karnataka Civil Codes Act 1964. Full stop. The learned counsel for the appellant submits that under section 19(1) of the Karnataka Civil Codes Act 1961, the value of the entire property should be considered for the purpose of determining the jurisdiction and not the share of the plaintiff alone. Full stop. Next, but a reading of section 19(1) makes it more than apparent that whenever the subject matter of the original suit or proceeding does not exceed, whenever the value of the subject matter of the original suit or proceeding does not exceed 10 lakhs, an appeal lies before the district court. Full stop. The words value of the subject matter of the original suit implies the value of the plaintiff in the suit settled property when it is a suit for partition. When it's a suit for partition. Full stop. When it's a suit for declaration of title or other reliefs, then the value of the subject matter of the suit would be the whole value. Full stop. In view of the fact that the suit was valued at a sum of rupees 16 lakhs, the share of the plaintiff would be less than rupees 10 lakhs, and therefore an appeal before the district court alone would lie and not before this court. Hence, office objection is upheld. The office is directed to return the papers to the appellant for representation before the district court. Full stop. Yes.
My lord, one favor, my lord. Kindly save the limitation, my lord.
Representation mugitalla.
Kindly save the other.
Representation.
I understand. I understand, my lord. This.
The time consumed in pursuing this appeal before this court shall be deducted while calculating the limitation applicable to an appeal before the district court.
Please, oblige.
Serial number 18, Anita B.
ಅದಕ್ಕೂ ಈಗ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ. Once it is presented, time is arrested ಅಂತ ಈ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ.
Oblige.
The appellant, my lord. Suit for partition. The suit is valued at 60 lakhs, my lord. The office has raised objection under section 19(1) of Karnataka.
Suit property is valued at
60 lakhs.
16.
60.
60. What is the plaintiff share?
It's 1/6, my lord.
It's
10 lakhs.
10 lakhs. Then you have to go before the district court. Does not exceed.
It's exactly 10 lakhs, my lord.
It does not exceed ಅಂದ್ರೆ ಏನು?
Yes, your honor.
10 ಲಕ್ಷ 1 ರೂಪಾಯಿ ಇದ್ರೆ ಇಲ್ಲಿ.
But after scrutiny by the district court, your honor, it was directed to file before this honorable court. We had approached the district court earlier. So after scrutiny by this district court, we had appealed here.
Civil Courts Act says it does not exceed.
It's my lord. But it is exactly 10 lakhs here.
10 lakhs and it is 10 lakhs alone. It doesn't exceed 10 lakhs. Does not exceed rupees 10 lakhs. So 10 lakhs ಅಂದ್ರೆ district court. 10 ಲಕ್ಷದ 1 ರೂಪಾಯಿ ಅಂದ್ರೆ ಇಲ್ಲಿ. Office has raised an objection regarding maintainability of the appeal in view of section 19(1) of the Karnataka Civil Codes Act. Full stop. It is stated in the valuation, it is stated in the valuation slip filed before the trial court that the valuation of the suit property was 60 lakhs and the share of the plaintiff was 1/6 in the suit property, and therefore the valuation of the share of the plaintiff was 10 lakhs. Full stop. It is now contended that the appellant had approached the district court.
Yes, ma'am.
And that the district court had directed the appellant to approach this court. ಎಲ್ಲಿದೆ ಅದು?
Tumkur, ma'am.
ಅಲ್ಲ ಇಲ್ಲೆಲ್ಲಿದೆ? Where have you produced that?
That I have.
ಮಾಡಿಲ್ಲ? Full stop. Since the language in section 19(1) is clear and says that if the value of the subject matter of the original suit or other proceeding does not exceed 10 lakhs, then the appeal shall lie before the district court, the appeal has to be filed before the district court and not before this court. Hence, office objection is upheld and the appeal is dismissed as not maintainable. Office is directed to return the papers to the learned counsel for the appellant who shall represent the same before the appropriate court. Full stop. The time consumed in pursuing this appeal shall be directed while calculating limitation applicable to an appeal before the district court. Yes.
Serial number 19, Devi Prasad Shetty.
Devi Prasad Shetty.
Respondent number 3.
Reporting
complaints,
in-
my lord.
What complaints?
ಅದು ಇನ್ನೂ ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡೋದಕ್ಕೆ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ ಸ್ಟಿಲ್ ನಾಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ whenever the party goes not they just say come tomorrow.
In view of this disposal, determine the compensation payable to the petitioners.
Without acquisition, they take.
Respondent number 3.
Survey is not conducted. What is the extent of land is used for the road? A survey has not been conducted. We'll take, I pray for 4.
ನೀವೇ ಹೇಳಿದಲ್ರಿ, ನೀವು ಹೇಳಿದ್ದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡೋದು ನಾವು.
What is the extent we have used ಅಂತ ಅದೊಂದು ಸರ್ವೆ ಆಗ್ಬೇಕಾಗಿದೆ.
ಅದನ್ನ ಯಾವ ಮಾಡ್ತೀರಾ?
I pray for 4.
In fact, ಅವರು KRDL is the authority, ಅವ್ರು ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ರು.
Whatever it is.
ಅವರು GMC ಮಾಡಿ ಇದು ವಾಟ್ ಇಸ್ ದಿ ಪೋರ್ಷನ್ ಅಂತ ಮಾಡಿ ಅವರು ಒಂದು ಫಾರ್ಮಲ್ ಆಗಿ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರು.
No, but when this petition was listed, Learned additional government advocate in response to the order dated so and so submits that KRIDL has formed a road in the land of the petitioners. When queried as to how KRIDL could form a road without acquiring the land, the learned additional government advocate submits the road was formed without acquisition. Learned additional government had directed to obtain instructions from the concerned about the amount of compensation that would be paid to the petitioners as per the.
ಇದರಲ್ಲಿ ಸರ್ವೆಗೆ DC ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ, ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಅದಕ್ಕೊಂದು 4 6 weeks ಕೊಟ್ಟಿರಿ ಸರ್.
ಕೊಟ್ಟಿರಿ.
ಅಲ್ಲ
ಒಂದು ಬೇಕಾಗತ್ತೆ ಸರ್.
ಸರ್ವೆ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ಹೊತ್ತು ಬೇಕು?
ಫಾರ್ಮಲ್ ಆಗಿ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. 2013 ಆಕ್ಟ್.
The Learned Council for the Learned Additional Government Advocate submits that steps are underway for survey and determination of the road of the property of the petitioners that was utilized for forming a road. He therefore prays time to finalize the survey and determine the compensation payable.
2 months ಅಂತ ಮಾಡ್ಬಿಟ್ರೆ
not almost every week not the party is going, not they have not still commenced anything.
ಸರ್ವೆ ಯಾವತ್ತು ಮಾಡ್ತೀರಾ?
ಆರ್ಡರ್ ಮಾಡಿ ಸರ್ವೆ
ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್.
ಯಾವತ್ತು ಮಾಡ್ತೀರಾ ಸರ್ವೆ? Within 1 week, 2 weeks, 3 weeks.
Within 2 weeks ಅಂತ ಮಾಡಿ.
Full stop. In view of the aforesaid submission, the Learned Additional Government Advocate is directed to survey the property and find out and demarcate the area of the land of the petitioners that is utilized for forming the road. And thereafter within 2 weeks, and thereafter take steps for determining the compensation in accordance with the order dated so and so. Order dated 10/12/25. Yes. List on.
After 2 months.
After 2 weeks ಕೊಡಿ.
ಇಲ್ಲ after 2 months.
ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಚೆಕ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಸರ್ವೆ ಮಾಡಿ.
List on so and so.
27th
Ravish.
Serial number for hearing an serial number 20 Ravish MG.
An application for
substitute service.
Why is it returned?
The 2 occasions was returned, and moreover is the party.
Dear friend, why is the notice returned?
It was returned one is not claimed.
ಅದನ್ನ ಹೇಳಿ.
Not claimed.
ಯಾರಿಗೆ not claimed?
The exact particulars was not.
ಮತ್ತೆ ನೋಡ್ದಂಗೆ ನೀವು ಅಯ್ಯ ಹಾಕಿದ್ರಿ ಹೆಂಗೆ?
But my submission is a partition should my lord.
Dear friend, first ಇದು preliminaries ರೀ. ಅದು ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕಲ್ಲ. ಎಲ್ಲ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಇದೆ. ನೀವು ಅವ್ರಿಗೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ? ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಹಾಕೋದು?
When we are purposefully avoiding, that is not so insufficient address is not correct.
ರಿಟರ್ನ್ ಆಗಿರೋದು ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ರಿಟರ್ನ್ ಆಗಿದೆ.
During the trial, after death of their respective ancestor, them come appear before the court, the impleaded under the very same address we have taken the steps, my lord. And one of the family members is already appeared, purposefully avoiding.
R1 Munilakshmi, R3 Manjunath, Meenakshi, 5, 7, 8, 11, 12, 14
and 15.
And 15. ಯಾರ್ಯಾರಿಗೆ ಏನ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ನೋಡ್ರಿ, ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಯಾರ್ಯಾರಿಗೆ. ನೀವು ಸುಮ್ನೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ ಮುಂಚೆ ನೋಡ್ಬೇಕಲ್ವಾ?
R1, R3 and R4 insufficient.
R1,
R3, R4.
R3, R4 insufficient address, huh?
Yes, sir.
R5? ನೋಡಿ ಈ ತರ ಅಡ್ರೆಸ್ ಕೊಟ್ರೆ ಹೆಂಗ್ ಸರ್ವ್ ಆಗುತ್ತೆ ನೀವೇ ಹೇಳಿ.
The what address they have furnished before the trial court is the very same address.
ಎಲ್ಲಿದೆ ಅಡ್ರೆಸ್?
The trial court in judgment. Because they are the impleaded after the death of their respective father's son.
ಆಯ್ತು. ಇದು ಅವರೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ನೀವ್ ಹಾಕಿದ್ದ?
ಅವರೇ ಹಾಕಿದ್ರು ಸ್ವಾಮಿ, ಅವರು ಬಂದ್ರು ಅದೇ ಅಡ್ರೆಸ್ ಬಂದ್ರು ಅದೇನು.
ಆಯ್ತು. R1, R3, R4 ಆಮೇಲೆ ಇನ್ ಬೇರೆ ಹೇಳ್ರಿ. 7, 8 R7 ಯಾರು? R7.
R7 is one of the LRs
Lakshmi.
of different number 2.
ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಿ. ಅವರು ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇರೋದು? ಲಕ್ಷ್ಮಿ ಅದೇ ಅಡ್ರೆಸ್. R8 ಮಾರಕ್ಕ. ಮಾರಕ್ಕ. R11 ಹರಿಸ್ಮಿತಾ. ಹರಿಸ್ಮಿತಾ ಅಂತ ನೋಡ್ರಿ ಇದೇನು? ಹರಿಸ್ಮಿತಾ RMA second stage residing at first main, first A cross. RMA second stage, first block, Ashwath Nagar, Bangalore, 94.
His brother was received.
Wrong for bearing 50.
Other family members were received, but they are purposefully they are avoiding.
14 or 15. Harishmita Mahadesh. Mahadesh. Muni Chikkamma. Muni Chikkamma. ನಾಗರಬಾವಿ ವಿಲೇಜ್ ಅಂತ ಕೊಟ್ರೆ ಹೆಂಗೆ ಸರ್ವ್ ಆಗುತ್ತೆ? ರಿಸೈಡಿಂಗ್ ಎಟ್ ನಾಗರಬಾವಿ ವಿಲೇಜ್ ಅಂದ್ರೆ ಏನು? ಇವರೇನು ಕಾರ್ಪೊರೇಟರ್ ಇವರು?
ಇಲ್ಲ what they are
MLA na?
What address they have given in trial court.
Correct, Mr. You should ascertain the proper address. ನಾಗರಬಾವಿ ವಿಲೇಜ್ ಅಂದ್ರೆ ಎಲ್ಲಿ ಹುಡುಕ್ತಾರೆ ನಾಗರಬಾವಿ ವಿಲೇಜ್?
ಅಂಬೇಡ್ಕರ್ ಕಾಲೋನಿ ಜನತಾ ಜ್ಞಾನ ಭಾರತಿ ಪೋಸ್ಟ್.
Correct. Some have to find out proper address.
Because is another family member was received. They are still they are in.
ಯಾರು ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ? Who has received it?
Then different number 10 and 12. They are the one of the family members and represented by different number 4.
Different number 10 is served. 13 is served.
Served.
10 is Pushpavati, wife of Muni Krishna, daughter of Muni Krishna, Harismita Mahadesh. Okay, that we can accept. Then what else? What about 14 and 15? Ramana Rao, residing at T-9.
They are the purchasers. They are in before the trial court. They have not been contested.
Mr. ಏನ್ ಕೇಳ್ತಿ ಏನ್ ಹೇಳ್ತೀವಿ? R7, R8, R11, R12 ಏನ್ರಿ ಆಯ್ತು? R7 ಹೆಸರು ಲಕ್ಷ್ಮಿ, unclaimed. R8 R.H. Marakka. Marakka.
Yes, sir.
ಅದ್ ನೋಡಿ ಹೇಳ್ರಿ ಅದು. First pass over. Deepak M.
Serial number 21.
I
Deepak M.
appear for the appellants in this case.
Respondent to art operation 1 week time ಕೊಟ್ರಿ ಸರ್ HK bus.
The delay may be
Objections
condoned.
ಹಾಕಿದಿರಲ್ಲಪ್ಪ.
ಹಾಕಿರೋ ಸರ್ 1 week time ಆರ್ಟ್ ಆಪರೇಷನ್ ಆಗಿದೆ ಸರ್.
ಯಾರಿಗೆ?
HK bus.
Long counsel for the respondent seeks time on the
Lords,
ground that the
once
arguing counsel is unwell.
Delay may be condoned, my lords, on medical reasons. we
Sir,
will
he
not-
wants to
Next time
argue.
purchase ಮಾಡ್ತೀವಿ ಸರ್. Next time medical produce ಮಾಡ್ತೀವಿ.
Just on so and so date. What is the suit for?
Recovery.
Money
suit.
recovery.
Money recovery. suit.
Decreed. Suit is decreed.
Yes, my lords.
But this deposit.
At the time of cross examination also, we were on some medical reasonings, we were not able to assist the court itself, my lords, in the lower courts. After that, we were not able to get in contact with the advocate. One of the other medical reasonings were there.
Then we'll consider. ಯಾವತ್ತು ಬೇಕು?
Next week ಅಲ್ಲಿ
List on.
15 ದಿನ ಕೊಡಿ ಸರ್. ಆರ್ಟ್ ಆಪರೇಷನ್ ಆಗಿದೆ ಒಂದು 15.
Don't execute the decree if that is the case.
1 week ಕೊಡಿ.
List on so and so.
27th
In the meanwhile, the respondent is directed not to execute the decree.
Yes, my lords, please.
Sorry.
Till the next date. Yes, next.
27th March. Serial number 22. Manasa MB.
Appear for the
MB Manasa.
for the appellant.
Direction to return the pen drive
Yes, my lord.
dated so and so. Pending before the registrar judicial. What is this IA
We
pen
have
drive?
produced a pen drive in support of, we had produced certain photographs on it. For that, we had produced a pen drive. The respondents had raised an objection saying the certificate produced in support of this pen drive was not proper. So for that reason, we are seeking leave of this honorable court to take back the pen drive and furnish necessary certificate.
You furnish a fresh pen drive. We don't want to give back what is there.
No, Malas, what has happened is they're saying that it has not been given from the source. That was taken on a phone.
Aitappa, you produce another pen drive, you take this back.
It may be ordered like that.
Along with whatever
And be permitted
certificate.
to file new pen drive along with certificate.
What
and
is the
the
section?
IA 126 is filed to return.
What section
the
63
pen
says,
drive.
my lord, is they have to give a certificate of the source. Section 63 of the New Evidence Act. Lord, the certificate, section 63(4)
Yeah,
says.
that's okay, but we are not returning this pen drive. Let him furnish a fresh pen drive
fresh.
along with the
Yes,
fresh
madam.
certificate.
Yes, ma'am. Yes.
Particularly IA 126 is filed by the appellant to return the pen drive that was produced by the appellants so as to furnish a correct electronic certificate. Full stop. Next para. It is stated in the affidavit accompanying the application that the appellants had filed an application under Order 39 Rule 2A of CPC to initiate contempt action, to initiate action against the respondents for disobedience of an order dated 10/12/2024. Full stop. It is stated that this court, in terms of an order dated 26/3/2025, had directed an inquiry into the said application by the registrar of this court. It is stated that some photographs showing the violation of the order of status quo stated that a pen drive containing some photographs showing the violation of the order of status quo was placed before the registrar, and along with that a certificate in section 60 certificate as provided under section 63 of the Bharatiya Sakshya Adhiniyam was furnished. It is stated that furnished ಮಾಡಿಲ್ವಾ certificate?
Furnished, but they are objecting saying that it
However,
was not
since the
proper.
said certificate was objected by the respondents as the same was not in accordance with law, the appellant has filed this application for return of the pen drive. Stop. In view of the fact that the pen drive was already placed before the registrar of this court and the inquiry before the registrar is pending, it is not appropriate for this court to return the pen drive. However, the appellant is permitted to furnish a fresh pen drive along with a fresh certificate as provided under section 63 of the Indian Bharatiya Saksha Adhiniyam. Yes, IA 1 of 26 stands disposed of on the above terms.
Earlier pen drive and the certificate may be taken as not the rest.
We'll consider that. See, tomorrow, if you want to replace these photographs in the pen drive, we don't want that to allow. Whatever is filed in the court is filed. Yes.
Serial number 23, Jagdish KG. Jagdish KG.
KG Jagdish.
For the appellant, my lord.
IA 1 of 25 LRs Barkuli. IA 1 of 25 is filed by the applicants to come on record as the LRs of the deceased appellant. Since the cause of action has survived the death of the appellant, the applicants are entitled to come on record and pursue this appeal. Hence, IA 1 of 25 is allowed and the applicants are permitted to come on record. Counsel for the appellant is directed to amend the cause title. What is vacating interim order? The purpose of the appeal will be defeated, Mr.
Yes.
2000?
My lord, that will be heard with, my senior counsel will come and argue the matter, my lord.
Please amend the cause title.
Yes, ma'am.
List
I will
on
amend
date could admit agilla. List for admission on date could.
Interim order may be extended, my lord.
Interim order granted as extended to the next date.
Serial number 24, V Anand.
It did come for admission first. V Anand.
My lord, it's a defendant's appeal, my lord. Suit for possession, my lord, was decreed, my lord. Granting 3 months' time, my lord. Kindly see the family tree, my lord, at page 3, my lord. Hello, names admitted, though. As I'm pressing for stay, my lord. I'm praying for stay.
Stay ilva?
Yes.
Stay ilva? If you don't execute, no, if you say that you will not execute, if you say that if you don't execute,
please,
then we'll take it up for early hearing without
Please.
granting any stay. Barcode.
Please.
The learned counsel for the appellant undertakes that during the pendency of this appeal, the judgment and decree impugned in this appeal shall not be executed. In view of the aforesaid submission, list this appeal for final hearing on yavathu beku.
Respondent undertaking, my lord. Appellant at the bandi.
Appellant alla, respondent.
Respondent.
Respondent alla mailidu. Respondent.
6 weeks.
Yavathu beku.
On 6 weeks.
Yavathu beku heli, you decide when you want.
6 weeks, my lord.
Decree yavathu. What is the date of the decree?
24.
Suit is for recovery of possession. 2006.
24, my lord. Both appeals are admitted.
99.
Common judgment.
99 isvi nimdu.
Second appeal, 63. That 63 undertaken.
I think then it's not suit based on idalla alla, ejectment suit alla idu.
Position.
Based on title.
Title.
So therefore matter requires to be heard. Correct, sir. It has to be heard. 2025 appeal. How can?
25 appeal andre suit nadidite ಕೆಳಗಡೆ ಕೊಟ್ಟಿದ್ದಾನೆ.
Yes, list on date could. April al kodi yaವಾಗ. Huh? Undertaking.
He filed an application in that state.
1963.
RFA 63 of 25 years ನಾನು ಇನ್ನೊಂದು ಸ್ಟೇ ಅವರೇನು ಕೇಳಿಲ್ಲ ಇದರಲ್ಲಿ ಮಾತ್ರ
69 ಅಲ್ಲ not
ಅಲ್ಲ ಯಾವ್ದೆಲ್ಲ ಸ್ಟೇ ಆದ್ರೆ ಏನಂತ
the common judgment.
ಇದರಲ್ಲಿ ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೆ ಮೊದಲು ಇದರಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೆ.
What about this respect of R2A to D ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ ನೋಟಿಸ್? Why you not taken process in respect of R2A to D?
It's last time it is written, my lord, I will take to.
Please do it today.
Please, my lord.
Otherwise you will
Course of-
vacate the order.
The course of the day will take.
Ivat Madi.
Yeah, today.
In 24.1 ಅಲ್ಲಿ, the learned counsel for the appellant undertakes to take steps in respect of R2A to D and R1B to G during the course of the day. It is made clear that if steps are not taken during the course of the day, the interim order, could you, the undertaking given by the learned counsel for the respondent on ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ಲಿ ಇಲ್ಲ there is no undertaking in the connected matter.
Today I will take steps, my lord.
ರೆಕಾರ್ಡ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಬಟ್ ಆ ಟೈಮಲ್ಲಿ ನೀವೇನು ಕೊಟ್ಟಿಲ್ಲ.
It was an oral submission, my lord.
Failing which the appeal shall stand dismissed as against respondent number 2A to D and R1B to G. Please do it today.
Please, my lord. I will do it.
MB Chandrachuda.
Serial number 25.
Appeal has been admitted, an interim order has been granted after hearing the respondent.
Admit ಆಗಿದೆಯಲ್ಲ.
Admit ಆಗಿದೆ, interim order after hearing the respondent.
Vacated now.
Let's see, there is one more heir. The court has held that their claim, my lord, their suit is dismissed. My suit is decreed. Court holds that they have not identified their extent of land which is
So
granted.
whatever it is, we can't
I
vacate
think
the
they are
order.
using the land.
IA 126 is filed to vacate the interim order granted by this court on
Admitted on 25/11/25. After hearing the respondent or admitted.
Yes, let us see.
25/11/25.
25/11/2025.
My lords, there is one more IA for direction.
Because our objections are not being considered by the honorable court.
Correct, ಬರ್ಕೊಳ್ಳಿ. For vacating the interim order granted on 25/11/2025. Full stop. Next para. The learned senior counsel for the respondent. ಯಾರಿಗೆ?
My lords, respondent number 1 is the plaintiff, my lords, in one suit.
For the respondent number 1.
There are two suits.
ಅಲ್ಲ ಈ IA 126 ಫೈಲ್ ಮಾಡೋದು ಯಾರು?
2 to 4.
2 to 4 filed by the learned senior counsel for the response 2 to 4 submits that.
Lords, these property is in possession.
Ah.
We have filed one more IA for direction that they should at least deposit money because they are utilizing my property. Court has given a categorical finding in their cross-examination itself.
That the trial court has recorded a categorical finding that the
And
appellant,
granted to the panchayat.
the appellant was in unauthorized occupation of the property in question.
No, not in unauthorized occupation.
The interim order granted by this court is militating against the interest of the respondents 2 to 4. And therefore, it is prayed that the order dated so and so be vacated.
No, my submission is,
The learned
there is a
counsel for
grant by the
appellant-
government in
learned
favor of
counsel
the
for the
panchayat.
appellant, however, submits that the decree is for possession of the property in question.
And there is a grant by the
therefore,
deputy
any
commissioner in
order
favor of the
vacating the
panchayat.
order, and therefore vacating the order of interim injunction would result in rendering this appeal infructuous. Full stop. Besides this, he contends that the appeal was admitted by this court after hearing the learned counsel for the respondents, and therefore it is not appropriate for this court to modify the order order dated so and so. Next, I consider submissions of the learned counsel for the appellant as well as the learned senior counsel for the response to court. Next para. This appeal arises out of a judgment and decree of recovery of possession of immovable property which is present, which is purportedly in the possession of the appellant. Full stop. This court, after considering the contentions urged by the parties, had admitted this appeal and had also granted an order staying the operation and execution of the impugned judgment and decree. Full stop. Since the appeal is admitted, comma, it is not appropriate for this court to modify the interim order of stay of the execution of the impugned judgment and decree as regards the B shell property. Hence, IA 1 of 26 is rejected. This is the appeal for admission.
Admit ಆಗಿದೆ.
Sorry, for final hearing. For final hearing.
There is one more IA for.
Oldest matter,
IA 2 of 25.
IA 2 of 25 is for depositing the rent.
Something, otherwise they are enjoying. Please see the operative portion of
ನನಗೆ
this.
ಗವರ್ಮೆಂಟ್ ಇಂದ ಗ್ರಾಂಟ್
Grant
ಆಗಿದೆ.
ಆಗಿದೆ, correct. Please
It
see
is a
the.
grant by the government in my favor.
Lords, I can.
Yeah,
It was
that's
not
all-
challenged.
I don't need to. Please.
It's all matter of.
Lords,
It's a government grant. There is no dispute about it.
There is no dispute, their grant. One
Then-
ನಿಮಿಷ judge. Our judgmentally,
The
please.
pendency of the suit, alienation has been made.
Lords, either I will argue or he will argue. If he finishes, I will argue. Please come to the judgment page, my lords, 35 para 63. We are not disputing there is a grant. Court, please see their own deposition.
Page 35.
Running page 35, internal page 35 of the judgment, para 63, my lords.
Yes.
It starts with overall deposition anta barutte tamge. Their own officials of DW1 and DW4 clearly establishes that defendant number 1, though has got 1 acre 20 guntas of land granted by special deputy commissioner but have encroached the land of plaintiff. Suit schedule property in OS so and so and OS so and so are same. There is no identification dispute as stated by counsel for defendants. The defendant 1, without proceeding to identify 1 acre 20 guntas in Gomar land, but has proceeded and encroached the land of the plaintiff, that is B schedule property. The operative, then it goes on that the operative portion alla ade heltare our claim en reject madilla. If your lordship sees the suit operative portion, ಅವ್ರದ್ದು ಐಡೆಂಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತಾರೆ ಲ್ಯಾಂಡ್ ಅನ್ನ. ಅವ್ರು ಐಡೆಂಟಿಫೈ ಮಾಡ್ದಾನೆ ನನ್ನ ಲ್ಯಾಂಡ್ ಬಂದು ಬಾರ್ ಫೆನ್ಸ್ ಹಾಕಿ ಕೂತಿದ್ದಾರೆ.
Right, then the trial court has not granted you any relief of mean profits or anything like that.
ಅಲ್ಲ ನಮ್ಗೆ ಬಂದಿಲ್ಲ, ಬಟ್ ದಟ್ಸ್ ವೈ ಮೈ ಲಾರ್ಡ್ಸ್ ಇಫ್ your lordship sees
To quantify. ಎಷ್ಟು 1 ರೂಪಾಯ 100 ರೂಪಾಯ 1 ಲಕ್ಷನ 10 ಲಕ್ಷನ
2 lakhs ಅಂತ ನಾವು ಕೇಳ್ತೀವಿ. ಏನಾರ ಒಂದು ಡೆಪಾಸಿಟ್ ದೇ ಆರ್ ಆಲ್ಸೋ ಕೀಪಿಂಗ್ ಇಟ್ ವೇಕೆಂಟ್ ಬಾರ್ ಫೆನ್ಸ್ ಮಾಡಿ ಅವ್ರ ಲ್ಯಾಂಡ್ ಅನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಅಂತ ಕೋರ್ಟೇ ಹೇಳಿದೆ. ಯು ಐಡೆಂಟಿಫೈ ಯುವರ್ ಲ್ಯಾಂಡ್ ಆಫ್ 1 acre 20 guntas ಅಂತ.
No, not appropriate at this stage.
ಒಂದು ನಿಮಿಷ ಏನಪ್ಪ ಹೇಳಿ.
No, it's not correct at this time, at this stage to direct any deposit. Because it's a matter of question of.
ಅವ್ರದ್ದು ಐಡೆಂಟಿಫೈ ಆಗಿಲ್ಲ. At least somebody should identify so that this entire dispute gets resolved.
IA 2 of 25 is filed by the respondents to. Correct ರೀ, ಅದನ್ನ ನಾವು ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕಲ್ರಿ. ತೀರ್ಮಾನ ಮಾಡಕ್ ಮುಂಚೆನೆ ನೀವು. ಏನಿದು ಏನಿದು why unnecessary importance should be given to this matter?
Violating the interim order of the trial court, alienation has been made during the pendency of the
IA
suit.
2 of
Contempt
25 is filed
application
by
is
the
pending.
response 2 to 4. Direction to the appellants to deposit
2 lakhs.
a sum of rupees 2 lakhs per month, per month. For unauthorized occupation, of the B schedule property. Full stop. It is contended that the trial court, after considering the material on record, the oral and documentary evidence, gave a categorical finding that the appellants, though were granted 1 acre 20 guntas in Gomar land, are in occupation of the land belonging to the respondents 2 to 4. It is therefore contended that the appellants are bound to deposit a sum of rupees 2 lakhs, which is the bare minimum rent that the B shell property would fetch if it is leased out. Full stop. The last senior counsel for the response 2 to 4 reiterated the above submissions and submitted that in the face of the finding recorded by the trial court that the appellants are in unauthorized possession of B shell property, comma, the appellants are bound to make good the loss suffered by the respondents 2 to 4 during the pendency of this appeal, and therefore he prays that a sum of rupees 2 lakhs be ordered to be deposited per month, 2 lakhs per month be ordered to be deposited. This is, however, contested by the learned counsel for the appellants, who contend that the question whether the plaintiff is in unauthorized possession of the B schedule property or not, comma, is yet to be decided by this court, and therefore the appellant cannot be penalized to deposit rent of rupees 2 lakhs per month. He submits that since the appeal is admitted, comma, the appeal is admitted, comma, it is not equitable to direct the appellant to deposit the rent of deposit a sum of rupees 2 lakhs per month. Full stop. I consider submission made by the learned counsel for the appellant as well as the learned senior counsel for the response 2 to 4. No doubt the trial court, in terms of its judgment and decree.
If your lordship permits, can I just?
Yes. In terms of its judgment, had recorded a finding, para 63 nal norm, 63 nalli red mark. However, the question whether the appellant is in possession of the property belonging to the plaintiff is to be considered in this appeal. And since considered in this appeal, and therefore, comma, it is not appropriate for this court at this stage to direct the appellant to deposit a sum of rupees 2 lakhs per month towards the purported damages that the respondents 2 to 4 have suffered due to the alleged unlawful occupation of the suit B property by the appellant. Hence, IA 2 of 25 is rejected. List the appeal for final hearing. Yes. Either connected matter in
same.
IA 1 of 25 is filed for dispensation of the production of the decree.
I have produced the certified copy.
Full stop. Since the appellant has produced a certified copy of the judgment and decree in Madidira.
Decree matra. Within 1 week I will file it. Judgment produce ಮಾಡಿದ್ದೀವಿ.
The learned counsel for the appellant undertakes to furnish a copy of the decree within a week.
Please.
In view of the aforesaid submission, IA 1 of 25 is disposed of,
Please.
permitting the appellant to furnish a certified copy of the decree within a week.
Please.
Paper book.
ಹಾಕಿದ್ದೀನಿ.
Learned counsel for the appellant has filed a paper book in serial number 25, Allah. Serial number 25, and therefore non-filing of paper books in serial number 25.1 is condoned. Setting aside abatement R6 ಏನಿದು?
R6 dispensation.
Not pressed.
Not pressed. Dispensation.
IA 1 of 26 to 3 of 26 is not pressed. Hence the same are rejected. List for final hearing. Yes.
26. NS.
ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ, ಯಾವತ್ ಬೇಕು ಹೇಳಿ. When do you want? Any Thursday, Friday, you take whatever date you want. Any Thursday, any Friday, take whatever you date you want ಅಂದ್ರೆ any date ಅಂದ್ರೆ ನಾನೇನು ಹೇಳಿ.
Next week. There is no urgency as such.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ರಾಜಾ, ಹಬ್ಬ ಯಾರು ಮಾಡ್ತಾರೆ? ಹಬ್ಬ ಯಾರು ಮಾಡ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್? ಅಲ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಬ್ಬ ಯಾರು ಮಾಡೋದು ಕೋರ್ಟ್ಗೆ ಬಂದ್ರೆ? ಡೇಟ್ ಕೊಡಿ.
April 2nd week or 3rd week.
ವಿಜಯಂತಿ ಬಾಬು.
Vijayant Babu.
Vijayant Babu, sorry.
NS Vijayant Babu.
My lords, I appear for the appellants. My lords, the appellants had filed a suit seeking specific relief for enforcement of an agreement.
Who is this proposed respondent?
My lords, before the disposal of the suit for specific performance, defendant number 8, he had sold the suit schedule property in favor of this proposed respondent.
Issue notice on IA 2 of 25.
My lords, matter is being listed, first time notice ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ.
Issue notice to issue emergent notice on the appeal to the respondents. Issue notice to the proposed respondent on IA 2 of 25. Yes.
Serial number 27. Harsha Kumar Gowda, HR.
Harsha Kumar Gowda.
I appear for the appellant.
5,332 days
Yes,
in
my
filing
lord.
the appeal.
My lord, the actual delay is around 285 days, my lord.
Actual delay.
Yes, my lord.
Ah.
My lord, the suit was ex parte decree, my lord.
Yavaga? When was the, what is the date of the decree?
My lord, 27/2/2009, my lord.
27?
27/2/2009.
Hmm.
OS number 150 of 2007, my lord.
ಏನ್ ಹಾಕಿದಿರಾ?
Miscellaneous have been filed, my lord. That has been dismissed, my lord, against which MFA has been filed. That is dismissed, against which the SLP has been filed. And that
ಅದು
is also
dismissed.
dismissed, my lord.
ಮತ್ತೆ RF ಹೆಂಗ್ ಹಾಕ್ತೀರಾ?
My lord, that is the jurisdiction is different, my lord. That is the filed seeking to set aside the ex parte, my lord. Here, my lord, challenging the judgment on the merits, my lord.
Hmm.
That is the, my lord, delay is caused for these reasons, my lord.
SLP ಯಾವ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು?
My lord, SLP was dismissed on, my lord, 3/1/2025, my lord.
3/1/25.
25, my lord.
Yes.
And the above appeal has been filed on, my lord, 16th December.
Delay ಮೇಲೆ.
But this delay cannot be condoned for this reason. But the agreement, this is a suit for specific performance. Agreement is of the year 2006. But they failed to, we issued a legal notice. Paper publication was taken. They have taken paper publication that we intend to sell the property. We replied to it. Then we came to know that they are trying to dispose of the property. We filed a suit for specific performance. Defendant number 1 appeared and he has undertaken to file wakalat on behalf of defendant number 2 also. They have not appeared thereafter. No written statement was filed. I have examined, the plaintiff was examined and one more witness who is the signal witness.
ಅವ್ರು ಹೇಳ್ತಿರೋದು ಏನಂದ್ರೆ ex parte
No, correct,
decree.
That is, there are two things, Parad. There is an ex parte decree. I am not disputing that aspect of the matter because they have not appeared and their remedy is only three remedies are available. Suppose it is error apparent in the face of it, they can file a review to the same court or else order 9 rule 13. Otherwise, section 96. Order 9 rule 13 and section 96 simultaneously also they can invoke because order 9 rule 13 is limited scope. And section 96, if it is the trial court has decreed the suit without noticing certain aspect like limitation and jurisdiction, then they simultaneously they can maintain. They have not filed any appeal. Order 9 rule 13 they filed and dismissed, and again evidence was recorded.
Suppose if order 9 rule 13 was allowed, then what would happen?
No, suppose order 9 rule 13 was allowed, suit will be restored. Suit will be restored. Then, my lord, in this case, that is not the case. But secondly, even otherwise, on reading of the plaint and the document produced, if the court decreed the suit without considering certain aspects, then also it can be interfered. But in this case, what they have done is, even otherwise, 360 days delay is there. Even otherwise, 5,500 days delay from the date of this, and the 16 years, not 1 or 2 days. Now, what they have done is, in the meanwhile, they filed a suit for partition. It is as if it is not as if they are not aware about it. They filed a suit for partition to deprive my right, and it was decided on merits. Suit was dismissed. Partition suit was dismissed. All these things have been suppressed and filed this regular first appeal. Therefore, there is no justification for, in this case particularly,
Yes,
to condone the
what
delay.
is justification for the delay of 300 and odd days?
My lord, after dismissal of the SLP, my lord, wrongly advised to file the partition suit, my lord, before the trial court, my lord. Partition suit has been filed, my lord, and the rejection of plaint has been filed, against which the plaint is rejected, my lord.
You say that you
For the wrong advice, my lord, I was suffered there, my lord. Then immediately I filed the appeal here, my lord. And my lord, the one thing is, my lord, The notice has not been served to the defendant number 1, my lord.
Don't argue that.
Yes,
It is, you lost that.
yes.
You lost that. Supreme Court has upheld that. So you cannot argue on
Yes.
non-service of notice. You can only argue on the judgment. How the judgment is not correct, ಅದನ್ನು ಹೇಳಿ. ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು.
Yes, my lord. My lord, the Supreme Court, my lord, in the identical matter, my lord.
Correct, ಇವಾಗ SLP dismiss ಆಗಿದ್ದು 3/1/25.
25, my lord.
You have filed the appeal on 16/12.
16/12, my lord.
So 300 and odd days delay.
Meantime, my lord, it is wrongly advised to file the partition suit,
ಎಲ್ಲಿ
my
ಹೇಳಿದಿರ
lord.
ಹಂಗಂತ affidavit ಅಲ್ಲಿ?
My lord,
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ wrongly advised ಅಂತ?
that has not been stated in my
Not
affidavit.
been stated ಅಂದ್ರೆ?
But that is the fact, my lord. Yes, my lord. Because the time has been spent in.
Stated it, you please state it at least.
Yes, my lord.
File a better
I will file
affidavit.
better affidavit, my lord.
I mean, even that is not their case in this before your lordship.
And original defendant has been expired, the LRs has been filed.
ಆಯ್ತು 349 ಡೇಸ್ಗೂ ಏನ್ ರೀಸನ್ ಅಂತಾನೂ ಹೇಳಿಲ್ಲ ನೀವು.
I will
349 days.
I will file my better affidavit, my lord.
Who has filed the partition suit?
The son and daughter of
Son and
the
daughter of the defendant number 1, my lord.
Son and daughter.
The defendant against other the family members. All of them are staying to, that is only, they are testing. One filed the miscellaneous petition and appeal filed other people. And they approach the Honorable Supreme Court.
A drowning man hanging on to the last straw ಅಂತ ಇದೆಯಲ್ಲ.
Correct, but illadru, suppose if they have stated
Fixing the
before
time, my
your
lord,
lordship regarding the suit for
all opportunity.
specific performance and
Right.
partition.
No opportunity, mister. You lost the opportunity. Supreme Court has confirmed
Lord,
that you deliberately abstained
with
from
respect to the
partition.
set aside of the ex parte, my lord, it has been confirmed, my lord, but on the merits, my lord.
Merits ಮೇಲೆ ಹೇಳಿ ಏನು ಅಂತ?
The
Merits
Supreme
ಮೇಲೆ
Court, my lord, one of the decisions, my lord, in the identical matter, stated that, my lord, if there is a sufficient cause, my lord, the opportunity to be given, my lord. For the delay.
For
the
delay.
delay, yes, my
For
lord.
delay.
Yes, my lord.
But your affidavit is bald.
Yes, my lord, I will file
Affidavit
my.
is bald. 349 ದಿನ ಡಿಲೇಗೆ you are not given a reason.
I'm sorry, I will file my better affidavit by next year.
On counsel for the appellant seeks time to file a better affidavit in support of IA 1025. List after the same is done.
My lord, interim order may be extended.
Interim order ಹೆಂಗ್ ಕೊಡ್ತಾರೆ?
My lord, they have filed the execution
My lord,
petition,
you have-
my lord.
My lord, you have
The court
filed
commission,
my
they
lord,
filed the
last you may
application for
kindly
the court
say
commissioner.
Even before your lordship, they have not stated regarding the party, this specific performance and the partition suit. Absolutely, there is
Don't
nothing.
execute, sir. There's already an interim order. ಹಿಂದೆ ಕೊಟ್ಟಿದೆ ಆಗ್ಲೇ. ಹಿಂದೆ ಕೊಟ್ಬಿಟ್ಟಿದೆ. Interim order granted on 27/2/2026 is extended till the next date of hearing. List on one date ಕೊಡಿ ಯಾವತ್ತು?
2 weeks, my lord.
This is covered
2
with
weeks ಅಲ್ಲ, next week ಅಲ್ಲಿ ಯಾವತ್ತು?
My lord, in the week commencing on the 23rd, my lord.
26th.
Much obliged.
Mallikarjun Basareddy.
Mallikarjun Basareddy.
Defendant number 3 died before the trial court, before passing the judgment.
Issue notice on IA 234 of 26. Why do you file these 3 applications?
Because my lord, abatement, my lord, that is because
Correct,
before the trial.
There's a circular issued by the High Court that you can file only 1 application.
That is absent. But now, my lord, final decree, my lord, that is one of the defendant, if I drop the final decree may be stayed, my lord.
Cool. Main appeal ಮೇಲೆ notice ಹೋಗಿದ್ಯಾ?
Notice ಹೋಗಿಲ್ಲ. Now office raised the objection.
Issue notice on IA, on the main appeal to the respondents. Notice to the proposed, notice to the LRs of the respondent number 3. On IA number 2, 3, 4 of 2026. Until disposal of this appeal, the drawing up of final decree is stayed. However, all further proceedings in final decree shall continue.
Grateful.
Is Y Jayanti Mala.
Serial number 29, Vaijayanti Mala B.
And I'm very for the respondent.
Suit is for injunction.
Suit is for the injunction, Your Honor. In this case, that one,
there is no dispute regarding the ownership of the property, Your Honor. Only regarding the setback. The thing is that there is 3 cases filed between the parties. One is OS number 7895 of 2013, filed by the Gauramma. I will tell that one name, Your Honor, because of the 3 cases are there. Gauramma.
No, what is the error in the judgment?
Setback, Your Honor. Setback is what the judgment is. They are telling is that it is agreed in the OS, earlier OS, that OS number 7895 of 2013. We agreed that we are ready to give the setback of 2.5 feet from the compound. What thing is that when there is a old compound is there, and we have filed a joint memo. That is a judgment. According to the judgment, already we have filed that one in the joint memo. But according to the plaintiff, they were told that it is only 1.5 feet, not the 2.5 feet.
Madam, that you cannot go back. If you are given an undertaking in one suit, you cannot go back. You cannot now say it is 1.5 feet.
That because it is a correction, Your Honor. In the memo, it was corrected.
7857 of 2013 ನಲ್ಲಿ
ಕರೆಕ್ಷನ್ ಮಾಡಿರೋದು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಜಾಯಿಂಟ್ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿರುವಾಗ ಪ್ಲೈಂಟಿಫಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅವನಿಗೆ. ಹಿ ಇಸ್ ನಾಟ್ ಏಬಲ್ ಟು ರೀಡ್ ದ ಮ್ಯಾಟರ್.
How can you say it now?
ಅಲ್ಲಿ ಕಮಿಷನರ್ ಅನ್ನೊಬ್ಬರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಪ್ಲೇಸ್ ನೋಡ್ಬಿಟ್ಟು ಬಂದ್ರು ಪರವಾಗಿಲ್ಲ ಸ್ವಾಮಿ. ಜಸ್ಟ್ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಸೆಟ್ ಬ್ಯಾಕ್ ಇದೆ, ಆಕ್ಚುಲಿ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟಿದ್ದೇವೆ ನಾವು. ಯಾಕೆಂದ್ರೆ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಆಗಿದೆ.
OS ನಂಬರ್ 7857 of 2013 ಅಲ್ಲಿ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ. ಏನಂತ? ನೀವು you will leave 2.5 feet of setback.
ಬಿಡ್ತೇವೆ ಅಂತ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ 2 ಹೇಳುವಂತದನ್ನ ಮತ್ತೆ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Then you have to go before the same court.
1/2 feet ಅಂತ ಅರ್ಲಿಯರ್ ಹೇಳ್ಬಿಟ್ಟು ಮತ್ತೆ 2 feet. ಅದೇ ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ
ನೀವು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಕೋಬೇಕು.
ಸ್ವಲ್ಪ ಮಿಸ್ಗೈಡ್ ಆಯ್ತು ಸ್ವಾಮಿ.
ಮೇಡಮ್, ಸ್ವಲ್ಪ ಮಿಸ್ಗೈಡ್ ಆಯ್ತೋ ಜಾಸ್ತಿ ಮಿಸ್ಗೈಡ್ ಆಯ್ತೋ, ನೀವು ಅದೇ ಸೂಟ್ ಅಲ್ಲಿ ಹೋಗಿ ನಮ್ನ ಮಿಸ್ಗೈಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಆ ಕಾಂಪ್ರಮೈಸ್.
ಅಲ್ಲ, ಒಂದು ಇದ್ರಲ್ಲಿ ಒಂದು ಕಮಿಷನರ್ ಅನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಬರ್ಬೋದು.
Recent Supreme Court judgment is also very same thing. They have to go before them.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಆದ್ರೆ ಒಂದು ಚಾನ್ಸ್ ಕೊಡಿ.
ಬರ್ಕೊಡಿ. ಇನ್ನೊಂದು ಕೊಡಿ.
ಅಲ್ಲಿ ಅದಕ್ಕೆ ಹೋಗಿ ನಮ್ಗೆ ಮಾಡೋದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಡಿ. ಬಿಕಾಸ್ ಇಟ್ಸ್ ಸೂಟ್ ವಾಸ್ 2013 suit, so lot of delay is there, so kindly give a permission.
That is all your problem, madam. You have come to the wrong court.
Kindly give me permission. You should have gone to the
correct court. You should have gone to the court within time.
So kindly give me a permission where I can challenge that one.
ಬರ್ಕೊಳ್ಳಿ. RFA 252 of 2023 is filed by the defendant, case number 859 of 2014 on the file of the 42nd additional city civil and session judge, Bengaluru, challenging the judgment and decree dated 16/4/2022, while RFA 256 of 2023 is filed by the plaintiff in OS number 784 of 2014 on the file of the 42nd additional city civil and sessions judge, Bengaluru, challenging the judgment and decree dated 16/4/2022. Next para. The appellant in this appeal, in these 2 appeals, shall be referred by his name so as to avoid confusion in the narration of facts. Likewise, the respondent in these 2 appeals shall be referred by her name. We'll stop. Next para. Srimati N. Gauramma filed a suit in OS number 859 of 2014 for perpetual injunction to restrain the defendant, to restrain Mr. Ramesh
from interfering.
2013.
Mr. Ramesh from Yenike, from putting up construction was over his property without leaving setback of 2.5 feet as agreed in OS number 7857 of 2013. Full stop. She claimed that she was the owner of the suit property and that the Mr. Ramesh was her neighbor on the eastern side. She claimed that Mr. Ramesh attempted to put up construction on his property without leaving a 3 feet setback as contemplated under the building bylaws framed under the KMC Act and without obtaining a sanction plan and license from the BBMP. She therefore lodged a complaint before the executive engineer BBMP and she claimed that the officials of BBMP failed to take any action against Mr. Ramesh. She therefore filed OS number 7857 of 2013 to restrain Mr. Ramesh from putting up any construction over his property without leaving 3 feet setback. Full stop. In the said suit, Mr. Ramesh appeared and filed a written statement agreeing that he will put up construction over his property by leaving 2.5 feet setback. Accordingly, a joint memo was filed by both the parties and the case was listed before the Lok Adalat where both the parties and their counsel were present and both of them agreed that 2.5 feet shall be left as setback by Mr. Ramesh. Consequently, the suit in OS number
7857.
7857 of 2013 was disposed of. The Srimati Gaurama claimed that despite the undertaking given by Mr. Ramesh, he proceeded to put up construction in violation of the order, in violation of his undertaking. Full stop. Therefore, she was advised to file a suit for perpetual injunction to restrain Mr. Ramesh from putting up construction without leaving the setback area. Full stop. The suit was contested by Mr. Ramesh, who claimed that he was the owner of the property on the western side of the property of Srimati Gaurama. He claimed that an old building existed on the property and that he, after demolishing the existing building, obtained a plan from the BBMP and was constructing on the property, on his property. Full stop. He alleged that Srimati Gaurama, without any right, title or interest, tried to encroach his property from the eastern side. Therefore, he lodged a complaint before the Assistant Executive Engineer BBMP. Contending that Srimati Gaurama had put up construction without leaving setback towards his property. However, no action is taken. However, he claimed that no action was taken by BBMP against the plaintiff. Full stop. He contended that Srimati Gaurama Srimati Gaurama had filed OS number 7853 of 2013 and that his advocate had colluded with Srimati Gaurama and they brought about a joint memo dated 13/11/2013 wherein it was allegedly stated that Mr. Ramesh would leave setback of 2.5 feet on the western side of his property. Full stop. He claimed that he had agreed to leave only half feet as per the sanction plan and permission, and that the plaintiff and the advocate for, and his advocate had inserted the numerical 2 in front of half feet. Full stop. He therefore contended that the suit filed by Srimati Gauramma for perpetual injunction on the premise that a compromise was already entered into in verse number 7857 of 2013 was not maintainable. He also claimed that his advocate had filed an application to recall the order accepting the joint memo in verse number 7857 of 2013, and that the same was registered as miscellaneous petition. ಅದೇನಾಯ್ತು? Miscellaneous petition ಏನಾಯ್ತು?
ಇಲ್ಲ ಅದನ್ನ ಫರ್ದರ್ ಮೂವ್ ಮಾಡಿಲ್ಲ ಇವರು.
Full stop. With these and similar contentions, he claimed that plaintiff is not entitled to any reliefs. Based on these contentions, the trial court framed the following issues. Next para. Mr. Ramesh also filed a suit in voice number 784 of 2014 against Srimati Gauramma for perpetual injunction to restrain Srimati Gauramma from interfering with the ongoing construction in his property. Full stop. Srimati Gauramma contested the suit and reiterated the statements made by her in voice number 859 of 2014. Full stop. The trial court, after considering the contentions, framed the following issues. ಯಾಕೆ ಜಾಯಿಂಟ್ ಟ್ರಯಲ್ ಮಾಡಲಿಲ್ವಾ? Both the suits are not clubbed?
ಕ್ಲಬ್ ಮಾಡಿಲ್ಲ.
Full stop. In the suit filed by Srimati Gauramma in voice number 859, she was examined as PW1 and she marked exhibits P12, P11. Mr. Ramesh did not examine himself, did not adduce any evidence, though exhibit D1 to D3 were marked. Though exhibit D1 and D1 to D3 were confronted by him to PW1 and were marked. Full stop. In the suit filed by Mr. Ramesh, he was examined as PW1 and he marked exhibits P1 to P38. Srimati Gauramma was examined as DW1 and she marked exhibits D1 to D6. Next, based on the oral and documentary evidence, the trial court came to the conclusion that Srimati Gauramma and Mr. Ramesh had earlier entered into settlement in voice number 7857 of 2013, in terms of which, Mr. Ramesh had agreed to leave 2.5 feet setback on the western side of his property, and therefore decreed the suit filed by Srimati Gauramma and directed the defendant and injuncted the defendant from putting up any construction in 2.5 feet on the western side of his property. The trial court dismissed the suit filed by Mr. Ramesh. Being agreed by the same, Mr. Ramesh has filed these 2 appeals. The learned counsel for Mr. Ramesh submitted that Mr. Ramesh was misled into believing, submits that Srimati Gauramma and the advocate for Mr. Ramesh had conspired to bring about a unconscionable settlement in voice number 7857 of 2013. She contends that Mr. Ramesh had agreed to leave setback of only half feet and that Srimati Gauramma and the advocate for Mr. Ramesh were instrumental in adding a numerical 2 in front of half, thereby making it seem as if Mr. Ramesh had agreed to leave 2.5 feet setback on the western side of his property. She therefore contends that the impugned judgment and decree be set aside and impugned judgment and decree be set aside and the suit filed by Srimati Gauramma be dismissed and the suit filed by Mr. Ramesh be decreed. Full stop. Anything else, madam?
ಒಂದು ಚಾನ್ಸ್ ಕಮಿಷನರ್
ಅಲ್ಲ ಏನಂತ ಹೇಳಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ನಿಜವಾಗ್ಲೂ ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಇದೆ
ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಅದಲ್ಲ ಮೇಡಮ್, ನೀವು ಹೇಳಿದ್ದೇನು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಮತ್ತೆ ಅವರು ಶಾಮೀಲಾಗಿ ಅರ್ಧ ಅಡಿ ಅಂತ ಇದನ್ನ 2.5 ಅಡಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಮ ಕೇಸ್.
ಆಕ್ಚುಲಿ ಅಲ್ಲಿ 1.5 feet ಬಿಟ್ಟೇನೆ ಅಂತ ಇವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಆದ್ರೆ ಅದು ಹಾಫ್ ಅಡಿ ಅಂತ ಅಲ್ಲಿ ಬಂದಿದೆ.
Learned counsel for
My
the
memo is very much available. The joint memo is also there.
per contra, the learned counsel for Srimati Gauramma submits
Already it is
that
there.
when the suit in voice number 7853 of 57 of 2013 was referred for mediation, Mr. Ramesh was also present along with his advocate. Statement ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
My lord,
ಆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಪ್ಕೊಂಡಿದಾರಾ?
return statement most probably ಒಪ್ಕೊಂಡಂಗಿಲ್ಲ.
ಒಪ್ಕೊಂಡಿಲ್ಲ. Full stop.
Settlement ಆಗಿಲ್ಲ, before ಲೋಕಾದಲ.
Submits
Memo is very clear.
Submits that in view of the settlement arrived before the Lok Adalat, Mr. Ramesh was not well advised to file a fresh suit for perpetual injunction. On the contrary, he must have gone before the same court in voice number 7857 of 2013. Full stop. He submits that so long as the joint memo in voice number 7857 of 2013 is in force, the suit filed by Mr. Ramesh is not maintainable, while the suit filed by Srimati Gauramma is maintainable, and she is entitled to an order of injunction to restrain Mr. Ramesh from putting up construction in an area measuring 2.5 feet western side of his property. Full stop. I will consider submissions made by the learned counsel for Mr. Ramesh and Srimati Gauramma. I have also perused the impugned judgment and decree passed by the trial court. Records illala?
Yes, sir.
Stop. A perusal of the only question that arises for consideration in this appeal is whether the trial court was justified in decreeing the suit filed by Srimati Gauramma and dismissing the suit filed by Mr. Ramesh. Next para. The suit filed by Srimati Gauramma was for perpetual injunction to restrain Mr. Ramesh from putting up construction on the western side of his property was based on a joint memo filed by both of them in OS number 7857 of 2013, in terms of which, Mr. Ramesh had agreed to set apart 2.5 feet on the western side of his property as a setback area. Full stop. Mr. Ramesh has now contended in the present suit that Mr. Srimati Gauramma and his advocate had conspired to file a false joint memo. Full stop. He has claimed that he had agreed to leave setback of only half feet and that his advocate and Srimati Gauramma have tampered the joint memo to seem as if Mr. Ramesh had agreed to leave 2.5 feet setback. Full stop. When once an earlier dispute filed by Srimati Gauramma was settled, Gauramma against Mr. Ramesh was settled amongst themselves before the mediation, when once Mr. Ramesh had agreed to set apart 2.5 feet on the western side of his property as a setback area, he cannot turn around and claim that the said settlement was unconscionable or fraudulent. Full stop. As a matter of fact, it appears that Mr. Ramesh had filed an application in voice number 7857 of 2013 for recalling the acceptance of the joint memo, and that the trial court had registered it as a miscellaneous petition. However, there is no mention as to what happened to that miscellaneous petition. In that way of the matter, Mr. Ramesh could not have challenged the correctness of the compromise decree entered in voice number 7857 of 2013 in view of order 23 rule 3 of CPC. Full stop. In that way of the matter, this court has no hesitation to hold that the trial court was justified in decreeing the suit filed by Srimati Gauramma and dismissing the suit filed by Mr. Ramesh. Hence, these appeals lack merit and are dismissed.
Serial number 30, Prasanna Kumar, RS.
RS Prasanna Kumar.
Appealing
Week's
for the
time may be
respondent.
granted, my lords.
I oppose any adjournment in this matter, my lords.
My senior is not well,
Let him
my lords.
stay. The FTP proceedings are not going further and they've been only seeking time in this matter, my
The
lords.
stage of the FDP.
My lords, in the summon stage itself,
FDP is still in summon stage.
No, my lords.
how to Swami, our FTP
What is
proceedings.
the hurry, madam? You proceed with your FDP.
My lords, there is a stay in before this honorable court.
Day of decree, drawing up a final decree.
Yeah, but all of them have come on record right now, my lords, the parties.
Who proceed with your FDP? Who has stopped your FDP? Who has stopped your FDP?
My lords, if your lordships may kindly have the interim order.
Please read the interim. Read the interim order. Please read the interim order, madam.
My lords, the drawing up of the decree is in respect.
Not to draw final decree proceedings until further orders.
Correct,
What do you
my
mean by
lords.
that?
My lords,
What do you mean by that?
fair enough, my lords. I just made a mention on that. But my lords, my submission before this honorable court is, this is a fit case that needs to be dismissed. They are just prolonging this matter without any grounds being mentioned at all.
Yes.
There is absolutely no grounds for this appeal, my lords. If your lords may kindly have the decree passed by the honorable trial court.
Yes.
Parties are Christians,
Mr.
my
Argue
lords.
for admission.
A week's time may be granted, my lord. Week's time.
No, 2023, no time will be granted.
One last
Argue
time.
for admission.
Please, my lord.
Pass over. Read the file and argue for admission.
My lords.
Read the file, mister. Read the file, see the previous orders, you will get to know what to argue.
Please.
Pass over.
Serial number 31.
File code review. Yes, read the previous order sheets.
Please.
J. Kumar K.
ಸ್ಟೇಟಲ್ ಮೀಡಿಯೇಷನ್ಗೆ ರೆಫರ್ ಮಾಡಕ್ಕಾಗ ಲಾಸ್ಟ್ ಸ್ಟೇಟಲ್ ಮೀಡಿಯೇಷನ್ಗೆ
ಏನ್ ಮಾಡಿದ್ರಿ?
ನಮ್ ಸೈಡ್ ರೆಡಿ ಇದೀವಿ ಸರ್.
ಅವ್ರು ಬಂದಿಲ್ಲ?
ಅಲ್ಲ ಜಾನ್ವರಿಯಲ್ಲಿ ಮಾತುಕತೆ ಆಗಿತ್ತು ಬಟ್ ಅವರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ ನಮ್ಮ ಪಾರ್ಟಿ ಹೇಳಿದ್ರು.
ಹೇಳ್ರಿ.
ಫೈನಲ್ ಇಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬೋದು ಸರ್. ಫೈನಲ್ ಇಯರಿಂಗ್
ಇವಾಗ್ಲೇ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಡ್ಮಿಷನ್ ಹೇಳ್ಬೇಕಲ್ಲ ಮೊದಲು.
ಸೀನಿಯರ್ ಇಲ್ಲ ಸರ್ ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಟಲ್
ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ. 2023 ಎಲ್ಲಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದೀವಿ, ಎಲ್ಲ ಆಗಿದೆ.
ಶಾರ್ಟ್ ಡೇಟ್
Argue for admission, pass over. Ask your senior to come. Pass over.
Serial number 32 urgent, serial number 33 government advocate.
Notice ಹೋಗಿದ್ಯಾ? Notice ಹೋಗಿದ್ಯಾ? IA 1 of 23.
ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ.
Huh?
Approved.
Any objection? ಬರ್ಕೊಳ್ಳಿ. IA 1 of
There is a delay, my lord. For the delay, I am coming.
IA 1 of 24 is filed for continuation of delay of 2447 days in filing the application to bring the LRs of the deceased respondent and to satisfy the abatement of the appeal as against respondent and to permit the appellant to bring the LRs of the respondent. Full stop. ಏನ್ ರೀಸನ್ ಇಷ್ಟೊಂದು ದಿನ ಡಿಲೇಗೆ?
Lordship may kindly see.
24 years delayed, 24 years, 27 days. for filing an appeal.
Delay for bringing the LRs, ಅದಕ್ಕೇನು objection ಇದೆಯಾ? The learned counsel for the respondents 1A and B has no objection for continuation of the delay. In that view of the matter, IA 1 of 24 is allowed and the LRs of R1 are permitted to be brought on record. Counsel for the learned government advocate is directed to amend the cause title and implead the LRs of the respondent number 1. ಹೇಳಿ IA 1 of 23 ಮೇಲೆ.
ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳ್ತೀನಿ ಸರ್. 2 points.
ಮೆರಿಟ್ ಮೇಲೆ ಫಸ್ಟ್ ಡಿಲೇ ಮೇಲೆ ಹೇಳಿ.
ಡಿಲೇ ಕಂಡೋನೇಷನ್ that is the reason and merit. Because
come on.
The Lordship may kindly see,
Sir,
it is an
first
ex
you
parte
should-
decree. It is an ex parte decree. No notice is served.
How do you say
ಅದು
no?
ಆಫೀಸಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಬಟ್ ಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ನಾಟ್
Records ಇಲ್ಲಿ Where is the order sheet of the trial court? ನೋಡಿದಿರಾ order sheet?
ಇಲ್ಲ ನೋಡ್ಲಿಲ್ಲ ಟುಡೇ
ನೋಡಿ order sheet ನೋಡಿ.
I am having this file today, that's what I am.
Order sheet ನೋಡಿ.
ಅಲ್ಲ another of the ground is there is they filed application under 108C that is rejected. Thereafter suit is filed and ex parte decreed. It is
ಅದು ನೀವು ಇಲ್ಲಿ ಬಂದು ಹೇಳೋದಲ್ಲ, ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ರೆ if you are sitting tight without moving an inch, then you are bound to face the consequences.
It is the same, same day it is
Notice
noticed.
serve ಆಗಿದೆಯಲ್ಲ ಚೆಕ್ ಮಾಡಿ ನೋಡಿ ಹೇಳಿ.
I have not
Pass
seen.
over.
Kindly have this on
No,
next
no,
week, my
no,
lord.
no.
Because
Yes,
today I
ma'am.
am having this file.
LCR ಇದೆ ಸರ್ ತಕೊಂಡು ನೋಡಿ ಸರ್. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ ನೋಡಕ್ ಹೇಳಕ್ಕೆ ಅಂತ.
ಅಲ್ಲ, ಅದನ್ನ ನೋಡಿ.
ಸರ್ವಾಗಿದೆ, it is clearly mentioned in.
ಅವ್ರು ನೋಡ್ತಾರೆ ಬಿಡ್ರಿ. Let him see, he has to argue. Nataraj Baba.
34, Nataraj Baba ke.
MB Chandrachуда.
Last occasion, a suggestion was made.
Huh?
Occasion suggestion was made, suit for specific was not dismissed. I received an amount of 6 lakh. Another 4 lakhs has to be paid ಅಂತ ಹೇಳಿ ತಾವು suggestion ಮಾಡಿದ್ರಿ. My client ಬಂದಿದ್ದಾರೆ ಕೊಡಕ್ ತಯಾರಿದ್ದಾರೆ.
My lords, if I may respectfully submit, we are the new counsels on record, my lords. Only yesterday we have wakalat.
No, it is your problem, mister. You have to argue the matter for admission.
Please, my lords, we'll need the copy, certified copies from the, on this honorable court, my lords.
Do whatever you want. You argue for admission. I'll not adjourn it. Admission
Lords,
argue on matter.
My lords, we have to go through the documents, my lords. We have to obtain them.
Plaint is hereby rejected as barred by law.
Yes, my lords. We have shown our readiness and willingness in the OS. However, they wish to come forward, my lords.
ಹೇಳಿ.
My lords, we have
Please
to.
point out what is the, see, what is the date of the agreement?
Only yesterday we have obtained the wakalat.
What is the date of the agreement?
2010, my lords. Year of.
Hope you know what the meaning of a date.
Yes, yes.
ಏನ್ date ಅಂದ್ರೆ ಏನು?
My lords, we have.
Date is day, month and year.
Yes, my lords.
So when I ask you the date, give me the date, not the year. What is the date?
My lords have to obtain the documents from the client, my lords.
Well, I'll
They've only
discuss
given
it.
the
NOC.
Date, agreement date is 9/12/2010.
Yes,
When did you file the suit? In 2015.
15, my lords.
What is the time fixed under the agreement?
3 months, my lords. 3 months.
When does it expire?
My lords, I'll.
When does it expire, mister? 12 to 3 ಎಷ್ಟು? March ತಾನೆ?
Yes, my lords.
What does Article 54 say?
My lords, we have continuously shown our readiness and willingness in this.
ಕೊಡ್ರಿ
There
ಅದು
has been no response from the.
limitation ಯಾಕೆ ಕೊಡಿ? ಕೊಡಿ ಅವ್ರ limitation ಕೊಡಿ. You should argue for admission first.
My lords, there is no single document for him to show that the property came to him. Even in 2015 to 16, on the date of filing of the suit, there was no property in his name. He kept on delaying it from his end, my lords.
Then why should specific performance be granted then? If there is no title in his name,
My lords, yes.
why should specific performance be granted?
My lords, we paid him the amount, initial amount as agreed upon the sale agreement. Thereafter, he continuously denied. He kept on promising us he'll be executing the.
ಕೊಡಿ Article 54 ಓದ್. Have you read 54?
Please, my lords.
What does it say? Second part of Article 54, what does it say?
My lords.
Please don't nod your head. What does it say? ಹಿಂಗ್ ಅನ್ಬೇಡಪ್ಪ, ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳು. ಕೊಡಿ.
Three years from the date of agreement.
Please read fully, mister.
The date fixed for the performance, or if no such date is fixed, when the plaintiff has noticed the performance is
So
refused.
therefore, if time is fixed,
Yes.
limitation starts from what date?
From the date of.
So within March 2010,
Yes, my lord.
you should have filed the suit within 2013 March.
Yes, my lords.
Have you filed the suit within 2013 March? If you are not, then the suit has to be rejected. There's no cause of action.
My lords, the property itself, my lords, to.
If you want to accept money, you please accept it. Otherwise, we'll dismiss it right away.
No, my lords, I'll seek instructions.
No. Last time ನಾನು ಹೇಳಿದ್ದೆ.
No, my lords.
ನಾನಂಗಿದ್ರೆ ತಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ I'll decide ಅಂತ.
No, my lords, the property itself did not stand in his name.
The worst case for you, if the property does not stand in his name, how can specific performance be granted?
My lords, he kept on promising that he'll be paying the.
Hey Baba, you are Nataraj Baba.
No, he may be determined. They have taken NOC.
No.
Yesterday we have filed our NOC, my lords. We have.
Right, whatever.
2 weeks time may kindly be granted, my lord.
Pass over, you want to argue, please argue. No adjournment.
Serial number 30.
6 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನೀವು 6 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀರಿ 2010 ಅಲ್ಲಿ, we can ask him to pay double, not more than that. Yes.
Grateful, my lord.
ಯಾರು ಇವರೇ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಅವರು?
4 ಲಕ್ಷ ಹೇಳಿದ್ರಿ, 4 lakhs ಹೇಳಿದ್ರಿ ಕೊಡಕ್ಕೆ.
4 ಲಕ್ಷ 2010 ಅಲ್ಲಿ ತಾನೆ. 2010 ಅಲ್ಲಿ 15 years ಆಯ್ತಲ್ಲ, ಇನ್ನೂ ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ನೀವು. 6, 12, 15 ಲಕ್ಷ ಕೊಡ್ಬೇಕು. ಮೇಕ್ ಇಟ್ 15. ಒಂದ್ ಸೈಟ್ ಲೆಕ್ಕನೂ ಇಲ್ಲ ಅದು ಇವತ್ತಿನ ರೇಟ್ ಅಲ್ಲಿ. ಒಂದ್ ಸೈಟ್ ಲೆಕ್ಕನೂ ಇಲ್ಲ. Even if I order for refund, 9% ಅಂತ ಮಾಡಿದ್ರು ಎಷ್ಟಾಗುತ್ತೆ ವ್ಯಾಲ್ಯೂ? 15 9 135. 6 ಅಲ್ಲಿಗೆ ಬಂತಲ್ಲ. 135 6 lakhs is 15 lakhs. 6 18 5 6 30.
ಕೇಳಿ ನೋಡ್ತೀನಿ.
15 ಲಕ್ಷ ಬಂತಲ್ಲಿ. You get instruction from your investor.
Please.
Otherwise you will lose even that 6 lakhs.
Grateful, my lord.
Serial number 35, Ramesh N.
Ramesh.
Suit for injunction. I am already in possession as on the date of.
ನೋಟಿಸ್ ಇನ್ನ ಸರ್ವ್ ಆಗಿಲ್ವಲ್ಲ?
ಆಗಿದೆ, ಕಳ್ಸಿದ್ದೀನಿ, ಸ್ವಲ್ಪ ತಗೊಂಡಿದ್ದೀನಿ.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ವಲ್ಲ ಅಂದೆ.
Notice ಇನ್ನು ಸರ್ವ್ ಆಗಿದೆ.
ಅವ್ರು ಸರ್ವ್ ಆಗಿಲ್ವಲ್ಲ?
Immediately after, on the last occasion.
After service of notice to the respondent.
Simple, ಅವರು claim returns.
ಅವ್ರು ಇಲ್ದಿದ್ರೆ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಪ್ಪ? ಅದರ್ ಸೈಡ್ ಬೇಕಲ್ಲ.
Admission ಗೆ ಅಂತ ನೆಕ್ಸ್ಟ್ ಇದ್ ಮಾಡಿದ್ರು.
36.
Court has issued
My lord,
notice to
appear
him.
for the petitioner, Lord appellant in this case, my lord.
Yes.
Lord, I appear for the respondent.
My lord, appellant in this case.
Yes, please argue for admission.
My lord, this matter, my lord, your lordship on last week, my lord, heard the matter, my lord, the identification of the boundary, my lord, by the commissioner was, my lord, totally different in respect of the second item.
ಏನಿದು? This is FDP na?
Yes, yes, my lord. Well, kindly see the order, my lord, passed by the, my lord, page number 36 for a moment, my lord. The schedule property is, my lord, second schedule property is in dispute.
My lord, my humble submission is, ನಮ್ಮ senior ದೇವನಹಳ್ಳಿ court ಅಲ್ಲಿ ಇದ್ದಾರೆ. Kindly have it on next week.
ದೇವನಹಳ್ಳಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. That is not a reason, mister. That is not a reason.
Or kindly pass over.
ನೀವು ದೇವನಹಳ್ಳಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದೇನೋ ಗೌರವ ಇರುತ್ತೆ. ನೀವು ಹೈಕೋರ್ಟ್ ಬಂದು ದೇವನಹಳ್ಳಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂದ್ರೆ
ಅದು ದಟ್ ಇಸ್ ಅ ಫ್ಯಾಕ್ಟ್.
ಅದಕ್ಕೆ
ಅದೊಂದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇತ್ತು, ಅದರಿಂದ ಹೋಗಿದ್ದಾರೆ.
ಹೇಳೋದನ್ನ ಪ್ಯಾಕೇಜ್ ಮಾಡಿ ಕ್ಲೀನ್ ಆಗಿ ಹೇಳಿ. ಯು ಶುಡ್ ನೋ ಹೌ ಟು ಟೇಕ್ ಅನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಅದಕ್ಕೆ ಹೇಳೋದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳೋದು ಒಂದು ಆರ್ಟ್ ಅಂತ.
ದಿಸ್ ವಾಸ್ ದ ಫ್ಯಾಕ್ಟ್ ಬಿಫೋರ್ ದಟ್.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳೋದು ಒಂದು ಆರ್ಟ್. ಐ saw a video 2 days back. The son calls the father and says that ಈ ಸತಿ ಎಕ್ಸಾಮ್ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಬರ್ದಿದ್ದೀನಿ, ನಮ್ಮ ಟೀಚರ್ ಕರೆದು ಹೇಳಿದ್ದಾರೆ, you should encourage your juniors, so sit along with the juniors and write one more examination ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಮಗ ಅಪ್ಪನಿಗೆ ಹೇಳ್ತಾನಂತೆ. So father gets carried away.
He prepared father.
ಪ್ಯಾಕೇಜ್ ಮಾಡ್ಬೇಕು. ಫೇಲ್ ಆಗಿ ಅಂತ ಹೇಳೋದ್ ಬದಲು ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಪ್ಯಾಕೇಜ್ ಮಾಡಿ ಹೇಳ್ದ ನೋಡಿ, ಹಂಗೆ ನೀವು ಪ್ಯಾಕೇಜ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು ಟು ಟೇಕ್ ಅನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
Yes, ma'am.
Yes.
ಹೇಳಿ. Lord, kindly see, my lord, in respect of page number 36 for a moment, my lord.
In 192/1 is on compact 18 guntas.
Yes.
Compact 18 guntas. How can you divide the property in bits and pieces? Allallallallalla ಇಷ್ಟು ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
That is how they.
Pass over, bring your senior.
Please, ma'am.
Lord, 230, my lord.
I don't know, but it is passed over, obviously it will be 230 only.
Great, my lord.
CC Malaya, serial number 37.
Money suit, my lord.
Yeah? Money suit.
This appellant was
Huh.
chief engineer in the department.
Huh.
The allegation is that while retiring, he has, there is a 5,46,000 rupees worth of, sorry, the amount of, there is no documents were provided. That is the allegation. Therefore,
Now what, 5 lakhs?
5 lakhs,
49,640 rupees.
What was that?
He got transferred one, he opened a parallel account. There's a government account, National Power Training Institute. So there was a government, one account. He got another account open. That amount from the government account is having transferred to his account. There he has withdrawn 2-3 checks with the account opened by him. It was not authorized to be opened and to be spent for any purposes. That has been paragraph number 13 onwards, page number, internal page number 13, page number 29. The complete details are extracted when whatever was admitted by the plaintiff in the cross examination. Kindly, may I read, my lords, page number 29. Sir, it is written as 24, internal page number 13, my lords. In the appeal memorandum.
This
is a case. He was a chief engineer. It is like this, my lord. There are interns. They come for the department. When the intern join for them, there is a specific cost is involved. Suppose it's the 10,000 rupees. Out of the 10,000 rupees, 5,000 rupees will be the departmental cost. That is a fees toward the department. Rest 5,000 rupees is the cost which is involved for their accommodation and other things.
No,
So there is a.
No, is there a corresponding document?
Yes.
that authorizes
Now
you-
the whole case is about, nobody's case is misappropriation. The case of the plaintiff as well as the defendant is that I submitted all the documents with the department. Department did not conducted an audit. Therefore, this amount cannot be taken into account. You are liable to pay. That too, Your Honor, I can say there is a time bar death. The time bar suit itself time bar. They're supposed to have been my retirement days. Lordship may kindly see 2039-2005. The alleged transaction is of 4th August 2014. Sorry, August 2014 till June 2014. There are couple, 2-3 transactions all about.
The fact that 5,49,640
Yes, ma'am.
was transferred to other account is not in dispute.
It is not that. That is not the case, my lord. It is not the case. See, when there is a, it has to be government money and private money as per the department rule. They cannot be mixed together. It has to be kept it separately. As I stated, 5,000 should be in the government. That should be kept in the government. That's rightly done. That is not in dispute.
Let us see your statement. Let us see your written statement.
I straight away take to the evidence itself, my lord.
Let us see your statement.
Statement,
first to understand what was your defense.
Please, my lord. Where is it? This is the one.
Yes, please.
Where is it? It's a page number. Lordship finds it. May I read from paragraph 3 onwards?
Yes, yes, please.
The averment made in para number 3 of the plaint, the defendant was working under the CEA chief engineer prior to April 2002 and in charge of both institutes at Bangalore, entirely false and not correct. It is pertinent to state that the defendant was in charge of PSTI only as a chief engineer of October 2001 to March 2002 under CEA. At the same time, one A. Bhimaya was Balaya was in charge of HLTC as a director till March 2002. The defendant continued to be in charge of PSTI from April 2002 till 9/8/2004 under NPTI, and A. Balaya continued to be in charge of HLTC from April 2002 till 11/2003 and continued director till 3/8/2004. The defendant took the additional charge of HLTC from 11/2003 and 9/8/2004 only. The defendant repatriated to CA and joined as a CA on 12/2/2004 after availing a joint time of 2 days 9th and 11th amendment made in parent that the false and so and so. This is how it's Lordship McKinley. In the year 2002, A. Balaya, director, was in charge of HLTC till 11 to 2003 and repatriated to CA after the relief of HLTC and 8 2004. Since 2000 onward, there were 2 bank accounts, so and so accounts, my lord. This is where the accounts have been maintained. That is one current account in SBI, another one, another account in for the purpose you're also making second to the for the trainees, food, hostel and maintenance and other things. When the defendant took additional charge of HLTC, the defendant got transferred near to his office and account number so and so operated 4 till 2002. The defendant got relieved from the joint CSA. Since Valaya's time, the bills and vouchers expenditure was not subject to audit, and this account is for the food of trainees and housekeeping and recreation facilities, including yoga course of them. As this is government money deposited by the trainees for the boarding, etc., this was maintained separately. As per Rule 13(7) of the receipts of the payment and rules, we are not opposed to mingle the government money and the non-government money. Thus, above practice of having 2 accounts were existed from CA time 16/10/1994 onwards. The amendment made in para number 5 of plaint entirely false and so on so. Now, let's say relevant paragraph. I lead the end of the next paragraph. The next page, my lord. Para number 5. However, we still maintain necessary records, vouchers, and submit them to DD so on so on 9 years back. Even till date, they have under his custody and not operated at all at the PST Bangalore. This is how the case is, my lord. It is their own cases that they have not audited. Since it is not audited, the amount has not been audited. Therefore, they consider it as a misappropriation. The reason also, Lordship McKinley filing this. Here, they should have, if at all it is a misappropriation in their case, they should have filed within 4 years and a department inquiry initiated, then should have been recovered. What is not directly possible, indirectly they're trying to do, because it is time-barred death or recovery procedure. After a lapse of almost 10 years, 13 years, they filed this present suit. So my first contention is this suit itself a time-barred.
Anyway, we'll consider but deposit 50%.
We already deposited, my lord. Already, it is already that is.
Here it is deposit. Granting no, only 50% as
50%. Deposit the remaining 50.
Because Lordship kindly see, why am I want to dispose of the matter, Lordship kindly see, entire my career, I have no difficulty and no such incident happened. I'm 82 years now. I'm fighting for the cancer. So this prime last limb of my life. With this is that allegation of this misappropriation is almost on my shoulder. This is my difficulty, my lord. And it is on the face of it. Their own document says that.
But now there's a right or wrong, there's a finding that you have withdrawn this money.
No, it is not a withdrawal. That is not, let them point out, it is not my point. What they made a submission is completely not on record. Their own document, Lordship may kindly for a moment. P16, Lordship kindly
will consider, admit this for final hearing. Yes. The filing of paper books is dispensed for the time being. Dispense agidiyalla is dispensed.
Balance amount to be deposited. Balance amount to be deposited.
Yes, next.
Serial number 38, Ajit Shetty.
Ajit Shetty.
Kindly pass over, my lords. He's another court. He's on his legs.
Pass over. Mohan Chandra.
39, 14%. Mohan Chandra, please.
Vijaya MN.
My lord, kindly have to next week, my lord.
Please argue the matter.
Kindly have to next Monday.
No, please argue the matter.
Please kindly pass out. Kindly pass out.
Yeah, what is a ejectment suit? Yes, suit is for ejectment.
Yes.
ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಕಮಿಷನರ್ ನ ಕಳಿಸಿ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಕೊಂಡ್ ಬರಕ್ ಹೇಳಿದ್ರಿ
Hmm.
ಅದು ರಿಪೋರ್ಟ್ ಕೂಡ ಹಾಕಿದ್ದಾರೆ ದೇ ಹ್ಯಾವ್ ವೆಕೇಟೆಡ್
ಅಲ್ಲ ಅವ್ರ ಅಪಿಡವಿಟ್ ಹಾಕ್ಲಿ, ನಾನು ವೆಕೇಟ್ ಮಾಡಿದ್ದೆ ಅಂತ ನಾನು ಹಾಕ್ತೇನೆ ಅಪಿಡವಿಟ್. ಅವರು ಹಾಕ್ಲಿ, ಯಾವಾಗ ಹಾಕಿದ್ದು ಅಂತ. ಅಲ್ಲ ಕೈಲಿ ಪಾಸ್
ಲಾಸ್ಟ್ ಟೈಮ್ ಅಫಿಡವಿಟ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದ್ದಾರೆ.
ಏನ್ vacate ಮಾಡಿದ್ದೀನಿ?
Pass over,
ನನ್ಗೆ ಹೆದರ್ಸ್ಬೇಡಿ ಸರ್.
pass over.
Serial number 40. Serial number 40, yes, Kalyan Basuraj.
Elections, election petition virtually, I lost the election petition before the trial court.
RFA ಹೆಂಗ್ ಆಗ್ತೀರಿ election petition?
Oh yes, club election ಇದು. Club election.
Local election.
ಅಲ್ಲಲ್ಲ, it is the.
Club election. Club election.
Club election.
Election petition ಅಂತೀರಾ?
ಅದೇ, virtually it is election petition. I have challenged the election of the respondent, second respondent, who was elected to the post of vice president on two grounds, very, very simple. I will not take.
Term ಆಗಿದೆಯಾ ಇದೆಯಾ?
September ಇದೆ.
ಮತ್ತೆ?
It becomes academic now. But only thing I would like to urge is, he has, projected himself as a medical practitioner, prefixed doctor in front of his name. I am the medical practitioner.
Is this club only meant for doctors?
No.
Then
He has misrepresented the mandate. That is one ground. The other ground is the members other than those who are found in the finance voters list were allowed to franchise their mandate on the date of the election. It is admitted by the general secretary. So these are the only two grounds, my lord.
ಡಾಕ್ಟ್ರು ಅಲ್ವೋ ಹೌದು ಅನ್ನೋದು ಸೊಸೈಟಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತೆ?
ಅಲ್ಲ, ನಾನು ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಅವರು. Some Christian missionary has given him certificate saying that
doctor, let him falsely claim as a doctor.
Yes.
Is that a ground to set aside his election?
That is a feeble ground.
What is the other ground?
The second ground is, as many as more than 100 members were allowed to franchise their mandate on the date of the elections, though their names were not found in the final election.
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ?
There are admissions in the cross examination. The secretary himself has admitted in the cross examination. No, last time when the matter has come up, we have made submissions, both of us have made submissions that we'll argue for final disposal only, having regard to the fact that the tenure of the elections will be ended by September.
Yes, please argue.
Kindly take the cross examination of
Yes.
DW1, please. DW1. Page 8, please.
Page 12.
Page 12, ink page 8. I have on 29/3/2025.
P1 ಇದು DW1 ದಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಸ್ಲಿಪ್ ಬ್ಯಾಕ್ ಯಾಕೆ ಸ್ಲಿಪ್ ಬ್ಯಾಕ್ ಹಾಕೋಣ ಎಸ್
So, much of the cross examination was on the question as to whether he was having the doctorate to prefix his name as doctor. I don't argue much on that aspect of the matter, my lord. It is a feeble ground. The other aspect would be para number 7 of the cross examination. The defendant number 1 is in public domain. It is false to suggest that I have prefixed the doctorate before my name and abused the process of election of defendant number 1 get elected. The details of votes secured by the candidates as mentioned in exhibit P3 is correct. I do not remember the strength of valid voters in the said election. Prior to the election only, the list of valid voters published by the defendant number 2. It is true to suggest that according to exhibit P5, eligible voters list published on 25/7/2024. It is true to suggest that as per the valid voters list, only the members have to franchise their mandate. So this has come, admission is there. Number of members who have franchised the mandate are more than the numbers found in the eligible voters list. Have to check the document and will give answer. So this is the admissions made by DW1. Kindly take the evidence of DW2.
Please, number of members who have exercised their franchise are more than the numbers found in the eligible voters list.
Yes.
Obviously, 100% voting ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಅದೇನಾಗಿದೆ, the number of the members who are not found in the voters list. I agree with your lordship insofar as that aspect of the matter.
This question that you have put gives an impression that there is voting of more than 100%. You heard ನೋಡಿ, number of members who have exercised their franchise are more than the numbers found in the eligible voters list and artha ಏನು?
Over and above the, that is not my case.
Eligible voters list ಇದೆ 105 ಜನ ವೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಅದು ಈಗ ಕೇಳ್ತಿದ್ದೀರಿ.
ಅದೆಲ್ಲ, that is not my case.
That is not the issue.
That is not my case.
ಓದಿ next ಓದಿ. Secretary of our club only produce those documents. I
Yes,
cannot produce.
no, secretary was examined, Lord. Kindly take the evidence of DW2.
DW1 ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. DW2.
Please read paragraph number 9.
I do not know if it is suggested that many members have been allowed to pay subscriptions fee on the date of the election itself, and they were allowed to franchise their mandate. It is false to suggest that since I was in the board of previous tenure of defendant number 1 club, and as such I was in cordial relations with the entire management, and I was part of decision taken by the previous management to allow the many members to pay subscription fee on the date of the election and allowed them to franchise their mandate. Many of the members of defendant number 1 club are my supporters. So he was in the previous management. So he has played his role in allowing the members who have not paid the subscription and paid DW2, please. Exhibit P1, my lord. Kindly go to exhibit P1 first.
P1,
P1, that is the bylaws. Bylaws of the society.
Yes.
Adರಲ್ಲಿ clause number 3, my lord. All members whose names are included in the final voters list are published shall be eligible to propose and second nomination,
Clause number 3 in what?
Clause number 3.
Illiದೆ ಇದು clause number 3.
Exhibit P1 ಅಲ್ಲಿ bylaws ಅಲ್ಲಿ.
I am reading bylaws. Clause
Yes,
number 3 is aims and objects.
ಅಲ್ಲಿ rule 9 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Rule 9 subclass 3 of rule 9.
All members whose name.
Yes, yes. So only those names are found in the final voters list, my lord, are eligible to vote. This is it is not in dispute. This document is not in dispute. Even the calendar of events, my lord, document number 2, exhibit calendar of events also indicates as to the fact that only those exhibit P2, my lord, calendar of events.
28 July. Page
28th, 24th annual general body meeting produced and marked as exhibit P2.
Page number ಏನು?
Page number 10.
Yes.
ಅದರಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ ನೋಟ್ಸ್ ಅಂತಿದೆ. ಕೊನೆಯಲ್ಲಿ ಪೇಜ್ 11 ಅಲ್ಲಿ. Lordship gets it. Notes. Fourth column ಅಲ್ಲಿ members who have failed to pay the dues of the club and deemed defaulters are not entitled to vote, contest, purpose or second a member of in electoral process. So this was my case. So in the cross examination of DW2, my lord, on 11/6/2025, the secretary of the club was examined.
Yes.
He was cross examined. May I please? I have elected as the secretary of defendant number 1 for the present term. It is true to suggest that the election was conducted by a returning officer. Myself and third defendant formed the syndicate and fought the election. So they were in the syndicate. The respondent before this court and this gentleman. It is true to suggest that exhibit P7 is the manifesto of our election campaign. It is false to suggest that at the time of present election, I was not aware about the process of election by the returning officer. I know that final voters list was announced by the returning officer as per exhibit P5. Final voters list, that is also not in dispute. The returning officer has to conduct the election on the basis of the final voters list published by defendant number 1 club. That was my question. Not necessarily it is not necessary. It is the discretion of the returning officer. That's what he answers. I am not aware if it is suggested that is there any resolution by the defendant number one club to permit the voters to franchise their mandate, though their names not found in the final voters list. I did not communicate the returning officer how he allowed the default voters to franchise their mandate in the present election. The witness point is that I communicated with defendant number two orally in this regard. I am not aware if it is suggested that there is no any resolution in the defendant number one club to permit the defaulted voters to franchise their mandate, though their names not found in the final voters list.
Who are they?
Right.
Who are those defaulted voters?
I'll come to that, Miller.
Name appeared in the list.
There are four, Miller. On the date of election, the bar and restaurant was not opened. Only transaction on that day is the election of defendant number one club. It is true to suggest that according to exhibit D7, the opening balance is serial number 208 and closing balance is 292. So they have collected subscription fee on that day and they issued receipts.
Yes.
208 to 292. It is true to suggest that serial number 208, 292 referable to payment of subscriptions by the defaulted members. So these members whose names were not found in the final voters list, on the date of the election, subscription was collected.
The payment of subscription was okay. You vote
It is true to suggest that in exhibit D7 series, there is a reference about opening and closing balance referable for payment of subscriptions by the defaulted members. It is false to suggest that conveniently I failed to produce the entire subscription receipt pertaining to the payment of so and so. It is false to suggest purposefully I have not produced the said documents only to help the defendant number two who fought the election along with me. I can produce the balance sheet of defendant number one club depicting the transactions which took place on the date of the election. It is false to suggest that several members were allowed to franchise their mandate on the date of the election, and in this regard, I am making false statement. At the time of franchise, the mandate by the members, the returning officer will take their signatures against their names and sheet maintained by the returning officer. I have to check the said records available in our club. We will produce the same before the court. No decision has been taken by the elected party to destroy the documents related to the election. Actually, he comes before the court and produces several documents to say that some of the members in the examination chief, he says, some of the members were
who are the voters whose name appeared in the defaulters list and who have exercised their franchise?
92 members, 84 members, their names were not found. They have collected the subscription on that date.
What is there to show that they have cast their votes? What is there to show?
It was my case before the trial court that these members' subscriptions were collected on that day and they were permitted to vote.
Have you put a question to DW2
ma'am,
saying that these 82 members who paid the subscription amount, they were permitted to vote on that day?
Number 12 I am not aware if it is suggested that is there any resolution by the defendant number one club to permit the voters to franchise their mandate, though their names not found in the final voter sheet. I did not communicate with the returning officer how he allowed the defaulted voters to franchise their mandate in the present election.
ಇವ್ರು ಮಾಡಿದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ? ಈ 82 ಜನ votes ಹಾಕಿದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ?
Really, the finding of the trial court, my lord, what the trial court says is, I have not objected to it.
No. ನಿಮ್ಮ evidence ಅಲ್ಲಿ have you said that ಇಂತಿಂತವ್ರು defaulted members they are not eligible to vote, yet they are permitted to vote ಅಂತ ಹೇಳಿದಿರಾ? Plaint ಅಲ್ಲಾಗ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ರೀಡಿಂಗ್ ಅಲ್ಲೂ ಇಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಇಲ್ಲ, ಅಂಡ್ ರೀಡಿಂಗ್ ಅಲ್ಲೂ ಇಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ. ಆಮೇಲೆ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗಿವನ್ ಎ ಫೈಂಡಿಂಗ್ ಓನ್ಲಿ 14 members have exercised that vote, whereas there is the court has given a finding in paragraph 20.
Court ಹೇಳುತ್ತೆ 14 members, only 14 members were allowed ಅಂತ.
Even one member if he has voted, that is wrong.
But the court says no, its margin is different. Margin is tilts the contesting candidate as well as the defeating candidate as well as the candidate was won is more than there is the vote that has been disputed. Then they correct. There is no reason.
On what basis did the trial court come to the conclusion?
The evidence.
14 members, though were defaulters, they have exercised the vote on the ಯಾವ basis?
Evidence on the basis of evidence.
ಯಾವ evidence?
DW2 has produced those documents.
Mr. You argue, I have not asked you.
DW2 the evidence nalli ತಗೊಂಡ್ಬಿಟ್ಟು 14
ಎಲ್ಲಿ
members.
ಹೇಳಿದ್ದಾರೆ DW2 ನಲ್ಲಿ 14 ಜನ ಪರ್ಮಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅದು I mean calculating that this thing, this list, the list that was produced, ಅದ್ರ ಮೇಲೆ ಕೌಂಟ್ ಮಾಡ್ಕೊಂಡು court has come to the conclusion.
ಹೆಂಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಸರ್.
14 members ಇಲ್ಲ.
How did the trial court come to the conclusion that 14 voters whose name did not appear in the final list of voters cast their votes? ಯಾವ basis ಮೇಲೆ trial court comes to the conclusion?
That I explained.
No, we will not adjourn this. Last time ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ.
ಓದಿ.
ಇದೆ paragraph 20 your last look and it's in the judgment. Note it.
It is listed today with the understanding that it will be taken up for final disposal.
Understanding only.
ಓದಿ ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ? Come to para 28.
20 ಅಲ್ಲಿ ಇದು ಒಂದು because other point my learned friend is not pressing, it's only with regard to the defaulters vote. Even though the plaintiff very much
ಓದ್ತಾ ಇದ್ದೀರಾ page?
para 20 of the judgment my lord.
Para 20.
ಹೌದು ಅದು page number ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಸರ್. Even though the plaintiff very much contended that because of the defendants number 2 has allowed some of the non-eligible members to franchise their mandate, he lost the election. However, he is not sure that how many of them have franchised in the said election. That apart, there is no recitals in the exhibit P1 that the members who have paid subscription on the date of election are not allowed to franchise their mandate. According to DW2, only 14 members have franchised their mandate by paying late subscription.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇದು? ಚೀಫ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Chief ಅಲ್ಲಿ ಇದೆ. And he has produced document exhibit D6 my lord. Exhibit D6 and D7 are very crucial.
Ali.
He says on that day subscriptions were collected only from 14 members. They have been allowed to franchise their mandate. But that is incorrect. On that day, as that is the reason I asked him question: was there any transaction on that day apart from the election, except collecting subscription fee and franchising mandate? There was no other transactions. He has admits in the class examination. Only 208 in the 292 ವರೆಗೂ ಆಗಿದೆ, bills ಹಾಕಿದ್ದಾರೆ. Deliberately they did not produce. Only 3 receipts were produced. Kindly see exhibit D7, please. D6 first.
ಸ್ಲಿಪ್ ಹಾಕ್ರಿ ತಿರ್ಗಾ ಹಂಗೆ ಬಿಡ್ತೀರಪ್ಪ. DW ಕೊಡ್ರಿ ಸ್ಲಿಪ್ ಹಾಕ್ರಿ.
Exhibit D6, my lord.
Hello, ನಿಮಿಷ ತಗೊಳ್ಳಿ. Where does DW2 say this 14 votes were permitted?
Chief ಅಲ್ಲಿ.
ಇಲ್ಲಿ ಓದಿ.
Chief examination. Para 5 minute. I state that defendant number 1 club is not restricted to any of the class of people's professions to become so and so. That is not. I state that by law the defendant number 1 do not provide for any prohibitions or restrictions to the defaulted members to regularize the default stated by remitting the subscription fee due to them by to the club before the election exercise their voting rights. This is incorrect.
ಸರಿ ಎಲ್ಲಿ ಸರ್ 14 votes?
14 vote ಅಲ್ಲ. If I am able to establish that exhibit D7 madam. D6 and 7.
Court says according to DW2 only 14 members have franchised their mandate by paying late subscription on the date of election.
ಹೌದು, that is exhibit D6 according to them. It is their own document.
DW2 ನಲ್ಲಿ ಹೇಳಿಲ್ಲ. DW2 ಹೇಳಿಲ್ಲ.
DW through ಮಾತ್ರ ಆಗಿರೋದು D6.
D6 ಅಲ್ಲ.
ಹೌದು.
D6 ಅಲ್ಲಿ
D6 ಅಲ್ಲಿ ಅಶೋಕ್ ಕುಮಾರ್ ಅಂತ ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಅದೇ ತರ 1 to 14 ಮೆಂಬರ್ಸ್ ಮಾತ್ರ
ವೋಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ ಸರ್? ಇವ್ರು ವೋಟ್ ಆಯ್ತು ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಕಲೆಕ್ಟ್
admits that
ವೋಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಎಲ್ಲಿ?
kindly see the examination chief itself. As I took the lordship to the examination chief at para number 6, that though the subscriptions were not paid preceding the finalization of the voters list, on the date we may permit them ಅಂತ ಹೇಳಿ ಅವರೇ ಹೇಳ್ತಾರೆ. ಸೆಕ್ರೆಟರಿ ಹೇಳಿದ್ರು
ಓದಿ.
para number 6 my lord of the examination chief. Para 6. I state that bylaw of defendant number 1 do not provide for any prohibitions or restrictions to the defaulted members to regularize the default status by remitting the subscription fee due by them to the club before the election and exercise their voting rights. This is contrary to exhibit P1.
ಎಲ್ಲಿ ವೋಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿ ಸರ್. ಆಯ್ತು, ಎಲ್ಲಿ ವೋಟ್ ಮಾಡಿದ್ದಾರೆ?
They rely upon exhibit D6.
14 ಜನ they paid the subscription, no dispute. ಅವ್ರು 14 ಜನ ವೋಟ್ ಎಲ್ಲಿ ಮಾಡಿದಾರೆ ಎಲೆಕ್ಷನ್ಗೆ?
ಹೌದು.
ಎಲ್ಲಿದೆ?
The secretary himself admits.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ? Have you put a question that ಈ 14 ಜನದ ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಿ, ಡಿಫಾಲ್ಟೆಡ್ ಅವರು, ಅವ್ರನ್ನು ವೋಟ್ ಮಾಡಕ್ಕೆ
ಸಜೆಷನ್ ಮಾಡಿದ್ದೀರಿ PW1 ಗೆ?
ಇಲ್ಲಿ ಓದಿ. DW1 ಗ
ಅಲ್ಲ, ಇವರಿಗೆ DW1 ಗೆ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿ ತೋರ್ಸು, ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
I am not aware if it is suggested that is there any resolution by the defendant member of club to permit the voters to franchise their mandate though their names not found in the voters list. Para number 2 ಅಲ್ಲಿ ಅಷ್ಟೇ.
ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ.
So exhibit D6 and D7 my lord. Exhibit D6 is said only from 14 members who have collected the subscriptions.
Correct.
But exhibit D7 is contrary to that.
Exhibit
D7.
D7.
The opening balance 208 and the opening balance 208. Closing balance 292.
ಸರ್ ಇರ್ಲಿ ಸರ್, 72 ಜನ ತಗೊಂಡಿದ್ದಾರೆ. ಈ 72 ಜನನೋ ಅಥವಾ 14 ಜನನೋ ವೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನಿದೆ?
ಸಜೆಸ್ಟ್ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಏನಿದೆ? There is nothing to show that these 14 people have cast their votes.
14 the learned judge records a finding that 14 members have voted.
ಎಲ್ಲಿ?
That will not tilt the balance ಅಂತ ಅವರು ಹೇಳೋದು.
How does the learned trial judge come to the conclusion that 14 people have voted?
That is his finding.
How is what I am asking you?
On the basis of exhibit D6 ಅಷ್ಟೇ.
ಹೆಂಗಾಗುತ್ತೆ? D6 ಅಲ್ಲಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ, ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವರೇ ವೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ?
And I have posed a question that they have maintained all the electoral ballots.
He should have summoned it.
No, he has made a statement before the court. I will produce it. He did not produce it. Adverse inference has to be drawn.
You should have summoned it. He said ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ನಮ್ಮ ಹತ್ರ ಇದೆ ಅಂತ ಅಂದ್ರು. You should have summoned it.
I should have.
ಮಾಡಿಲ್ಲ ಅಷ್ಟೇನಾ?
My only request would be, in so far as prefacing the doctor before the that finding of the trial court, your lordship kindly set aside and
no, that not in this proceeding. ನೀವು ಆಯ್ತು ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ಗೆ ಹಾಕೊಳ್ಳಿ, do whatever you want. Nobody can use the word doctor unless they are registered as doctors. File a complaint before the Karnataka Medical Council, do whatever you want.
But ಇವರು ಹೇಳ್ತಾರೆ there is no restriction ಅಂತ.
Appeal is dismissed. Yes, next.
Number 41, PD Surana.
What is in
Service of notice ಇನ್ನು complete ಆಗಿಲ್ಲ. Last
After service of notice to the respondent. ಯಾರಿಗೆ service
connected
ಆಗಿದೆ?
matter ಅಲ್ಲಿ only one respondent is the caveat, others ಇನ್ನು service ಆಗಲಿಲ್ಲ.
Issue, ಬೇರೆ notice issue ಮಾಡಿಲ್ವಾ?
Notice
Connected
order
appeal.
ಮಾಡಿದ್ದಾರೆ but service ಆಗಲಿಲ್ಲ.
List after service of notice to the respondents. MC Basuraj.
42, Basuraju MC.
Suit for partition. Suit
ಏನಾಗಿದೆ?
was dismissed on the
Suit is
ground.
dismissed.
ಹೌದು.
Admit call for records.
Really, let them maintain status quo, my lord. There are 9 items of.
Notice of ಬರ್ಲಿ ಆಮೇಲೆ move ಮಾಡಿ for interim stay. Let notice go and come back.
Please.
Yes. IA 2 of 25 shall be considered after service of notice.
Please.
Serial number 43, R.A. Devanand. 43.
R.A. Devanand. ಕೊಡ್ರಿ.
The appeal had come up for first time for admission.
Yes.
I made a submission that it's a groundless appeal. It has been recorded. All that I want is, there is a decree for eviction against me in respect of a residential portion of the property. I just want 6 months' time to vacate and go. One nimsha, please. To which, my lord, the other side said there is an arrears of 6 lakhs rupees.
No, 16
towards-
lakhs. 16 lakhs.
16
Let
lakh
him complete,
rupees.
mister.
Please.
Let him complete.
16 lakh rupees being the arrears of rent, which is to be payable. And the trial court has found out 1 lakh and odd at the time of drawing the judgment and preparing the judgment, and which I have deposited it. And 2 lakhs is already there with him as a security deposit. And 16 lakhs, he counted it. And he made a sort of a very long memo alleging 16 lakh rupees
Have
being
you- The trial court has only directed the defendant to pay 1,10,000.
Yes, Mullahs, page 13 of the order.
Page?
13, Mullahs.
1,3.
1,3 of the decree, Mullahs.
Bodi.
Yes, Mullahs. The contents of para 13 of the, if I may read, Mullahs. Defendant is liable to pay an enhanced rent. So the contents of para 13 of the plaint in 1406 of 21, which was a suit for injunction, which was lapsed, Mullahs, which came to be abated.
Please
which was
read.
not- Yes,
Either you argue or you read.
Yes, Mullahs.
Don't do two things at a time.
Please. Hence, the defendant is liable to pay enhanced rent at the rate of 5% after every 11 months as per prayer C. From 1/10/2012, defendant is liable to pay damages in form of mean profits for unlawful occupation of the suit scheduled premises. It is common practice in renting out residential properties. Rent will increase at 5% every year. DW1 in his cross-examination has stated that on today he is in occupation of the suit scheduled property and is paying monthly rent of 30,000. Hence, the defendant is liable to pay arrears of rent in form of mean profits for his unlawful occupation of suit scheduled premises at the rate of 42,000 per month from 12/9/2019, and subsequently 5% increase every year. As per prayer D, plaintiff prayed that a grant of appropriate relief under these circumstances, as admitted by the defendant, he is only paying 30,000 rent per month. Hence, he is liable to pay arrears at 5% increase of every year to the agreed rent. Under these circumstances, the defendant is liable to pay interest on the said amount of the arrears. Looking at facts and circumstances of this case, hence I think it proper to direct the defendant to pay the said amount of rent with interest at 9%. This Malats I've used to arrive at that figure, Malats. And
But the decree is only for 1,10,000.
No, Malats. I've also been awarded, Malats, interest.
That is fair enough, but decrease for only 1,10,000, not for 16 lakhs. So if you want to file, you file an appeal. You file an appeal.
That's also the para number 15, Malats. Defendant is liable to pay mean profits.
File is petition for determining mean profits.
From 1/10/21, Malats.
So somebody will have to calculate this mean profits.
Yes, Malats.
File an application before the same court for determining mean profits. But as of now, 1,10,000 he is deposited. He wants 6 more months' time.
No, Malaj, since the appeal was filed, Malaj, the decree was on 1/12/2025. Thereon, he stayed in the same premises. Then he sought 5 months, Malaj. Then he sought mediation before the previous bench. He's been
More
staying
months.
there.
3 more months.
Please, Millard.
3 more months.
He's already, Malaj, dragged it.
It was not audible to me.
ಮೂರು ತಿಂಗಳು.
ಸ್ವಲ್ಪ ಯಾಕಂದ್ರೆ can I seek little concession at the hands of this court? Instead of 3 months, can it be made it up to 4 months?
No, Malaj, at what rate?
Pay the, what do you call the rent?
Rents are being paid.
No,
In
he's
fact,
only as per
Pay the rent as determined by the trial court at rupees 42,000 per month.
No, Malaj.
that has been accounted to 1,10,000 and odd.
Sir.
There is a decree.
For the 4 months
Very well.
you want to
Very well,
stay,
very well.
for the 4 months you want to stay
No.
extra, from today onwards,
I understand
pay
it.
42,000 per
No, no,
month.
I understand it. And the respondent is the owner.
Hmm.
He is not the one who injected me into the possession of the property as a tenant in the year
But then you
2021.
can argue the matter. Either you take time and get out, or you argue the matter on merits.
No, no. What I am trying to submit for my lord's consideration is there is no contract between myself and
When
the,
you argue the matter, well, decide the matter.
Malaj,
very well, next week.
Sorry.
Malaj, next week, Malaj, I can't say.
Next
Malaj.
week.
Next week, Malaj.
Because he has accounted hike in rent of every 5%. There is no contract between myself and the owner of the property.
Malaj may hear me next week.
Then counsel for the apparent seeks time list on so and so.
ದೇವಾನಂದ ಸರ್
Sir, serial number.
46 ಸರ್ ಇಲ್ಲ ಸರ್ ಇದೆ
ಇಲ್ಲ ತಾನೆ
ಇದೆ ಇದೆ
48 ಸರ್
48 ಇದೆ
Sir, 38 ಏನು? 38 ಏನು? ಇದು ಬೇರೆ. Password.
59 ಸರ್ 59
ಸರ್ 50 ಅರ್ಜನ್ ಆಗಿಲ್ವಾ?
50 ಅರ್ಜನ್ ಆಗಿಲ್ಲ ಸರ್ ಇದೆ
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಇದೆ ಸರ್ 49 ಇದೆ ಸರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್
Sir. Sir, am I audible?
Milord's kind permission.
Ah,
Serial number 49, Milord's mediation report is awaited. May I request for a week's accommodation in that, Milord's. I have informed the other side also.
Joint counsel for the appellant seeks time. Distance also.
27th March.
Much.
Correct. Huh? Then I don't know. Correct.
Serial number 45, Guraja.
Or Gurra.
Please, Your Honor. Our defendants feel suit for partition and separate possession has been decreed. Not plaintiffs filed a suit for partition and separate possession, contending that, my lord, they are entitled for half share. Initially, the suit was filed in Bangalore, and, my lord, thereafter, my lord, during the COVID time, it was transferred to, my lord, Nelamangala court. The defendant died.
How are these two persons related?
Related. Our husband
and Padma KG, how are they related?
Our friends, husbands, ibru friends.
So it was purchased in their names.
Legal transfer aito. We could not lead the evidence.
No, what is wrong with the judgment?
We had no opportunity to.
Correct. What is wrong in the judgment?
There was a partition. He creates a partition deed of 1999. Naveen. So, my lord, it was only nominal sale deed. My lord, entire consideration amount was paid by.
What is the law? Section 45, TP Act. What does it say? Please point out, what does TP Act say? Joint purchase is ಏನಾಗುತ್ತೆ? ಕೊಡಿ ಸಾಹೇಬ್ರು ಕೊಡಿ.
Sorry,
45 or 48 are 45. 45 ತೊಗೊಳ್ಳಿ.
Fiduciary relationship.
ಎಲ್ಲ fiduciary ಕೊಡಿ. There should be an agreement to the contrary. Otherwise, the law is both of them have contributed half each.
But now we wanted to put him certain questions, my lord, in the cross examination, my lord. If amount was paid by, my lord, husband of defendant.
Please read it. Please read it.
I can't.
So therefore, 45 against you can't argue.
But, my lord, if I get certain admissions,
assuming that money is paid by your husband, unless there's an agreement to the contrary,
and
the law is
other documents we wanted to produce.
ಏನು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು?
ಒಂದು opportunity.
2009 suit, sir.
ಅಲ್ಲ, ಒಂದು ಡೇಟ್ ಅಲ್ಲಿ ಈಗ you lords may
2009 suit we can't grant any indulgence. 2009 suit 16 ವರ್ಷ ಆಗೋಗಿದೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು. ನಮ್ಮ mother died, my lord, during COVID. As a result of that, my lord, we could not, written statement was filed by.
Please point out from the written statement, what is the substantial defense that you have raised? Please point out from the written statement.
ಮತ್ತೊಂದು ಇನ್ನೊಂದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೂ ನಾವು ರೆಡಿ ಇದೆ. ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೂ ನಾವು ರೆಡಿ ಇದ್ದೇವೆ.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ಹೇಳಿ.
Same thing we have.
Please read the paragraph, one of the written statement, page 22.
Please. Yara?
Page 8 of the judgment.
The defendants contended that defendant is the wife of one LR Munigangappa, and said Munigangappa and B. Arshna, husband of, jointly purchased 4 acres converted land in survey number situated to the east of the suit schedule under registered sale deed dated 24/11/1995. In pursuant to the said registered sale deed, said the Munigangappa and Shivanna became joint owners of the said land to the east of the said suit schedule property, both of them having half share each in the said property.
So ನೀವು ಒಪ್ಕೋತೀರಾ?
ಅಂದ್ರೆ ಅಷ್ಟರ
ಇವ್ರಿಗೂ ಅರ್ಧ ಇತ್ತು ಅಂತ ನೀವೇ ಒಪ್ಕೋತೀರಾ?
But my lord, consideration amount was paid.
Then you should have said, ನನ್ ಗಂಡ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲ ನನ್ ಗಂಡಂಗೆ ಬರ್ಬೇಕು.
Original written statement was filed by defendant. She died. LRC ಗೆ paper publication ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes. No, but your
I prefer one opportunity, my lord. ಅಲ್ಲ ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ನೋಟಿಸ್ ಮಾಡಿ ಅವ್ರು ಬರ್ಲಿ.
ಸಾರಿ
ನೋಡಿ
ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ?
ಅಲ್ಲಲ್ಲ ಅಟ್ ದಿಸ್ ಸ್ಟೇಜ್ ಮೈ ಲಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರ ಮುಂದೆ ನಾವು ಯುವರ್ ಲಾರ್ಡ್ಸ್ ಮೇ ಇಲ್ಲೇ ನಾವು ಏನಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಹಿಯರ್ ಇಟ್ ಸೆಲ್ಫ್ ಮೈ ಲಾರ್ಡ್ ವಿ ವಿಲ್
ಶೋ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್
ಪ್ಲೀಸ್.
List number 1, passed over matter, serial number 30.
I'm applying for respondent number 1 in the matter 1.
Serial number?
Sorry, sir. Serial number 20.
13, huh?
Serial number 20, sir.
The morning I prayed a week's time.
20, serial number 20.
Addo.
20, huh?
Ravisha MD.
One is on 31/1/2024. All the postal articles was returned.
What about respond number 15? No such address ಅಂತ ಇದೆಯಲ್ಲ?
No such address ಅಂತ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಬೇಕಾದ್ರೆ I will once again. But he is
Ramana Rao.
Subsequent to unclaimed endorsement, once again I have taken this.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿತ್ತಾ?
Serve ಆಗಿತ್ತು ಸ್ವಾಮಿ, he was an agreement holder, he was appear before the court, but later on he has not been contested.
Suit for partition.
Suit for partition.
There's no sale deed in favor of respond number 13?
He is in a MOU agreement holder. With
Sale deed ಇದೆಯೇನಪ್ಪ
No
ಅಂತ
sale.
ಕೇಳಿ. ಬರ್ಕೊಳ್ಳಿ. IA 1024 is filed for substituted service of notice to respond number 1, 3, 3 to 5, 7, 8, 11, 12, 14 and 15. It is evident from the records of this court that the notice issued to the respondent number 1 to 14 has returned unclaimed.
On 31/1/24.
As per the endorsement dated 31/1/2024.
Later on,
Thereafter, fresh process was taken out to serve the said respondents. And the same were returned unserved with an endorsement intimation delivered. Insufficient address ಅಂತ ಹೇಳಿದ್ರು ಬೆಳಿಗ್ಗೆ. Full stop. As regards respond number 15, comma, the notice issued on 31/1/2024 returned with an endorsement, no such address in the address. While the notice issued on 34/2024 returned unserved with an endorsement left. Stop. The respondent 1, 3, 4, 5, 7, 8, 11, 12 and 14. Sorry, the address of the respondent 1, 3, 4, 5, 7, 8, 12, 11, 12, 14 mentioned in the cost title of this court corresponds with their address mentioned before the trial court. Hence, notice to them is held sufficient. So as regards respondent number 15, comma, the learned counsel for the appellants contend that he only had an agreement of sale and a memorandum of understanding. Agreement of sale or memorandum of understanding?
Joint development agreement.
Only a joint development agreement and a general power of attorney. GPA illa?
GPA ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ.
Joint development agreement. Full stop. Therefore, he is not a necessary party but a formal party to this appeal. Hence, notice to respondent number 15 is dispensed. This is the appeal for admission on date. IA 1 of 2024 stands disposed of accordingly. Yes. In view of the above, IA 1 of 24 is disposed of. Yes. Next.
Serial number 30.
Serial number 30.
Yes, sir. 30.
Appearing for respondent number 1, my lords.
Okay, for the appellant, in the morning round, I seek the short,
Prasanna Kumar.
Lords.
short date may be fixed in this case.
There is
Argue for
absolute,
admission, Mr.
It's a suit for partition, my lords,
Where is the family tree?
at page number 49 of the appeal memo. my lord.
49. They are Christians.
Please, my lords.
Property is owned by whom? Aralappa.
Arlappa, my lords. In the 1977, it was been acquired by Shri Arlappa either through a sale deed, my lords. It is subsequently in the year 1997, my lords, the Arlappa died. After his death, my lords, all the children of the Arlappa had given a consent that the revenue records may be transferred in the name of Sri Chandramma. Thereafter, my lords, in the 1999, the last son, the Balraj Mela, who is appellant herein, has applied for a loan in the name of the Chandramma. He has constructed a 4-story building, my lords. Out of his own income, he was auto driver and he constructed a building.
Caro Philomena.
No, my lords, the appellant herein, Balraj. Out of his hard-earned income, my lords. Now, my lords, in the year 2017, the plaintiff, who is the last daughter, who had been married in the year 1993, had filed a suit for partition and separate possession, seeking 1/4 share, which has been decreed.
Oh, 1/4, madam, 1/6 agಬೇಕಲ್ಲ.
Swami, ಅವ್ರು ತೀರೋಗಿದ್ದಾರೆ.
ಯಾರು?
If your lords will have 49, the first son and the second son dies. Only the lineal descendants get share in this properties, my lords.
Yes.
As per Christian law, under section 32, 33 and
For
37.
Christian law, Indian Succession
Indian
Act.
Succession Act.
Ah.
So
Only the
therefore, it is only 1/4 share.
Yes.
And they themselves write that there are no issues. They're
thing
only
is-
dragging this case, my lords.
The thing is, my lords, it is no doubt that the scheduled property, which is a vacant site, was the joint family
The
property.
Indian Succession Act.
32, 33 and 37 are the relevant
Indian
provisions of.
Succession Act.
ತಗೊಳ್ಳಿ.
No, we have. No, but when did this Aralappa die?
In the year 97, my lords.
1970.
1997, my lords.
1997.
Aralappa.
1997, my lords.
97. When did Anthony die?
The 30 years ago, it is mentioned, my lords. That 30
He
years ago.
predeceased his father.
Please,
Yes.
please, my lord.
What about this Philomena Raj?
In the year 2017, my lords.
Then how it becomes 1/4, madam?
So, my lords, if
How
your
does
lords,
it become 1/4?
because my lords, the wife, she is also deceased, my lords, and there are no children. One second, my lords. There are no
Wife is
children.
allowed, my lords.
Right now, there are only 4 people, my lords. Joseph is dead. His
Madam.
children are part in the case.
Mr. Philomen Raj was alive as on date of death of Aralappa.
My lords, he was alive. He also got one share, but he does not have any lineal descendants.
He may not have, but His wife is entitled to claim his
My lords,
share.
his wife is also deceased.
Yaro.
Mary, there is no, there
Has
is, my
been
lords,
informed, my lords, this is alive.
Mary is
my lords,
alive.
she is also not there. And that contention has never been brought before the trial court, either in the written statement or in any notices, nor any evidence is being led to that effect. There is no mention of that even in this RFA,
The
that she is alive.
genealogical tree is produced by themselves only, my lords. In that it is mentioned that Mary is mentioned in that, my lords.
Yes.
There is no stance in the written statement also in respect of that. My lords, the issue here is, this appellant herein is enjoying there are 8 houses which are given for rent, and he is taking
Anthony,
all the rent.
please wait. Anthony does not have children.
No, my lords, he didn't marry. He's a bachelor and he died.
Died a bachelor.
Yes, my lords.
Philomen Raj.
My
his
lords,
wife-
Been married, my lord.
wife is also deceased. In fact, before that itself, they had a church divorce. Of course, there was no divorce before the court. There was a church divorce, and later she is also deceased.
No, is there any mention that she is deceased?
My lords, there's no mention of her being alive. There is no document also. From last 30 years, they are not.
You are claiming 1/4 share.
Correct, my lords.
You do not say that Mary is dead.
My lords, if
You
your
do not
lords
say
will have-
Mary is dead.
Your lords will have my plate.
Where have you said that Mary is dead? If you say Mary is dead and if you produce something to show that, then this division of 1/4 is justified. Please point out where you have said that Mary is dead.
My lords, in my para 1, I have said that Anthony died without marriage. The second son, by name Philomena Raj, died without issues.
Mary's wife.
I agree, my lords. That is not stated
Wife.
in the plain.
Mary's wife, not issue.
Correct.
So Mary is dead ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Allah, my lords,
Allah,
because
my
they were already divorced. The fact that they were already divorced, there was no mention, I believe, my lords. That's the reason there was no mention there.
If there is a divorce, it should be in accordance with the Indian Divorce Act. If there's,
Absolutely.
Just a divorce and it has no recognition.
Correct, my lords. But the last information that I have regarding Mary, that she is deceased, neither they have produced any document to show that she is alive.
But to admit, call for records.
Records of,
Admit this for fine hearing. Yes.
Serial number
But
31.
you should say that Mary is dead, madam. You should say
my lords, I'll
somewhere.
try to get the document to that effect, my lords.
Please produce a document if you get it.
Sure, my lords.
Produce it.
Serial number 31, Vijay Kumar K.
Vijay Kumar.
Appellant, my lord. Seeking adjournment, my lord. Senior is not feeling well.
No adjournment. ಬೆಳಿಗ್ಗೆನೇ ಹೇಳಿದೆ ಕೊಡೋದಿಲ್ಲ ಅಂತ.
ಈ ಶಾರ್ಟ್ ಡೇಟ್
ಕೊಡೋದಿಲ್ಲ.
ಮಿಡಿಯೇಷನ್ ಗೂ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇದು ಲಾಸ್ಟ್ ಟೈಮೇ ಅಪಿಯರ್ ಆದಾಗ ನಾನು ಹೇಳಿದ್ದೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
ಹೌದು ಸರ್.
ನೀವು ಮಾಡ್ಕೊಳ್ದಿರ ಏನ್ ಮಾಡಕ್ಕ?
ಶಾರ್ಟ್ ಡೇಟ್ ಸ್ವಾಮಿ. ವಿತೌಟ್ ಫೈಲ್ ಸರ್.
No, sorry. Please argue for admission. What is the suit for? Specific performance.
Suit for specific performance.
Decree ಆಗಿದ್ಯಾ?
ಹೌದು ಸರ್. ಈ ಶಾರ್ಟ್ ಡೇಟ್ ಮೇಲೆ
ಏನ್ ಎಕ್ಸ್ಪರ್ಟಿ ಡಿಕ್ರಿನಾ?
They had appeared, my lords.
In spite of sufficient opportunity, defense 1 to 5 did not cross-examine PW 1 to 3. They did not lead any evidence also.
No, my lords. They have not filed written statement also.
2019 suit.
I will have it on tomorrow, my lord. Without fail.
ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ? ಸೂಟ್ ಅಲೋ ಮಾಡ್ತೀನಿ, ಅಪೀಲ್ ಅಲೋ ಮಾಡಿ ವಿಲ್ ಡೈರೆಕ್ಟ್.
Has to be remanded.
Madam, it's a substantive relief. That man is being deprived of his property without an opportunity to contest. He had an opportunity, but he did not use it.
He did not use it.
So therefore, ಜಮೀನ್ ಹೋಗ್ತಾ ಇದೆಯಲ್ವಾ?
ಅಲ್ಲ ಅವರು ಎಂಟರ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. They filed ವಕಾಲತ್.
There are so many ifs and buts. One of the lawyer would not have gone, lawyer would be sleeping, lawyer would have gone to some meeting.
Agree.
So many reasons are there.
My objections may be noted.
ಎಷ್ಟು ಅಂತ ಹೇಳಿ? ಎಷ್ಟು ಕೊಡ್ತೀರಪ್ಪ ಕಾಸ್ಟ್?
Nominal cost.
Huh?
Nominal cost.
Nominal ಎಷ್ಟು 4 ವರ್ಷಕ್ಕೆ ಒಂದೊಂದು ವರ್ಷಕ್ಕೆ 10,000 ಹಾಕಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
2019 ಇಂದ ಇದೆ.
ಒಂದು ವರ್ಷಕ್ಕೆ 10,000 ಹಾಕಿದ್ರೆ 50,000 ಆಯ್ತಲ್ಲ, 60,000.
Financial transactions. Financial transaction ಅದೇ ಕೊಡಕ್ ಆಗಿಲ್ಲ ಅಂತ.
ಸರ್ ಲಾಯರ್ 10,000 ರೂಪಾಯಿ ಇಲ್ಲ ಕಡಿಮೆ ಮಾಡ್ತಾರೇನ್ರಿ ವರ್ಷಕ್ಕೆ? ಒಂದು ವರ್ಷಕ್ಕೆ ಒಬ್ಬ ಲಾಯರು 10,000 ರೂಪಾಯಿಕಿನ್ನ ಕಡಿಮೆ ತಗೊಳ್ ಮಾಡ್ತಾರ? ಸೊ ಯು ಹ್ಯಾವ್ ಟು ಪೇ 50,000 rupees.
ರಿಮೈನಿಂಗ್ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಕೂಡ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪ್ಲೇಂಟ್.
ನೋಟ್ ಕೇಳ್ಕೊಂಡು ಹೇಳಿ, 50,000 ರೂಪಾಯಿ ಆದ್ರೆ ಅಲೋ ಮಾಡ್ತೀನಿ. ದಿಸ್ ಟುಮಾರೋ.
Day after Monday, Milan.
Monday is criminal day, criminal petition.
Please.
This tomorrow.
33, government advocate.
7878 days.
There are 3 respondents served on the Tahsildar and Deputy Commissioner.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದ್ದು? When was he served?
One respondent is not served, my lord.
ಯಾವತ್ತು ಸರ್ವಿಸ್ ಆಗಿದ್ದು?
2198. January 98.
20 January 98.
98.
ಯಾರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ?
ತಹಸೀಲ್ದಾರ್ ಆಫೀಸಲ್ಲಿ ಸೀಲ್ ಇದೆ.
ತಹಸೀಲ್ದಾರ್. ಹಾ.
ಚೀಫ್ ಸೆಕ್ರೆಟರಿನೂ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಅವ್ರಿಗೇನು ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಡಿಸಿಗೆ
ಡಿಸಿ ಆಫೀಸು ಸೀಲ್ ಇದೆ.
ಡಿಸಿ ಆಫೀಸ್ ಅದೇ ಯಾವ ತಾರೀಕು?
ಅದು ಸೇಮ್ ಡೇನೆ.
ಸೇಮ್ ಡೇ. How can you say that you are not served?
ಅಲ್ಲ, it is served on person ಅಂತ ಹೇಳ್ತಾರೆ, ಆ ತರ ಪರ್ಸನ್ ಅಲ್ಲಿ ಏನು ಆಗ್ಲಿಲ್ಲ.
ಪರ್ಸನ್ ಹೆಂಗ್ ಸರ್? ಡಿಸಿ ಪರ್ಸನ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ
ಸೇಮ್ ಡೇನೆ ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆ. 22/1/22 ಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸೇಮ್ ಡೇನೆ ತಂದು ಹಾಕಿದ್ದಾರೆ ಅದನ್ನ.
Take action against the person responsible for not contesting the ಏನ್ 7,020 ವರ್ಷ.
ಅದು ನಾಲೆಡ್ಜ್ ಆಗಿದೆ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಬಂದಾಗ ಸಮಯ, ಅದುವರೆಗೂ ಗೊತ್ತೇ ಇಲ್ಲ. ಫ್ರಮ್ ಡೇಟ್ ಆಫ್ ಕಂಟೆಂಪ್ಟ್, ಇವನ್ ಕಂಟೆಂಪ್ಟ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಕ್ಲಿಯರ್ಲಿ
20 years ಆದ್ಮೇಲೆ ಹೆಂಗಿದೆ?
ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಕೋರ್ಟ್ಸ್ ಆಲ್ಸೋ should be cautious to deal with the matter. Even contempt court also.
Cool.
I will file better affidavit, my lord.
No
opportunity may be given for better affidavit.
ಏನು 20 ವರ್ಷಕ್ಕೆ ಡಿಲೇ ಏನ್ ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಆಗ್ತೀರಾ?
ಅಲ್ಲ, ಅದು ಡೀಟೇಲ್ಸ್ ಅದು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿಲ್ಲ ಅದರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ. ಹಂಗಾಗಿ
ಅಲ್ಲ, ಏನ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಫೀಸಿಗೆ ರಜಾ ಹಾಕಿದ್ರು ಅಂತ ಹೇಳ್ತೀರಾ? ತಹಸೀಲ್ದಾರ್ ರಜಾ ಹಾಕಿದ್ರು ಅಂತೀರಾ? ತಹಸೀಲ್ದಾರ್ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
mistakenly taken as.
No, how can that be a mistake?
Moreover, your hardship may kindly see the merits. 194 application is filed, form 50 is filed, rejected. During the pendency of the application, suit is filed for adverse possession. A government land measuring 29 acres, nobody has granted in that land. The merit case, madam.
ಆಯ್ತು, ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಮಾಡಿದ್ರೆ ಯಾಕೆ ಆಗಬಾರ್ದು?
Adverse possession, they are not entitled for adverse possession.
ಆಯ್ತು ಸರ್.
When the form 50 is filed.
Form 50 is rejected. So form 50 is 1991. Form 50 is filed in 91.
Yes, my lord.
So ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದಾರೆ?
71. Form 50 is filed 91. 71.
71
ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. Not disclosed before the trial court. ಅದು ಹೇಳಲೇ ಇಲ್ಲ, ಫಾರಂ 50 ಫೈಲ್ ಮಾಡಿದೀವಿ ಆಗಿದೆ ಅಂತ.
80 years they are the position of the property. The suit was filed.
But is it a fact that you filed form number 50?
ಫೈಲ್ ಮಾಡಿದೀನಿ ನನ್ನ ಜೊತೆಲಿ.
ಅದು ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾಹಿತಿ ಇಲ್ಲ ಇದರಲ್ಲಿ. But from 80 years there is position. The suit was filed in the year 2000.
Sir, we are not discussing about the suit. We are discussing about some application filed by you in form number 50. If you filed an application form number 50, you are bound to disclose it in the suit. Otherwise, this is a judgment obtained by fraud. It can be set aside in any proceedings.
So many documents were produced before the court. Just in the trial court, they are produced before the trial court.
Now, do you deny that you have filed form number 50? Huh? If you filed an application form number 50, then the adverse possession limitation cuts. If you are before some court And if your possession is protected by some tribunal, some committee, then you can't claim adverse possession. ಈ affidavit horrible ಆಗಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. Nothing is mentioned in this.
And that document is also produced along with the appeal. From 50, rejection order, everything is produced before. But is the same is suppressed before the trial court and then the order.
ಈ affidavit ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಫಾರಂ 50 ಬಗ್ಗೆ?
ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ, appeal ಅಲ್ಲಿ ಹೇಳಿದ್ವಿ. Grounds ಅಲ್ಲಿ. ಅದಕ್ಕೆ I am seeking time better affidavit.
Learned additional Advocate General seeks time to file a better affidavit in support of IA 1023, list on so and so. Yes.
Serial number 34, Raj Baba K.
Raj Baba. ಏನ್ ಸರ್ 15 ಲಕ್ಷದ್ದು ಚೂಡವ್ರೆ 15 ಲಕ್ಷ. Yes, Mr.
My lords, if I may respectfully submit, my lords, I wish to bring two facts before this honorable court, my lords. My lords, in 2011, there is a representation by the vendor to the Tahsildar to reflect his name in the MR. It was in 95, the original owner, he had granted through a will to the vendor. He died in 95, and before the revenue entries came into his name, he made a sale agreement to us. In 2011, he went and gave a representation to the Tahsildar to reflect his name. Even in 2014, only in the year 2014, after our continuous persuasion, in 2012 also we had to sell one of the properties to show our readiness and willingness to purchase to complete the sale deed. My lords, in 2014, only then the revenue entry's name is reflected in the name of the vendor. After issuing a legal notice in 2014, my lords, it's on the same address where the vendor resided. The legal notice was served. Only after serving him, we filed a suit for specific performance in 2015.
Yes.
Lords, the learned trial court unfortunately has failed to record the mixed question of fact and law.
How can it be a mixed question of law?
My lords, mixed question of fact.
Fact. How can it be a mixed
My lords,
question of
from
fact?
the date of refusal, my lords.
Why is date of refusal? Time is not fixed.
My lords, time was indeed fixed. The vendor kept on persuading us for the continuous 4 years. I was a 70-year-old person. I was a 70-year-old person, my lords. He kept on persuading me. Only in the 2014, we got to know that after he received the revenue entry in his favor, we have sufficient documents to demonstrate, my lords.
Correct. Apart 2010 ನಲ್ಲಿ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರೋದು.
Yes, yes, my lords.
3 months will take you to March 2011.
Please, my lords.
3 months, March
Please.
2011.
Please,
So March 2014 ನಲ್ಲಿ you should have filed a suit.
Please,
Now you are saying that in March 2014 his name was not entered in the revenue records.
My lords, only in the year 2014, my lords, one document.
How did you enter into an agreement without ascertaining the documents?
My lords, it was in his father's name. He persuaded us so much so that we are not going anywhere, only to complete the sale deed. He even made us to sell our remaining property to complete the sale transaction. We were ready with our remaining part of the sale consideration, my lords.
So what did you do? You are ready with the remaining consideration.
We are ready, my lords.
What did you do? Did you file a suit within time?
My lords, we in fact sent a legal notice in the year 2014.
ಅಷ್ಟೇ. ಬರ್ಕೊಳ್ಳಿ.
My lords, only in the year 2014, we came to know that the plaintiff.
Accept 15 lakhs or you want to dismiss of the appeal?
My lords, it may be posted on Tuesday, my lords. There are 5 LRs to be.
Tomorrow. This tomorrow.
Serial number 36.
Ravindranath.
Not happy for the brief. Not appellant in this.
Grateful, my lords.
Yes, Chandrasekhar.
Sir. Now, my lords, on the last date of hearing, my learned friend has furnished a sketch along with the memo if your lordships could kindly peruse the sketch and the
Page?
my lord, separately on the last date of hearing, my lord, a sketch was.
Memo, along with the
submitted.
memo which has been filed.
Please don't interfere, Mr. Ravindranath.
Please,
Please, sorry.
now, my lords, if your lordships could kindly peruse the sketch and the schedule, my learned friend was referring to the schedule in the decree, and now on comparison of the schedule in the decree and the sketch given by my learned friend, not the boundaries are totally different. If your lordships could kindly see the sketch. As per the sketch,
ಅಲ್ಲಲ್ಲ, ನಾನ್ ಕೇಳ್ತೇನೆ.
ಬಂದೆ.
Let me clarify what is.
I'll
without running in my
clarify
mind,
why,
first-
my lords, they have made a submission and it is nothing but they are misleading the honorable court also. I'll come to it. If your lordships could kindly bear with me for a few minutes. If on a perusal of the sketch, ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ 4.5 ಗುಂಟೆ ಒಬ್ಬರಿಗೆ 4.5, ಅದು ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಸರಸ್ವತಿ ಮತ್ತೆ ಜಯರಾಮ್ ರೆಡ್ಡಿ, ವಸಂತ ಮತ್ತೆ ನಾಗರಾಜ್ ಅಂತ ಸೀರಿಯಲ್ ಆಗಿ ಫೋರ್ ಆಫ್ ದಮ್ ಲಾಸ್ಟ್ ಕಾಲಮ್ ಇಲ್ಲಿ ತೋರಿಸ್ತಾರೆ. This is entire survey number 192/1 what they have given. Now, if your lordships could kindly see, my lords, Lord, I am furnishing, my lord, the Google sketch. The entire property has been developed.
Google sketch ಅಲ್ಲಿ ನಾವು
ಇಲ್ಲ ಬಿಲ್ಡಿಂಗ್ಸ್ ಬಂದಿದೆ. ಯಾಕೆ ಹೇಳ್ತಾರೆ ಅಂತ ತೋರಿಸ್ತಾ ಇದೀನಿ ಅಷ್ಟೇ ನಾನು. Otherwise, my lords, your lords, please.
Decree ಅಲ್ಲಿ ಏನಪ್ಪ ಇದೆ?
Sir?
What are the boundaries mentioned in the decree?
Boundaries are there in the decree. My lord, I have made the submission on the other day also, my lord. Even today, I am making the same submission, my lord. Very honestly, my lord, without any suppression, I am making the submission. In fact, my lord, the other side is trying to mislead this honorable court. My lord, the entire 54 guntas, my lord, has been divided.
Mislead ಮಾಡ್ತಾರೆ, ನೀವು ಲೀಡ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
ಅದಕ್ಕೆ ಬರ್ತಾ ಇದ್ದೀನಿ ಸರ್, ಅದಕ್ಕೆ ಬರ್ತೀನಿ. 54 guntas, my lord, has been divided among 3 brothers. Not during the pendency of the final decree proceedings, not the other brothers, that is, my lords, the uncles of my lords, the appellant herein and the respondents, my lord, they randomly, my lord, they have taken and developed the property. My lord, the buildings have come up. Now, as per that sketch, my lords, it is not in, my lord, consonance with the, my lord, boundaries nor the, my lord, actual, my lord, village map also.
Why did you not get this decree amended?
Please, my lord.
ಈ decree amendment ಮಾಡ್ಕೋಬೇಕಲ್ವಾ? Right or wrong, there is a decree passed by the court.
Please, my lord, please.
Now, you cannot say that I will divide a property which is not subject matter of the
No,
decree.
ಯಾಕೆ ಅವ್ರು ಕೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಆಲ್ರೆಡಿ my lord, the kindly see the my lord, the appellant herein, my lord, he is in the portion, my lord, shown at, my lord, the second portion, my lord, shown to Jairam Reddy. Already he has put up construction and he is residing there.
ಏನಾದ್ರು ಮಾಡ್ಕೊಂಡು.
He has given for rents. He has given for rents. And wherever, my lords, the uncles of, my lords, the appellant have put up the construction, as per this sketch, my lord, it is shown to the respondents 1 and 2 here, my lord.
Yes.
Respondents 1 and 2. There is no property at all, absolutely. Wherever, my lord, vacant property was there, randomly they have constructed, that has been divided. As per this sketch, my lord, the construction part has been
The
given.
report of the court commissioner.
Please,
Whether
there is an observation in the order also, my lords.
ಈ ಚೆಕ್ ಬಂದಿಲ್ಲಿರುವಂತ ಪ್ರಾಪರ್ಟಿ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಏನಾದ್ರು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲಿ ಒಂದು ನಿಮಿಷ. Order ಅಲ್ಲಿ, if your lordships could kindly, my lord, paragraph, my lord, I'll come to para 12, my lords. There's the reference, my lords, to that. Para 12 of the, my lord, I think page 19, my lord. If your lordships.
Two of what?
Not para 12, my lord, of the order, my lords. Final decree proceedings. In page 19. Internal page 7 of the final decree proceedings. Para 12. The court commissioner has produced the notice issued to the parties postal remit so and so. In his intimation dated 19/3/2024, he has specifically mentioned that already houses are constructed over survey number 192/1, and hence he cannot conduct the survey physically, but he has identified the other mode, he has said.
How can you do that?
Right?
Who is it?
Next
No,
paragraph.
please wait. Who is he to do that?
Right, he ought not to have done.
Court said,
Please, my lord.
court said to the commissioner, ಇದೊಂದು ಜಾಗ ಇದೆಯಪ್ಪ, ಇದು ಹೋಗ್ಬಿಟ್ಟು ಡಿವೈಡ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಹೇಳಿ. He goes to the spot, says that I cannot identify the property. But he picks up vacant portions and he divides those vacant portions. Who is he?
Not yes, whatever available, not in so far as Mahazar is concerned, my lords, the uncles have also, my lord, are signatories to the settlement. My lord, he will not get the jurisdiction, my lord, I agree with your lordship.
He has to only put a report.
Please, my lord, I agree with your lordship.
He has to only file a report to the court.
True, my lord.
Saying that this property cannot be identified.
True, my lord.
Because there are many constructions
Yes.
put up. So the court would take a call as to what should be done.
But I agree with your lordship.
Who is he, this man, to divide?
But he will not get any jurisdiction to, my lords, if there is no, I'll agree with your lordship, my lord, there is no dispute. But even assuming for a moment, my lord, I thought, my lord, I wanted to get a commissioner appointed from this honorable court.
No,
My lord,
not
ultimately, my lord, the result would be the same. Whatever available properties are there, insofar as those properties are concerned, my lord, it has to be divided and allotted, that's all.
No,
Nothing.
The decree has to be altered.
True, my lords.
Decree has to be altered. Decree alter ಮಾಡಿದಂಗೆ ನೀವು ಅವ್ನ್ ಮನ್ಸಿಗೆ ಬಂದಂಗೆ ಅವ್ನ್ ಕೊಟ್ರೆ ಈ ಸ್ಕೆಚ್ಗೂ ಮತ್ತೆ ಡಿಗ್ರಿ ಟ್ಯಾಲಿ ಆಗಲ್ವಲ್ಲ.
ಈಗ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಸ್ಕೆಚ್ ನೋಡಿ ಸ್ವಾಮಿ, ಅದು ಟಾಲಿ ಆಗಲ್ವಲ್ಲ.
ಅವ್ರದ್ದು ಬೇಡಪ್ಪ.
ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಟಾಲಿ ಆಗಲ್ವಲ್ಲ.
ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ.
ಆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರೋದು ನಮಗ್ ತೋರಿಸ್ತಾರೆ.
ಬರ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಅದ್ರ ಜೊತೆಗೆ ಅದರ್ ಸಬ್ಮಿಷನ್ ಲಾಡ್ಜ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ. In so far as item number 1 is concerned, my lord, that has been done.
Item number 1 ಬಗ್ಗೆ ಅವರು ಕೇಳ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ, item number 2 ಬಗ್ಗೆ my request to your lordships, my lords, if you are, my lord, remanding the matter to the trial court, my lord, in so far as item number 2 is concerned, my lord, we'll file necessary application, seek for modification. But my request to your lordship is, my lord, let there be a time limit, my lords. Otherwise, my lords, the appellant, my lord, because the appellant, my lord, along with sisters respondents 1 and 2 has filed the suit. He himself has given the schedule in the plaint also.
4th January 2025 passed by the 18th additional city civil judge Bengaluru in FDP 171 of 2012. Next para. A suit in OS number 1749 of 2006 was filed for partition separate possession of the plaintiff's share in the suit's real property. The said suit was decreed. Full stop. The suit was filed in respect of 2 portions of land, namely land in survey number 2 survey numbers, sorry, 2 portions, 2 survey numbers, namely land in survey number 8/3 of Dodda Nekundi village, Vartur Hobli, Bengaluru urban district, measuring 2 acres, including 8 guntas of Karab, and survey number 192/1, measuring 18 guntas, situated Dodda Nekundi, Vartur Hobli, Bengaluru East Taluk, Bangalore, measuring 18 guntas. Full stop. The plaintiffs then filed FDP 171/2012 for giving effect to the preliminary decree granted in
Plaintiffs 2 and 3 and
plaintiffs 2 and 3.
One has
granted
not
in
tried.
OS number 1749 of 2006. The trial court, the final decree court appointed a commissioner for division of both the aforesaid properties. Accordingly, the commissioner submitted a report by demarcating portions of the properties as per the shares of the plaintiffs in survey number 8/3. Insofar as survey number 192/1 is concerned, the commissioner specifically mentioned that already houses are constructed over survey number 192/1, and hence he cannot conduct this, and hence I cannot conduct the survey physically, but I have identified open spaces through total station method. Full stop. The final decree court, after perusing the report of the commissioner, accepted the division insofar as survey number 8/3 is concerned. However, insofar as survey number 192/1 is concerned, it held double inverted comma. I have perused the said report and found that there is no any illegality committed by the court commissioner. Full stop. He has divided survey number 192/1 measuring 18 guntas and shown the property as available on the spot. As per the said report, he has allotted the property marked as 11 Roman 2A to 2C, totally measuring 3 guntas 24 annas in favor of respondent number 3, 4 guntas 8 annas in Roman 1A and Roman 1B to respondent number 2. 4 guntas 8 annas in 3A and 3B are allotted to Srimati Saraswati, and 4 guntas 8 annas is in Roman 4 is allotted to Srimati Vasanta. Full stop.
But that has been modified, my lord. At page 12, your lordship should see, internal page 12, allotment as modify ಮಾಡಿದ್ದಾರೆ court ಅಲ್ಲಿ ಅದನ್ನ. Whatever the commissioner had allotted, that has been modified and allotted by the court.
The final decree court, after accepting the report, passed an order allotting Roman 1A and 1B, measuring 3 guntas and 1 gunta 8 annas in favor of Srimati Saraswati / petitioner number 2 before it. 4 guntas 8 annas identified as Roman 4 to petitioner number 1 / Vasanta. Portion shown as 2A and 2B and 2C, totally measuring 4 acres, 4 guntas 8 annas to respondent number 3 Jayappa, and Roman 3A and 3B measuring 4 guntas 8 annas to respondent number 2 / NS Nagaraj. Full stop. Being agreed with the said demarcation and apportionment, the appellant is before this court. The learned counsel for the appellant submits that survey number 192/1 was bound by the boundaries mentioned in the decree, and therefore the division ought to be in accordance with the boundaries mentioned in the decree. He contends that the the survey commissioner who was appointed to divide survey number 192/1, instead of identifying the land in survey number 192/1 within the boundaries mentioned in the decree, had reported that several houses had come up in the property and that he had identified vacant spaces in the said property and had divided the same. Full stop. He contends that this is impermissible, as the survey commissioner cannot arrogate to himself the power of the civil court. If there's any alteration in the boundaries, it must have been done by the civil court and not by the commissioner. Full stop. Per contra, the learned counsel for the respondent submits that the survey commissioner has identified 18 guntas of land in survey number 192/1 which are vacant, and he has equitably distributed the land amongst all the sharers. He therefore contends that there is no illegality about the way in which the survey commissioner has divided the properties. He therefore contends that no interference is warranted with the order passed by the final decree court accepting the report of the commissioner and modifying the shares. So I consider submissions made by the learned counsel for the petition appellant as well as the learned counsel for the respondents. Next paragraph. A copy of the preliminary decree granted in OS number 1749 of 2006 shows that survey number 192/1 measuring 18 guntas situated at Dodda Nikundi village was bound on the east by road, west by Rama Reddy's property, north by private property, south by Lakshmaya Reddy's property. It is not the case of the respondents before the final decree court that survey number 192/1 with the boundaries mentioned above does not exist, or that several of that the parties to the suit had developed portions of land in survey number 192/1. Full stop. Once the survey commissioner was appointed to identify survey number 192/1 within the boundaries mentioned in the decree and to divide the properties as per the preliminary decree, he ought to have first identified the property by identifying the boundaries and thereafter must have divided the properties equitably as per the decree. Full stop. However, it appears from the impugned order that the survey commissioner had reported to the court that several houses have come up in survey number 192/1, and therefore he cannot conduct a survey physically. And that he has identified open spaces through total station method. Full stop. The trial court, after receiving such a report, must have of the decree insofar as the boundaries of survey number 192/1 is concerned, or must have taken necessary steps to identify the identify the land within the boundaries mentioned therein. Full stop. On the contrary, the trial court, the final decree court has accepted the report of the commissioner and thereafter modified the shares as identified by the commissioner and allotted the shares to the petitioner, the appellant and the respondents. Full stop. It is apparent that this division is not in consonance with the preliminary decree granted, as the boundaries mentioned in the preliminary decree do not correspond with the boundaries mentioned in the report of the court commissioner or in the final decree passed by the court. In that view of the matter, the impugned order passed by the final decree court, insofar as survey number 192/1 is concerned, has to be set aside to ensure that the final decree drawn will be in line with the preliminary decree. Full stop. Therefore, this appeal is allowed. The impugned order passed by the so-and-so court in FDP 171 of 2012 is set aside insofar as survey number 192/1 of Dodda Nikundi village is concerned. It is open for the parties to file appropriate application to alter the boundaries of survey number 192/1 based on the 192/1, and it is for the court to decide, it is for the final decree court to decide whether such alteration is feasible and is just and proper, and thereafter proceed to pass appropriate orders. Yes.
Serial number 38.
Time limit could be fixed by this.
The
Otherwise,
final decree court shall conclude this exercise within a period of 6 months from the date of receipt of a copy of this
4
order.
months.
ನೀವು ಎದ್ದೇಳೋದಕ್ಕೆ 6 ತಿಂಗಳು ಬೇಕು. ಇನ್ನು ನೀವು ಅಪ್ಲಿಕೇಶನ್
My lord, on submission
amendment.
to my lord, your lordship. My lord, on submissions.
Uh,
My lord, on submission. My lord, in respect of survey number 8/1, my lord, I may be allotted, my lord, in the first beginning. My lord, other respondent, my lord, other respondent petition may be allotted in 3, 4, my lord, 2, 3, 4. I may be allotted one, my lord, because there is no coordination between the, my lord, the petitioner. That's why, my lord, only I request in that other survey number, my lord, I allotted block number 1.
That you should have argued before the final decree court.
Lord, that's why, that is also, my
Next,
lord, argued the matter, my lord, instead of that, it has been given.
Serial number 38. Ajit.
Lords, the defendant is before your lordship. Lords, though the plaint first prayer, my lords, was for mandatory injunction.
allowed in part and See number 38. Yeah, objections. For what?
To the IA. ಹೋದ್ ಸರ್ತಿ ನಾವು ಕೇಳಿದ್ರು.
Objections to what?
To the application, not
for stay.
For stay.
There appears no application is filed. ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಹಾಕಿದೆ.
ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. ಏನ್ ejectment ಆ?
Suit for possession.
Possession.
Though it was worded as
based on title.
Based on title.
Then admit. Interim order granted on 5/3/2026 is continued until dispose of this appeal.
Great.
Paper call for records, paper books to be filed within 8 weeks.
Great.
Mohan Chandra.
49, 14% Mohan Chandra P.
Yes. Hmm.
One application is called.
Huh?
I number one, regarding restoration of the schedule fee, including the movables. Second application regarding the respondent has taken a contention that I have vacated the premises. Within my specific content, I have not vacated premises. He has
I
not.
could come and argue on merits.
Yes, that's why.
Argue on merits of the.
Suit is one for ejectment filed by the respondent hearing and dependent before trial judgment. The date of agreement is 4/4/2021, my lord. And then thereafter continued the tenancy on 22/3/2024. There is no dispute between landlord and tenant relationship. Tenancy was continued till 22/3/2024. In the meantime, the respondent has interfered with my position and I filed the suit for permanent injunction in OS number 3040/2023. In the said suit, the trial court has granted temporary injunction. Thereafter, on 22/3/2024, respondent hearing got issued a notice terminating the tenancy. I sent a reply 8/4/2024 denying the entire contention and sought for counterclaim stating that he has discontinued electricity supply and caused a lot of damage, etc. Thereafter, he has discontinued electricity supply on 1/5/2024. Once again, thereafter, he has discontinued water supply in the month of June 2024. Thereafter, on 6/7/2024, the plaintiff has respondent has filed a suit for eviction. Such notice was served to me in the month of November. I filed a detailed written statement denying the main contention of the respondent that I am in areas of rent.
Your?
Areas of rent. And she has terminated my tenancy. I deny the entire contention of the respondent. And there are sought for counterclaim in the said suit. Thereafter, the respondent has filed IA for areas of rent. I filed application for restoration, electricity, water supply, etc. And appointment of court commission. After hearing both sides, the institute trial court posted the case for order on I number 4, 6, and 7. Instead of passing the order on I number 4, 6, and 7, trial court passed the judgment under order 12 rule 6 CPC, stating that I admitted the contents of the defendant. It is completely false. I agree. Your lordship, kindly see the judgment.
Yes, madam. How could the court decide on admissions without hearing the parties?
My lord, kindly see the admission, what admissions I have given, my lord.
The court heard IA number 4, 6, and 7. The court heard IA number 4, 6, and 7. Instead of deciding those applications, court disposes of the suit itself.
Not only my suit, my lord, even his suit also decreed, my lord.
The suit itself is disposed of. How?
Because, my lord, I have given the admission saying that even the, kindly see the page number 8, my lord, page number 7, in paragraph 9. What admissions I have given? As per this provision, the court, on the basis of the application filed by the parties or on suo motu, can pass judgment on admissions, and these admissions can be out of the pleadings or otherwise, and it may be orally or in writing. While hearing IA numbers 4, 6, and 7, the learned counsel for the plaintiff fairly submitted that tenant has filed the suit for permanent injunction not to evict him without due process of law. He also fairly submitted that the plaintiff is ready to refund the security. is ready to refund the security deposit of rupees 1,05,000 to the tenant. Defendant is ready to pay the arrears of rent. Even he argued that the landlord is ready to give up his claim for arrears of rent exceeding security deposit if tenant is going to vacate the suit property immediately and hand over the possession of the suit property. The tenant, the party in person also.
ವಾಪಸ್ ಕೊಡ್ತೀರಿ ಹೇಳಿ. When will you repay?
ಇವಾಗ ನನ್ಗೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ 2023 ಇಂದ ಇಲ್ಲಿ ತನಕ ನನಗೆ ರೆಂಟು ಇಲ್ಲ, ವೇಕೆಂಟ್ ಆಗೇ ಇದೆ, ನನ್ಗೇನು ಇಲ್ಲ. ಐ ಆಮ್ ಎ ಸೀನಿಯರ್ ಸಿಟಿಸನ್. ನಾನು ಅವತ್ತೇ ಹೇಳ್ದೆ ನಾನು ಅವರಿಗೆ ವೆಕೇಟ್ ಮಾಡಿ ನಾನು ಅರಿಯರ್ಸ್ ಬಿಟ್ಬಿಡ್ತೀನಿ. ಅರಿಯರ್ಸ್ ಅವತ್ತಿಗೆನೆ 2 ಲಕ್ಷ ಆಗತ್ತೆ.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ?
ಅಲ್ಲ ನಂದು ಬ್ಯಾಲೆನ್ಸ್ 4 ವರ್ಷದಿಂದ ನನ್ಗೇನು ಇಲ್ಲ.
ಬಾಡಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು?
11,500 ಕೊಡ್ತಾ ಇದ್ರು.
11,500 up to 2024 ಮಾರ್ಚ್.
ಅಲ್ಲ ಇದೊಂದು ರೆಸಿಪ್ಟ್.
What is there to show that you have paid?
ಸ್ವಾಮಿ ಇದೊಂದು ರೆಸಿಪ್ಟ್ ಇದೆ, ಅವರೇ ಎಕ್ಸಿಕ್ಯೂಟ್.
Tenant, the landlord has not issued single receipt. So, so in the year 2023, he tried to interpret my position. ಅವಾಗ ಏನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ವೆಕೇಟ್ ಮಾಡ್ತೇನೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡೆ, ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಟರ್ನ್ ಆಫ್ ದಿ ಸೆಕ್ಯೂರಿಟಿ ಡೆಪಾಸಿಟ್ ಅಂತಿದ್ವಿ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ 15,000 ಕೊಟ್ಟು ನನಗೆ ಏನ್ ಮಾಡಿ ಅಂದ್ರೆ ವೆಕೇಟ್ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟದೇ ಇದ್ದಾಗ ನಾನು ವಯಸ್ಸು 30/2023 ಇಂಜೆಕ್ಷನ್ಗೆ ಹೋದೆ. ಅವ್ರು ಒಂದ್ವೇಳೆ ಕೊಟ್ಟು ನಾನು ಅವತ್ತು ವೆಕೇಟ್ ಮಾಡಿರ್ತಿದ್ದೆ. ಡೈರೆಕ್ಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಇಂಜೆಕ್ಷನ್ ಟೆಂಪರರಿ ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಇದ್ರೂ ಕೂಡ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಡಿಸ್ಕೌಂಟ್ ವಾಟರ್ ಎಲ್ಲ ಮಾಡಿ ಮೈನ್ ಗೇಟ್ ಲಾಕ್ ಆಗಿ ಯಾವುದೂ ಬಿಟ್ಟಿಲ್ಲ. ನಾನು ಇವರು ಇದಕ್ಕೆ ಒಂದು 3-4 ಕಂಟೆಂಪ್ಟ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಉಂಟು.
ಎಲ್ಲ ದಯವಿಟ್ಟು ಸ್ಟಾಪ್ ಮಾಡಿ. ಮಿಸ್ಟರ್, you filed a suit for injunction 3040 in 2023.
17/5.
You cannot claim that you had paid the rent by cash. You cannot claim that because you already filed a suit in 2023.
ಅದಕ್ಕಿಂತ ಬ್ಯಾಕ್ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
ಅದಕ್ಕಿಂತ ಬ್ಯಾಕ್ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಏನಿದೆ ಪ್ರೂಫ್?
ನಾವು ಅದಕ್ಕಿಂತ ಬ್ಯಾಕ್ ಇಂದ ಕೇಳ್ತಾ ಇಲ್ಲ. ನಾವು ಅದಕ್ಕಿಂತ ಬ್ಯಾಕ್ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾವು. ಅಲ್ಲ ಇಲ್ಲೇ ರಿಸಿಪ್ಟ್ ಇದೆ, ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿರೋದು.
ಮಧ್ಯವರ್ತಿದಲ್ಲಿ ಮಾತಾಡಬೇಡಿ. ಎಷ್ಟೊತ್ತಿ ಹೇಳಿದ್ ನಿಮಗೆ?
ಸಾರಿ.
When did you come into possession, Mr.?
4/4/2023.
4/4/21. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರೆ, ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ರೆ ದುಡ್ಡು? ಎಲ್ಲ ಕ್ಯಾಶ್, ಆಲ್ ಕ್ಯಾಶ್. ನೋ ರಿಸಿಪ್ಟ್.
ಇಲ್ಲ ಅವರು ಕೊಟ್ಟಿಲ್ಲ,
ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ.
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ 1 lakh ಕೊಟ್ಟಬೇಕು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ.
1 lakh ಕೊಟ್ಟಿದ್ದು ಕ್ಯಾಶ್ ಅಲ್ಲೇ ಕೊಟ್ರಾ? 1 lakh ಕ್ಯಾಶ್.
ಯಾಕಂದ್ರೆ ಆ ಟೈಮ್ ಫೋನ್ ಪೇ ಇಲ್ಲ ನನ್ನಲ್ಲಿ, ಯಾವುದಕ್ಕಿಲ್ಲ. ಈಗ ನಾನು ಮಾಡ್ತಿದ್ದೇನೆ, ಈಗ ಫೋನ್ ಪೇ ಅಲ್ಲಿ ಬೇರೆ ಕಡೆಯಲ್ಲಿ ಕೊಡ್ತಿದ್ದೆ. ಅವಾಗ ಫೋನ್ ಪೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಕ್ಯಾಶ್ ಅಲ್ಲಿ.
ಅಗ್ರಿಮೆಂಟ್ ಏನ ಇದೆಯಾ?
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಉಂಟು, ಬರ್ದು ಅದು ಎಡ್ಮಿಟೆಡ್.
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಏನಾದ್ರೂ ನೀವು ಕ್ಯಾಶ್ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಏನಾದ್ರೂ ಪ್ರೂಫ್ ಏನೋ ಇದೆಯಾ?
ಕ್ಯಾಶ್ ಕೊಟ್ಟದಕ್ಕೆ 2023 ಫೆಬ್ರವರಿ ಮಾರ್ಚಿನದ್ದು ಕೊಟ್ಟದಕ್ಕೆ ಅವರಲ್ಲಿ ಅದೇ ರಿಸಿಪ್ಟ್ ಅವರು ಕೊಟ್ಟದಕ್ಕೆ ನಾನು ತಗೊಂಡೆ. ಯಾಕೆಂದ್ರೆ ಅದಕ್ಕೆ ಮೊದಲಿನದ್ದು ಅವರು ಇದು ಮಾಡಿಲ್ಲ, ಅದಕ್ಕಾಗಿ ಅವರೇ ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ. ಅಪ್ ಟು ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅದು ಕೇಳ್ತಿದ್ದಾರೆ ಅವರು.
ಇದೇನ SC ನಂಬರ್ ಏನೋ ಹಾಕಿದ್ರು, ಅದೇನದು?
ಅದು SC ಅಲ್ಲಿ ಏನಂದ್ರೆ,
ವಾಟ್ ಇಸ್ SC?
SC is the son of the respondent committed murder of his mother. ಅದರಲ್ಲಿ ಏನಾಯ್ತಂದ್ರೆ, ನಾನು ಅಲ್ಲಿದ್ದಾಗ ನನ್ನಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡಿ ಆ ಕೇಸ್ ನಡೆಸಿ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ಅದ್ರಲ್ಲಿ ಕೇಸ್ ನಡೆಸಿದ್ದಕ್ಕೆ ಅವ್ರು ಏನ್ ಮಾಡಿ ಅಂದ್ರೆ ಯಾವುದೇ
ನಿಮ್ ಕ್ಲೈಂಟ್ ಇವರು
ಅದ್ ಮೊದಲು ನಾನು ಟೆನೆಂಟ್ ಆದ್ರೆ ಅಲ್ಲಿ ಪೆಂಡ್ ಇದ್ದಾಗ ಅವ್ರು ಇದು ನಡೆಸಿ ಅಂತೇಳಿ ಅದಕ್ಕೆ ನಾನು ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಅದು ಅವ್ರು ಹೇಳಿದಕ್ಕೆ ನಾನು ನಡೆಸಿದೆ, ಅದು ಅಮೌಂಟ್ ಇಸ್ಕೊಟ್ಟಿಲ್ಲ.
ಇದಕ್ಕೆ ಏನ್ ಹಿಂಗ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ನನ್ನ ಇಷ್ಟಕ್ಕೆ
ಯಾಕೆ ಮೋಹನ್ ಚಂದ್ರ, why do you want to get into a mess? Please get out.
ನಾನು ಆಲ್ರೆಡಿ ಕೋರ್ಟಿಗೆ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಆಫ್ ದಿಸ್ ಆನರ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟರ್ ಮೀ ಟು ಫೈಲ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಪೀಲ್. ನಾನು ಅಪೀಲ್ ಕೂಡ ಇಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. ಮೇ 30, 2026 ಒಳಗಡೆ ವೆಕೇಟ್ ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತೇನೆ. ಆದ್ರೆ ಟಿಲ್ ಟುಡೇ ನನಗೆ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಪೊಸಿಷನ್ ಕೊಡೋದು ಅಲ್ಲಿದ್ದಂತ ಎಂಟೈರ್ ಮೆಟೀರಿಯಲ್ಸ್ ಅನ್ನು ಖಾಲಿ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ. ನೋಡಿ ಕಂಪ್ಲೇಂಟ್ಸ್
ಬರೀ ನಿಮ್ ಕೇಸ್ಗಳೇ ನಡೆಸ್ಕೊಂಡಿರ್ತೀರ ಅಷ್ಟೇ ಲೈಫ್ ಲಾಂಗ್. ಪ್ಲೀಸ್ ವೆಕೇಟ್. ಯಾವಾಗ ಖಾಲಿ ಮಾಡ್ತೀರಿ?
ಸಾಮಾನ್ಯ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನು ಕೊಟ್ಟರೆ
ಸಾಮಾನ್ಯ ಏನು ಇಲ್ಲ ಅಲ್ಲಿ.
ಅವರು ವೆಕೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲಿಂದ ರಿಮೂವ್ ಮಾಡಿದ್ದಾರೆ.
ಮೇಡಮ್ 1 ಲಕ್ಷ.
ಅಲ್ಲ ನನಗೆ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟೇ ಬಂದಿಲ್ಲ. ನಾನು 4 ವರ್ಷದಿಂದ ಅದು ವೇಕೆಂಟೇ ಇದೆ.
ನೋಡಿ ನಿಮ್ಮ ಲಾಯರ್ ಅವರು.
ಸ್ವಾಮಿ ನಾನು ಅವ್ರ ಲಾಯರ್ ಆಗಿದ್ದಕ್ಕೇನೆ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದೀನಿ. ಇಲ್ಲ
ಅವ್ರು ಹೇಳ್ತಾರೆ ಆ ಕೇಸ್ ಮರ್ಡರ್ ಕೇಸ್ ಫೀಸೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾರೆ.
ಸ್ವಾಮಿ
ನೀವು ನೋಡಿದ್ರೆ ಬಾಡಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತೀರಾ.
ಅಲ್ಲ ಅವ್ರು ಅದ್ರಲ್ಲಿ
ನಾನಿಷ್ಟೇ ಅವ್ರು ನನಗೆ ಕೊಡ್ಲಿ ನನ್ನ ಎಂಟರ್ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ಟು ನಾನು ಮೇ ಅಲ್ಲಿ ವೆಕೇಶನ್ ಅಲ್ಲಿ ಖಾಲಿ ಮಾಡ್ತೇನೆ.
ಅಲ್ಲ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಒಂದ್ಸತಿ ನೋಡಿ
ನೋಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟು IAML ಹಿಯರ್ ಮಾಡಿ ಮೇನ್ ಸೂಟ್ ನಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರ ಆನ್ ಅಡ್ಮಿಷನ್. ಶುಡಂಟ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಗಿವ್ ಅನ್ ಆಪರ್ಚುನಿಟಿ.
ಅದನ್ನ ನಾನು ಒಪ್ಕೋತೀನಿ.
ನೀವು ಒಪ್ಕೋತೀರ ಅಂದ್ಮೇಲೆ ಸೆಟಿಸ್ಫೈಡ್ ಆಗ್ಬೇಕಲ್ವಾ ಇದು?
ಅಲ್ಲ ಇವಾಗ ಅವರು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನಾನು
ಪೊಸಿಷನ್ ಬಿಡಿ, ಅದ್ ಬೇರೆ ವಿಚಾರ. ಜಡ್ಜ್ಮೆಂಟ್ ಸೆಟಿಸ್ಫೈಡ್ ಆಗ್ಬೇಕಲ್ವಾ?
ಹಾಗಾದ್ರೆ ಅವ್ರ ಸೂಟ್ ಕೂಡ ರಿಸ್ಟೋರ್ ಆಗ್ಬೇಕಾಗತ್ತೆ.
ಅವ್ರ ಸೂಟು ರಿಸ್ಟೋರ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಅವ್ರ ಅಪೀಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರು ಅದ್ರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್
ಇಲ್ಲ 1 ಲಕ್ಷ ಏನೋ ಇದೆ ಅದು ವಾಪಸ್ ಕೊಡಿ. ವಿಲ್ ಆಸ್ಕ್ ಹಿಮ್ ಟು ವೆಕೇಟ್.
ಅಲ್ಲ ನಂದು 4 ವರ್ಷದ ಅರಿಯರ್ಸ್ ಇದೆಯಲ್ಲ ಅದ್ರ ರೆಕವರಿಗೆ
ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ನಾನು ಒಂದ್ಸತಿ ಪಾಠನ ಕೇಳಿ ಹೇಳ್ತೀನಿ.
ನಾಳೆ
Final hearing matter serial number 46. D. Prabhakar, PM Narayan Swamy, Ramesh Kumar V.
Mr. D. Prabhakar. Yeah, EF for production of additional documents is filed by whom?
Suit for fair injunction.
IA ಯಾರು ಹಾಕಿರೋದು? ನೀವು ಹಾಕಿರೋದು? IA ಯಾರಪ್ಪ ಹಾಕಿರೋದು? You have filed the application.
Also.
You have not read the papers.
Senior counsel engaged ಮಾಡಿ sir. Held up in Kotal 4 is coming.
Please argue. Let him come. Suit is for injunction.
Suit is for injunction in respect of a non-existing property of which he is not in possession of the same.
Let him argue.
Yes, ma'am.
Yes. Yes, Mr. Starting trouble. ಹೋದ್ರಿ ಪ್ಲೇಂಟ್ ಹೋದ್ರಿ.
Plaintiffs acquired the absolute right title property by virtue of a registered will dated 7/1/2002 minutes. Executed by one Shri Arogyappa, husband of first plaintiff and father of the second plaintiff.
Yes.
And Arogyappa is the absolute right title and the interest for the social property by virtue of a registered sale deed dated 6/1/71. And in the year 1998 and 91 in the name of Srimati Chinnamma Madams. And said Arogyappa expired in the year 21/8/2002, my lords.
Yes.
As per the will dated 7/1/2002.
What is the case of the defendant?
Lord Shima kindly see.
Yes.
The property which.
ಅವ್ರು ಹೇಳ್ತಾರೆ ತಡೀರಿ.
Yes.
This is a first appeal, Mr. Sheshgiri Rao. What is this?
Yes.
Yes, Mr.
Paragraph 8, my lords. Plaintiffs who are his wife and son, it submitted the said Aragyappa expired, leaving behind legates, that is plaintiffs herein succeed and as per the will dated 7/1/2002. In paragraph 11, my lords.
Yes.
Taking advantage of the death of Aragyappa, they started interfering with the peaceful possession and enjoyment of the social property by the plaintiffs. And the plaintiffs submit that the defendants made attempts on 8/10/2002. Paragraph 12, illegal acts of the defendant, the plaintiffs filed a complaint to the jurisdictional Kodaganhalli police station on 9/10/2002 seeking protection from the clutches of the defendants. The cause of action for the suit arose on 8/10/2002, my lords. Paragraph 11.
Yes. Defendant's case ಏನು? What is this, mister? Where is he?
Kotal 4, my lords.
ಯಾರು ನಾರಾಯಣ ಸ್ವಾಮಿನ ಪ್ರಭಾಕರ್?
ಇಲ್ಲ, ವಿಕ್ರಮ್ senior counsel engaged.
Non-counsel for the appellant is not ready and seeks time. List on so and so, subject to payment of cost of rupees
ನಾಳೆಗೆ ಹಾಕ್ಲಿ sir, please. Last
2,000 payable to the association. Yes. Vivek Holla, Vijay Kumar.
Serial number 47 urgent, serial number 48 Vivek Holla.
Vijay Kumar K. Vijay Kumar K. Mr. Vijay Kumar K.
Vijay Kumar K for respondent.
The suit is for injunction.
Yes,
Please argue.
it's in this one. So I'm also requesting for a short.
Whatever it is, 2,000. Non-counsel for the appellant seeks time. List of so and so, subject to payment of cost of rupees 2,000 payable to the association. Serial number 50.
Serial number 49 urgent, serial number 50 Nayak Ramchandra Rama.
But in this case, I'm appealing for the first respondent number 1.
Naik Ramchandra Naik. Serial number 50. There is no representation for the appellant. Even on the last date, time was sought for to address arguments. This, as a last chance, list on so and so, subject to payment of cost of rupees 2,000 payable to the association. Sampath Anand Shetty.
Serial number 51
VV
Sampath Anand
Shivkumar.
Shetty.
My lord, request for the short accommodation.
2,000.
Senior is in other.
Non-counsel for the appellant seeks time. The request for last time ಏನಾಗಿತ್ತು ನೋಡ್ರಿ, last time time ತಗೊಂಡಿದ್ರಾ?
Appellant 6 times.
On the The request for adjournment is not justified as on the last date also, time was sought for by the learned counsel for the appellant. As the last chance list on so and so, subject to payment of cost of 2,000 payable to the association.
Serial number 52,
Vijaya Pramati Das.
Mati Das.
Lordship, I filed NOC wakalat, my lord. Mr. Das has filed his memo of retirement. Also, my lord, advocate for R1 and R2 have filed a memo stating that this be listed with other connected matters, one of which is pending before a DB, my lord. I have a memo along with.
Illi the memo.
My lord, the memo was filed on 6/3/26, my lord.
Now, there's some matter pending before the division bench.
Yes, my lord.
Arising out of the same judgment.
My lord, it pertains to the same trust, my lord.
Same trust, we are not concerned. This is a suit for injunction.
My lord,
We
I
are
think
not concerned
R1
with other suits. Ready, na? ಆಯ್ತಪ್ಪ ಇದನ್ನ ಅಲ್ಲೇ ಕಳಿಸ್ಬೇಕಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಆಗಿದೆ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ? Mister, this is 2008 appeals. 2023, 23, 23, 23. ಅಲ್ಲ ಈ ಅಪೀಲ್ಸ್ ಇದೆಯಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಒಂದೇನೋ ಡಿವಿಷನ್ ಬೆಂಚ್ ಪಾರ್ಟಿಷನ್ ಇದೆ, ಇನ್ನೊಂದು ಸಿಂಗಲ್ ಬೆಂಚ್ ಮುಂದೆ ಪಾರ್ಟಿಷನ್. Can this appeal not be taken up? ಈ ಅಪೀಲ್ ನ ತಗೋಬೋದಾ? ಅಲ್ಲಪ್ಪ ಈ ಅಪೀಲ್ ನ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ತಗೋಬೋದಾ?
There will be subject to outcome of that because the one of the questions is the trust that is formed. They state that it is out of joint family anta because R1 and R2 are uncles of appellant over here, whereas R4, my lord, he is the father of the appellant. It is his joint, it is his self-acquired property, my lord. That's the contention. So comprehensive suit adike irad, my lord, which is why they have also sought it be heard together. This is basically an injunction suit, but others are partition, my lord.
We don't want to argue this matter. But could learn counsel for the appellant and the learn counsel for the respondent submits that there are several appeals which are pending before the division bench of this court, and the 1126 ಇದೇ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ಬೇಕಲ್ವಾ? ಮತ್ತೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂತ ಹೇಳ್ತಿದ್ರೆ ಯಾವ್ದೊಂದು
first one, my lord, partition suit, first one 736/23.
Hence, ಏನ್ ಮಾಡಾಯ್ತು? Which are pending before this court, and therefore prays that this appeal may be taken along with those appeals. A memo dated 6/3/2026 is filed in that regard. View of the above, list this appeal along with RFA 1126/23, 826/23 and 1048/23. ಯಾವತ್ತು ಬೇಕು? ಇಷ್ಟ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಅದೆಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಅದೆಲ್ಲ ಅಪೀಲ್ಸು? ಅಲ್ಲಪ್ಪ ಆ ಮೂರು ಅಪೀಲ್ಸ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
Request for serial number 50. I am sorry, I could not able to.
ಅದಾಗೋಯ್ತಲ್ಲ.
ಇಲ್ಲೇ ಇದ್ದೆ ಪಕ್ಕದಲ್ಲಿ.
ಹೋದ್ರು ಬಾಲರಾಜ್ ಹೋದ್ರಾಗ್ಲೇ. ಬಾಲರಾಜ್ ಬಂದಿದ್ರು.
ಕಾಸ್ಟ್ ಹಾಕಿದೆ.
ಕಾಸ್ಟ್ ಅದೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್.
ಬೆಳಗ್ಗೆಯಿಂದ ಕಾಯ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. You miss the bus, you have to take the ticket for the next bus.
Last may waive the cost.
ಏನ್ ಮಾಡಕ್ಕ? Yes, next ಕಟ್ಟಿ ಬರೋ ಇಲ್ಲ.
53 Murali BS.
Yes. BS Murali.
Appear for the appellant. Kindly pass over, Your Honor.
Yes.
My lords, kindly pass over. My senior
Madam,
colleague is
350, madam.
senior colleague is in Kotal 3. He is on his legs,
Pass
my
over.
lords. Much obliged.
Serial number 54, Rashmi Jadhav.
Rashmi Jadhav. Rashmi Jadhav.
Proxy counsel appear in behalf of Rashmi Jadhav, my lords. A date may be given, my lords. Those are my instructions.
Tomorrow. Tomorrow.
I'll inform them, my lords.
Learned counsel for the appellant seeks time. On the last occasion, on the last day 2, time was sought for by the Land Council for the appellant. Hence list on so and so, subject to payment of cost of rupees 2,000. Payable to the association.
I am proxy counsel, my lords.
So what? 4,000?
No, no.
Then actually you should pay 4,000. You are a proxy counsel.
My lords.
2,000 for you and 2,000 for her. So 4,000.
No, my lords. No, my lords.
ಆಯ್ತು ರೀ ನಾಳೆಗ ಇವತ್ತು ಹೇಳಿದ್ರೆ ನಾಳೆ ಹೇಳ್ರಿ. Mr. GB Manjunath.
Number 55, GB Manjunath.
Vinay Swami Mutturaj. You are Vinay Swami or Mutturaj? Who is Mr. Mutturaj?
Mutturaj is the appear for defend.
Nanneno ಬಂದಿಲ್ಲ ಅವ್ರು ಮುತ್ತುರಾಜ್ ಅಲ್ವೇನ್ರಿ?
ಅವರೇ ಮೂವ್ ಮಾಡಿದ್ರು ಅಂತ ಕಾಣುತ್ತೆ, ನಾನೇನ್ ಮೂವ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ರೆ 2023 ರಾಷ್ಟ್ರ ನನಗೆ ಇರೋದು. Yes, please go on.
Tomorrow.
ಸರ್ 2,000 ರೂಪಾಯಿ ಯಾಕೆ ಕಟ್ತೀರಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಆಯ್ತು ಮಾಡ್ಬಿಡ್ತೀನಿ. ಆಯ್ತು ಓಕೆ
ಹೇಳ್ರಿ.
Plaintiff's appeal, man. Plaintiff's appeal. OS 935 2021 filed for partition and separate possession.
Where is the family tree? Family tree.
Family tree ಹಾಜರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ.
ಆಯ್ತು ಹೇಳಿ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಏನು ಅಂತಾದ್ರು ಹೇಳಿ.
ಅಲ್ಲ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಅಂದ್ರೆ ಇವರು ಒಂದಿ plaintiffs 1, 2, 3 are the children of one Rudrappa and Siddharajam. So far as 1, 2, 3 properties are concerned, the court has granted 1/3 share in respect of item number 1 and 3. So far as in respect of item 2 property, the court has not granted.
Why?
Siddharajamma, this second item property, 5 guntas of land in Edavanalli village has been purchased by Siddharajamma's name from the ancestral income derived from the family property.
Yes.
So the court has come to the conclusion that she was not in possession, and thereafter the landlords of survey number 139 have interfered with the possession, and she filed adverse possession and obtained a decree. Hence it is a self-acquired property. That is what the court says. The property purchased by the Siddharajamma is the income derived from the ancestral property.
Yes.
That property.
Who are the defendants?
Defendants 1 and 2 are the purchasers. 2 is the purchaser of the item number 2 property. That is land, 5 guntas of land.
Siddharajamma's property.
Siddharajamma's property.
Who is defendant number 1?
Defendant number 1 is husband of defendant number 2. Third is the bank manager. The FD was there, and hence notice was issued not to disturb any amount, because nominee was made as defendant number 1 as made as nominee. So far as FD deposits are concerned. So hence we issued notice, and bank has stopped the issuing since it is not matured. Hence the bank did not give the money. Thereafter suit has been filed. The bank divided the amount, FD amount with interest, and paid to the plaintiffs. First property is concerned. This is a 15/20 site that has been allotted 3 shares with the court. So far as second property is concerned, second item of the property is concerned, the court has dismissed the suit. Only in respect of second item, the appeal has
Yes, how will you get this property? How can you claim that this property is acquired out of the funds of the joint family?
Siddharajamma is not having any income, my lord.
But it is adverse possession, alva.
Allala, she was not having any income and it has been purchased. The vendors have started interfering with the property purchased by Siddharajamma. Hence, she has filed a suit for adverse possession and
ಆ
thereafter.
ಸೂಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಹೇಳಿದಾರ? ಆ ಸೂಟ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
ಆ ಸೂಟ್ ಅಲ್ಲಿ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಅದು ಕಾಪಿ.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ಯಾರ ಹತ್ರ ಇರ್ಬೇಕು?
ಸೂಟ್ ಅವರು ಅವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದು.
ಆ ಸೂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಒಂದೇ ಹಾಕಿದ್ದು.
ಮತ್ತೆ you also admit ಇದೆಯಲ್ಲ certified copy of the decree exhibit D1 ಕೊಡ್ರಿ ಇದು. There's some compromise entered into.
Ultimately ended into compromise.
Ultimately it ended in a compromise. Siddharajamma versus Muniappa.
He was the vendor of that second item property in favor of Siddharajamma.
What is there to show that this property was purchased by Siddharajamma? Out of the funds of the joint family, ಈ ಪ್ರಾಪರ್ಟಿನ ಫ್ಯಾಮಿಲಿಯವರು ಸಿದ್ದರಾಜಮ್ಮನ ಹೆಸರಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡೋದು ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನಿದೆ?
Stated in the plaint, my lord. Stated in the
plaint,
but
is your pleading,
she was
sir.
not
What is the
having
proof?
any. She was not having any income, my lord. She is only a housewife.
Sir, Siddharajamma has filed a suit for declaration that she has perfected her title by adverse possession.
Yes.
Correct?
Yes.
Is there anything to show that Siddharajamma has purchased this property from Muniappa? ಮುನಿಯಪ್ಪನಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು plaint 903
plaint
certified copy of the decree. Where's the judgment? Exhibit D1 decree produce ಮಾಡಿದ್ರು, judgment produce ಮಾಡಲಿಲ್ಲ. ನೀವು ಕ್ವಶನ್ ಮಾಡು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೀವು ಕೇಳಲೇ ಇಲ್ಲ ನೀವು ಡಿಗ್ರಿ ಎಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿ ಅಂತ. ಪ್ಲೇಂಟ್ ಕಾಪಿ ಏನಾದರೂ ಇದೆಯಾ OS 903 ನಲ್ಲಿ?
We'll get it, my lord. Your lordship may have it next week, my lord.
Defendant admits the plaintiff is in feasible. ಸಿದ್ದರಾಜಮ್ಮಂಗೆ ಹೆಂಗ್ ಬಂತ ಹೇಳಿ ಇದು ಹೆಂಗ್ ಬಂತಿ ಆಸ್ತಿ?
Siddharajammange, Rudrappa has contributed the money and gave her and obtained
agreement of sale. Was it by way of an agreement of sale or a sale deed?
Through sale deed only is purchased from Muniappa.
Where is the sale deed? Where is the sale deed?
Lordship, I will next week, my lord, I will get it.
Then you have to pay cost, sir. 2,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಕು.
ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ ಇವತ್ತು ಹಿಯರಿಂಗ್.
ಟೈಮ್ ಸೆಕೆಂಡ್ ಟೈಮ್
ಅಲ್ಲ, ಮೀಡಿಯೇಷನ್ ಬೇರೆ ಹೋಗಿತ್ತು, ಅದು ರಿಪೋರ್ಟ್ ಏನಾಯ್ತು, ಏನ್ ಅಪೇರ್ ಆಯ್ತು ಅಂತ ಅದು ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ. ಏನ ಅಪೇರ್ ಆಗಿದ್ರೆ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರು ಅಂತ. ಐ ವಿಲ್ get all the details, my lord, your lordship have it by next week.
All the details are, there are no details only. ಇಲ್ದಿರೋದು ಎಲ್ಲಿಂದ ತರ್ತೀರಾ?
ಅಲ್ಲ ಹಳೆ ಫೈಲ್ಸ್.
2,000 ರೂಪಾಯಿ ಕಟ್ಟಿ ಎಲ್ಲರಿಗೂ ಏನ್ ಹೇಳ್ತಿದ್ರು ನಿಮ್ಗೂ ಅದೇ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
ಅಲ್ಲ ನಾನು ಅರ್ಧ ಮಾಡಿದ್ದೀನಿಲ್ಲ ಈಗ.
ಅರ್ಧ ಮಾಡಿದ್ರೆ 1,000 ರೂಪಾಯಿ ಕಟ್ಟಿ ಹೆಂಗಿದ್ರೆ.
ಅರ್ಧ ಮುಕ್ಕಾಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಸ್ವಲ್ಪ ಅದಿಷ್ಟು ಹಾಜರ್
1,000
ಮಾಡೋದು
ರೂಪಾಯಿ ಕಟ್ಟಿ ಹೆಂಗಿದ್ರೆ.
ಅದಿಷ್ಟು ಹಾಜರ್ ಮಾಡೋದು ಅಷ್ಟೇ ಇದೆ.
ಅವನು Land Council for the applicant seeks time. Since the last chance list, ಯಾವತ್ತು?
Thursday, next Thursday.
Thursday is a holiday.
Friday.
26 subject to payment of cost of rupees 2,000 payable to the association.
Which association?
Advocates, ನಮ್ಮ ಹೈಕೋರ್ಟ್.
High Court Advocates Association. ಅಲ್ಲಿ ಇದು 20 ಈಗ ನಾವು 11 ಇಸ್ವಿ RFA ನಾವು ಕಾಯ್ತಾ ಇದ್ದೀವಿ ರೀಚ್ ಆಗ್ತಾ ಇದೆ. 23ನೇ ಇಸ್ವಿ ಮ್ಯಾಟರ್. ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ನಮ್ಗೆ ತುಂಬಾ ತೊಂದರೆ ಆಗ್ತದೆ.
ನನಗೇನು
ಯಾಕೆ ಅಂದ್ರೆ
ನೋಡಿ, ಇಷ್ಟು ಕೇಸು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಯಾರಾದ್ರೂ ಒಬ್ಬರಾದ್ರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ತಾನೆ. So many cases are listed for final hearing. At least one lawyer should argue. At least one lawyer. 4:15 ತನಕ 4:45 ತನಕ ಆಕ್ಯುಪೈ ಮಾಡ್ಬೇಕಲ್ವಾ? ಇನ್ನು ನನಗೇನ್ ಬೇರೆ ದಾರಿ ಇದೆ? I don't have any other means. Either I have to dismiss the appeal for non-prosecution or I have to force you to argue. Force ಮಾಡೋದು ಹೆಂಗೆ?
ಅಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ. ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು ಬೇರೆ ಇವತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕೋದು ಒಪ್ಕೊಂತೀನಿ.
I will not get any vicarious pleasure by imposing cost. I only want lawyers to argue the matter. ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ಈ ಜಡ್ಜು ಟೈಮ್ ಕೊಡೋದಿಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ರೂ ಮಾಡೋಣ ಅಂತ ಮಾಡ್ತೀರಾ ಅಂತ ದೃಷ್ಟಿಯಿಂದ ಕಾಸ್ಟ್ ಹಾಕ್ತಿರೋದು.
ಅದೇ ಶುರು ಮಾಡಿದ್ವಿ. ಸ್ವಲ್ಪ ಪೇಪರ್ಸ್ ಇಲ್ಲ, ಇದು ಮೀಡಿಯೇಷನ್ ಹೋಗಿತ್ತು ಪೇಪರ್ಸ್, ಕೆಲವು ಪೇಪರ್ಸ್ ಎಲ್ಲ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಲಾಯರ್ ಹತ್ರ ಇದೆ. ಹಂಗಾಗಿ ನನಗೆ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಆಗಿದೆ. ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಾನು ಮಾಡ್ಬಿಡ್ತಿದ್ದೆ. ನಾನ್ ಶುರು ಮಾಡಿದ್ ನೀವು ಸುಮ್ನಾಗಿದ್ದೀರ ಅಷ್ಟೇ. ನಾನ್ ಶುರು ಮಾಡಿದ್ರೆ ನೀವು ಸುಮ್ನಾದ್ರಿ. ಅಲ್ಲಲ್ಲ, ನನಗೇನಂದ್ರೆ ಮೀಡಿಯೇಷನ್ ಒಂದು ವಿಷಯ, ಮೀಡಿಯೇಷನ್ಗೆ ಪೇಪರ್ಸ್ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಲಾಯರ್ ಎಲ್ಲ ತಗೊಂಡೋಗಿದ್ರು ಅದೆಲ್ಲ. ಹಂಗಾಗಿ ನನಗೆ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಆಯ್ತು. ಸಡನ್ ಆಗಿ ಇದು ಪೋಸ್ಟ್ ಆಯ್ತು. ಅದಕ್ಕೆ ಒಂದ್ ವಾರ ಟೈಮ್ ಕೇಳ್ತಿದ್ದೀನಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನಾನು ಮಾಡೇ ಬಿಡ್ತೀನಿ. ನಾನು ಟೈಮೇ ತಗೊಳಲ್ಲ. ನಾನು
ನೀವ್ ಮಾಡಿ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನೋಡೋಣ. ಅಲ್ಲಿವರೆಗೆ ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಡಿ, ನೋಡೋಣ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕಾಸ್ಟ್ ಬೇಯು.
ಆಯ್ತು.
ಎಸ್
56 ಅರ್ಜನ್ serial number 57 ಚಂದ್ರಶೇಖರ್ ಸಿ.
ಹಿಂಗೆ ಕುತ್ಕೊಳ್ಳಿ, ನೋಡಿ ಎಷ್ಟು ಕೇಸ್ ಕರಿತೀವಿ, ಎಷ್ಟು ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ ಅಂತ ನೀವೇ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ ಬಂದು
ನಾವು 10, 11, 12 ವಾರಗಟ್ಲೆ ಕಾಯ್ತಾ ಇದೀವಿ. ಎಷ್ಟು ದಿವಸದಿಂದ ಕಾಯ್ತಾ ಇದೀವಿ? 12, 13 ರೀಚ್ ಆಗೋದಿಲ್ಲ.
ರೀಚ್ ಆಗ್ತಿದ್ದಲ್ಲ ಮಾಡಿ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದು. ಹಂಗಾಗಿ ಇದು ಮೀಡಿಯೇಷನ್ ಹೋಗಿದ್ರಿಂದ ಇದು ಮೀಡಿಯೇಷನ್ ಹೋಗಿದ್ರಿಂದ ಪೇಪರ್ಸ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲದೆ ಇದ್ರಿಂದ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್ ನಾವು
ರೀಚ್ ಆಗೋ ಕೇಸಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ. ರೀಚ್ ಆಗದಿರೋ ಕೇಸಲ್ಲಿ ನಾನು ರೆಡಿ.
ಇದರಲ್ಲಿ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಆಗಿರೋದು ಮೀಡಿಯೇಷನ್ ಕಳಿಸಿದ್ರಿಂದ ನಾನು ಪೇಪರ್ಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಲಾಯರ್ ತಗೊಂಬ ಅಂತ ಹೇಳಿದ್ರೆ ತಂದಿಲ್ಲ ಅವರು. ಅದಕ್ಕೆ ಟೈಮ್ ಕೇಳಿದೆ ಅಷ್ಟೇ, ಮತ್ತೆ ಯಾವ್ದಕ್ಕಿಲ್ಲ. ನಾನು ಟೈಮ್ ಕೇಳ್ತೀನಿ.
ಚಂದ್ರಶೇಖರ್ ಸಿ.
Ready please. Suit is for partition. The last ವಾರ ಬಂದಿತ್ತು, ತಾವು ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತಾ?
ಹೇಳಿ
ಪ್ಲೀಸ್ my lord. Suit is for partition. Filed by respondent number 1 to 4. One Anjanappa, please my lord, who is the father of plaintiff and defendant number 2 and 3. ಅಂಜಿನಪ್ಪ ಅವ್ರಿಗೆ ಮೊದಲನೇ ಹೆಂಡತಿ ಜೈರಂಗಮ್ಮ ಅಂತ ಸ್ವಾಮಿ. ಜೈರಂಗಮ್ಮ ಅವ್ರ ಮಕ್ಕಳೇ ಪ್ಲೈಂಟಿಫ್. Suit schedule property is originally purchased by Jairangamma in the year 1971 by way of release deed. Thereafter, my lord, she dies in the year 1991. After that, my lord, Anjanappa married defendant number 1 Gangamma, and defendant number 2 and 3 are the children of second wife. Lord, wherein in the year 2015, please, 11, please, my lord, the Anjanappa executed a gift deed in favor of defendant number 1 and 2. Lord, without with respect to suit schedule property, without challenging the gift deed, and though it is well within the knowledge of plaintiff, Lord, they.
How can Anjanappa execute a gift deed?
Lord, after the death of Jairangamma, Kata was transferred to the name of Anjanappa, please.
He had only one six share.
Before that, I agree, please, but Jairangamma ಯಾವುದು individual income ಇರಲಿಲ್ಲ. to purchase the property.
Yeah.
The second thing, please, my lord, he availed a loan to construct that property. ಈಗ 2 floor building ಇದೆ. At the time of purchase, it was vacant land. It is constructed by Anjanappa. Lord, Anjanappa was working as a government employee. ಅವ್ರು construct ಮಾಡಿದ್ದಾರೆ. More than please, my lord, plaintiff says, my lord, plaintiffs and defendants are joint family members.
ಆಯ್ತು, ಆಂಜಿನಪ್ಪ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅನ್ಕೊಂಡ್ರು ಕೂಡ,
Please, my lord.
this property belongs to Jairanga Nayakamma. What about the building, mister? Building.
Building is being out of there, the other children, the other children have taken loan and have put up construction.
What is there to show that the other children have taken loan?
I will produce documents, but here,
Mister, have you produced any documents to show that you have raised a loan?
not here.
Huh? What do you mean I have to check?
One more code.
But my only submission is, ಆಯ್ತು ಶೇರ್ ತಗೊಂಡ್ಲಿ, ಫಾದರ್ ಶೇರ್ನ ಇವ್ರು ಕೊಟ್ರು ಆಗುತ್ತೆ. That is my only request.
For the property, he has right of only 160 share. How would he execute the gift deed if he was the entire property?
Oh, that's okay, but what about the building? In the building, if Anjanappa has constructed the building belongs to him.
We had on Monday also. We will clarify.
ಇನ್ನ 4 ಗಂಟೆ 8 ನಿಮಿಷ.
He's outside. He'll jump in.
Can't help it, mister. But to pay cost. What applies to everybody applies to you.
Last day it was for settlement.
You did, now you say there's no settlement.
The appellant has argued, respondent, I give my response next week. Monday, do it.
One counsel for the respondent seeks time. Since this appeal was, mediation fail, I thought. Since this appeal was heard in part and listed today, to explore a settlement. This appeal was heard on the last date. And it was listed today to find out whether the parties are willing for an amicable settlement. The learned counsel for the response 1 to 4 submits that there is no settlement. Full stop. He, however, seeks time to address further arguments. The request is not justified as the matter is already heard. Hence, list on 26th. Monday parala. Subject to payment of cost of rupees 2000. ನಾಳೆ ಹಂಗ ಆಗಲ್ಲ. ನಾಳೆ ಮಾಡ್ತೀರಾ? ನಾಳೆ ಲಿಸ್ಟ್ ಟುಮಾರೋ. ನಾಳೆ ಕಾಸ್ಟ್ ಬೇಡ.
Serial number 58, Jagdish S. Patil. Jagdish S. Patil.
He has paid the court fee. He has the right of first audience. Let him argue first.
The suit for recovery of money, my lord, and this appeal is filed by the defendant in this case, Your Honor. The appellant has engaged interior work for the respondent and is entrusted the work for interior work, my lord, kitchen and 2-bedroom, Your Honor. Whatever the quotation, whatever the amount he has, work he has did by his respondent, I paid the 10 lakh rupees, 10 lakh at 25,000 euro. What the respondent claims, he did extra work in my house, my lord. Extra work ಏನು ಮಾಡಿಲ್ಲ. Extra work is comes under.
Let us see what was the work that was entrusted to the plaintiff first.
Yes, my lord.
And what was the extra work that he has performed? For the extra work, what was the price agreed?
Yes.
ತೋರಿಸಿ.
ಅಲ್ಲ ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಏನ್ ಮಾಡಿದ್ರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕಾಗತ್ತೆ. He has to explain.
Let us see what he has mentioned in the plaint. ಕೊಡ್ರಿ plaint.
ಅವ್ರ ಪ್ರಿಂಟ್ ಅಲ್ಲಿ ಅವರ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಚೀಫ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಡನ್ ಬೈ ದಿ ಪ್ರಿಂಟಿಫ್, ಓನ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಡನ್ ಬೈ ದಿ ಪ್ರಿಂಟಿಫ್ ಏನಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. Judgment and decree.
ಎಲ್ಲಿದೆ ಟೋಟಲ್ ಬಿಲ್ ಎಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡೋದು ಎಲ್ಲಿದೆ? See, he says that the official quotation was handed over to the defendant for an amount of 12,02,000.
Yes, madam.
A quotation is exhibit, where is that document?
P1, madam.
P1.
Quotation is given by the plaintiff, my lord. The work quotation is only for ಇಷ್ಟು ವರ್ಕ್ ಆಗದಂತ ಆಗುತ್ತೆ. ಅದು ಜಾಸ್ತಿನೇ ಆಗ್ಬೋದು, ಕಮ್ಮಿನೂ ಆಗ್ಬೋದು. ವರ್ಕ್ ವಾಟ್ ಇಟ್ ಡಿಡ್ ಇವರನ್ನ ಆ ಕೊಟೇಶನ್ ಪ್ರಕಾರ ಮೈ ವರ್ಕ್ ವಾಸ್ ಕಂಪ್ಲೀಟೆಡ್ 10 lakhs rupees and 10,25,000 ಇವರನ್ನ ಅಷ್ಟು ವರ್ಕ್ ಮಾಡಿದ್ದಾರೆ, ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದೇನೆ. ಅವರು ಏನು ವಾಟ್ ಈಸ್ ಎಡಿಷನಲ್ ವರ್ಕ್ ಏನ್ ಮಾಡಿದ್ರೆ ಅಂತ ಇಸ್ ನಾಟ್ ಕ್ಲಿಯರ್. ಈಸ್ ಓನ್ಲಿ ಸಿಂಪ್ಲಿ ಕ್ಲೇಮಿಂಗ್ ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಐ ಡಿಡ್, ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಬಟ್ ಎಲ್ಲ all exhibit document, my lord, only I referred only the items, my lord. No disputes arise, only the question of extra work, your honor.
So let us see the invoices.
Yes, my lord.
Let us see the invoices.
Invoice dated, my lord, 19/1/2016, and second invoice dated is 21/1/2016, my lord. ಟೋಟಲ್ ಬಂದಿರೋದು 11,32,628, my lord. ಅದರಲ್ಲಿ ಡಿಸ್ಕೌಂಟ್ ಹೋಗಿ 10,50,000 ಆಗಿದೆ. And lower court, my lord, The defendant is not reduced any evidence, Your Honor.
The total invoice material supplied is 13,76,519. 13,76,519. You say 13 lakhs 97,000. How is that 97?
So here, the total quotation was about 12 lakhs, 2,200. The extra additional cost that was taken up was 1,94,879. That is how this 13,97,000.
No, the invoices that you have produced, the total sum is 13,76,519. The value of all the invoices. Yes, Mr. Signatures yardidu invoices melirodu. Signatures on the invoice. Whom does it belong to?
The mode of communication, one was the invoice and one was to the mail.
No, there are some signatures acknowledging the receipt of this material on the invoices. Who has signed these invoices? Received this material, kitchen material, Surya Balu.
Their worker, my lord.
Huh?
Our worker. ಅವರೇ ಮಟೀರಿಯಲ್ ಕಳಿಸೋದು ಅಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಒಬ್ಬರು ಇರ್ತಾನೆ ಅವನೇ ರಿಸೀವ್ ಮಾಡ್ಬಿಟ್ಟು ವಿಲ್ ರಿಸೀವ್ ದ ಮಟೀರಿಯಲ್.
In the workplace, the person who is working there only is receiving the and acknowledging that.
Kalyan Builders and Developers. Who is this Kalyan Builders Developers?
The appellant, my lord.
Appellant.
Appellant. He is also running developer. He is also developer. He is also builder, Your Honor.
Yes. Want to settle it or you want to contest?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ, ಡಿಗ್ರಿ ಆಗಿದೆ. ಐ ಟು ಒಬ್ಲೈಸ್ ದಿ ಕೋರ್ಟ್ ಆರ್ಡರ್. ಐ ಆಮ್ ರೆಡಿ ಫಾರ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಲ್ಸೋ. ಡಿಗ್ರಿ ಆಗಿದ್ದಕ್ಕೋಸ್ಕರ ನಂದು ಎಕ್ಸ್ಟ್ರಾ ವರ್ಕ್ ಆಗಿದೆ ಅಂತ ಹಂಗಲ್ಲ.
ಆಯ್ತು, ಎಷ್ಟು ಕುತ್ಕೊಂಡು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಅದು ಕುತ್ಕೊಂಡು ನಾ ರೆಡಿ ಇದ್ರೆ ಈಸ್ ವೆರಿ ರೆಸ್ಪಾನ್ಸ್ ವೆರಿ adamant, Your Honor. He is asking decreasing amount and plus interest. He is not ready to give single paisa.
Why would he? ಆಯ್ತು, ಪ್ರಿನ್ಸಿಪಲ್ ತಂದು ಕೊಡ್ತೀರಾ? Will you get the principal amount?
ಪ್ರಿನ್ಸಿಪಲ್ ಅಂದ್ರೆ ಅದು 3,75,000 ಆಗುತ್ತೆ. ಬಟ್ ವರ್ಕ್ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ನಂದು ಎವಿಡೆನ್ಸಸ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿ ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಬೇಡಿ ಅಂತ ಯಾರು ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಿ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿಲ್ಲ. I filed application before the lower court, my lord, and I recall the recall application. Same day it was recall, and the same day I have cross examination to the plaintiff, my lord, and immediately the same day the case was posted for the judgment, my lord.
Why you did not lead evidence on the same day?
ಇಲ್ಲ ಅವತ್ತೇ ಕ್ರಾಸ್ ಮಾಡಿದ್ರು.
ನೀವ್ ಯಾಕೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ?
ಅಲ್ಲ ರೆಡಿನೇ ಇದ್ವಲ್ಲ ನಾವು, ರೆಡಿ ಇದ್ವಿ. ಒಂದು ಅಪಾರ್ಚುನಿಟಿ ಒಂದು ಸ್ಟೇಜ್ ಅವತ್ತೇ ಕೊಟ್ಟಿದ್ರು. ಕ್ರಾಸ್ ಮಾಡಕಂತ ಹೇಳಿ ಕ್ರಾಸ್ ಮಾಡಿದ್ವಿ. ಇಮಿಡಿಯೇಟ್ಲಿ ದಿ lower court adjourned the matter for judgment, my lord. Application is clean mention ಮಾಡಿದ್ವಿ. Reopen and recall, my lord. Reopen ಅಂದ್ರೆ the entire stage come in the for the trial, my lord. I'll see I'll read the order sheet also, my lord. Wait one second. I complete one. On 3/2/24, my lord, I filed a application I number 7 and 8 for reopen and recall of PW1 for cross examination, my lord. The reason assigned in the affidavit annexed to be application stand satisfied accordingly I number 7 and 8 hereby allowed. PW1 present and fully cross examination, my lord. Counsel for the plaintiff submit no further evidence, my lord. Heard argument on side of the plaintiff and defendant. directly for the judgment, my lord. At least one opportunity, one opportunity, one stage evidence.
Yes, is there any mail like, regarding the extra work that you have done?
Akshay, my humble submission is, whatever the material has gone through his invoices has been acknowledged by the applicant. He himself has put the signatures on that.
Illide.
Only signature.
Illide. Invoice mela.
Invoices mela.
That is not his signature.
No, he has signed those signatures.
No. No, it's something called Balu. Surya Balu. It's not his signature.
For Kalyan Builders, they have received. There is a seal there. Surya Balu has received for Kalyan Builders. That seal, round seal is there. That is for Kalyan Builders. So the applicant party is already have received.
I think, please total up these amounts. Let us see how much will it come.
Here the issue is what the quotation is for about 12 lakhs to 2,000 some change. Then the deviations have taken place after going there to work.
That's okay. Whatever material that you have supplied, as per the invoices, along with tax, you please total up and let us know what is the total amount.
Yes, sir.
You total it up. Annexure P3 is 80,150. Annexure P is 80,150.
Lakhs 76.
Plus
13 lakhs 76,000.
ಮತ್ತೆ 97,000 ಹೆಂಗ್ ಬರುತ್ತೆ?
13 lakhs 76,590 rupees.
Correct, but in the plaintiff you mentioned it as 13 lakh 97,000. How did you get that figure?
Extra work does not be billed. That is why the
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ? What is there for that?
13 lakhs 76,000 rupees.
But what about 10% discount for that? You offered in the mail that you will get 10% discount.
10% discount.
No, it doesn't say so. Discount should be shown in the invoice.
My humble submission, Lordship. This would have been settled on the very same day, sir. He has dragged his matter for almost 9 days. Now still he is going on. It is not that the person does not have money also. He is a very big builder, having a lot of things. This is a small portion of this property where he has developed a little bit of designing and all these things, which he wanted to deviate. After the completion of the work, he says, no, I'm not interested. That is where all the dispute arises.
My lord, after completion work, I paid whatever work done by the discordant. I paid, my lord. 10 lakh, 25 lakhs I paid. Now, another ಚೀಟ್ ಮಾಡೋ ಇದ್ರೆ ಏನೋ ಒಂದು 10 ಏನೋ 50 5 ಲಕ್ಷ ಕೊಟ್ಟರೆ 4 ಲಕ್ಷ ಕೊಟ್ಟು ಮಾಡ್ಬೋದಾಗಿತ್ತಲ್ಲ. ಐ ಪೇಡ್ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಮಾಡಿ 10,25,000. As per my requirement, I paid my lord. As per requirement, I paid.
How much have you paid?
10,25,000 my lord.
10 lakh?
10,25,000. 10 ಲಕ್ಷ 25,000.
What was the quotation actually? 12 lakhs ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ಸರ್ ಅಲ್ಲಿ ಏನದು ವರ್ಕ್ ಅಷ್ಟೇ ಮುಗಿತದ.
ಆಯ್ತು ರೀ, ವರ್ಕ್ ಅಷ್ಟೇ ಮುಗೀತು ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ how did you come to the conclusion that it is 10 lakhs? On what basis?
Discussion between the plaintiff and appellant and respondent my lord. Discussion between the plaintiff and appellant, they have come to
ಏನಿದೆ
the
ಡಿಸ್ಕಷನ್
conclusion.
ತೋರ್ಸಿ, ಏನಿದೆ?
Yes my lord.
That is usually the builder's language.
ಅಲ್ಲ, you are also architect, you are also one type of builder, I am also builder. That is not a disputed one. No, personally you cannot.
We are adopting everything on through image, buildings.
ಸರ್ ನಾವು ಕೆಲಸ ಮಾಡಿದವ್ರಿಗೆ ಇವನ್ ಐ ವರ್ಕ್ ಆಸ್ ಎ ಬಿಲ್ಡರ್ my lord, ಯಾರು ಕೆಲಸ ಮಾಡ್ತಾ ನಾವು ಕೊಟ್ಟೆ ಕೊಡ್ತೀವಿ. ₹1 ಯಾವತ್ತು ನಮ್ ಡ್ಯೂ ಯಾವುದು ನಮ್ ಉಳಿಸ್ಕೊಂಡೆ.
ಇದೆಲ್ಲ ಸುಮ್ನೆ ಬಣ್ಣದ ಮಾತು ಯಾಕ್ರಿ ಆಡ್ತೀರ? ಏನಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ? ಏನ್ ಕೇಸ್ ನಾನು ಹಂಗಿದೆ, ನಾನು ಹಿಂಗಿದೆ, ನಾನು ಬೆಳೆದಿದ್ದೀನಿ. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್ ಮಿಸ್ಟರ್? ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ ಬೇಸ್ಡ್ ಆನ್ ದ ರೆಕಾರ್ಡ್. You might like your client. Don't glorify your client before the court. ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಇಂದ್ರ ಚಂದ್ರ ದೇವೇಂದ್ರ ಅದು ನಿಮಗೆ, ಕೋರ್ಟ್ಗಲ್ಲ. ನಿಮಗೆ ಇಂದ್ರ ಚಂದ್ರ ದೇವೇಂದ್ರ, you go, you worship, you pray before him, you kneel before him, you do whatever you want before your client. You are arguing a matter before the court. ಕೇಸ್ ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ.
And second thing is my lord, the lower court has passed the judgment and decree. Even the legal notice also mandatory my lord in this case. Legal notice were not marked. Not before the not produced before the lower court my lord.
Any mediation attempts has been done in this case. Filing in the lower court itself.
Yes.
Here also we told that we are ready. You give us a price.
See, there is some in the mail itself. You have admitted that there is a delay in execution of the contract.
Delay in execution of the contract is because of the deviations.
Not of the deviations. You say in the mail that some other vendors were doing some work in the site.
No, some other vendors were doing, because of that some delay is there. That we admitted. But what happened was, that is not hindered anything, any of the programs.
He says that I got the painting was already over. You people came late and damaged the painting. You spoiled the painting. That is the allegation.
That's only the allegation.
It's an allegation.
We have not used any evidence towards that part also. Nor any photograph they have produced. What is
So it is all common sense.
Yes.
It's all common sense. You have been engaged not only for the kitchen work, for also some wardrobe work also. So when you enter the wardrobe, your people or your laborers enter the wardrobe, they will also spoil, touch ಮಾಡ್ತಾರೆ, ಮುಟ್ತಾರೆ, ಏನೋ ಮಾಡ್ತಾರೆ, ಹಾಳು ಮಾಡ್ತಾರೆ. So therefore we do not know.
Paging of wardrobe definitely you have to touch the wall.
You have to touch the wall. He says that I got the walls painted. You came late.
It is very
So
simple.
therefore come up with some via media settlement.
No, here is something. Now,
ಎಷ್ಟು?
ಸುಮಾರು ಸತಿ ನಾವು ಕೂತಿದ್ದೀವಿ.
Pay 2 lakhs. Pay 2 lakhs and close it. 2 lakhs. Pay 2 lakhs and close the issue. No interest, nothing. We do not know who is at fault. Otherwise, we'll have to restore the suit and let the case go on for another few years. Or you want to buy peace, take 2 lakhs and close it.
Lordship, at least 2.5 lakhs.
Close it at 2 lakhs, mister. 2 lakhs.
Almost 9 years, 9 ವರ್ಷ ಆಗಿದೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಅದಕ್ಕೆ ಹೇಳಿದ್ನಲ್ಲ, we do not know who is at fault. In the mail, you admit that there's a delay on your part. In the mail, there's a mention that there's a delay on your part.
We have been very clean before the court. What is there we are telling. We are not telling that we have not done anything of that. But this is the amount that has been paid to us.
No, he says you delayed it.
His program has been fixed. He has done it. Gone to the. We have already put up the water. Then he goes for painting. Then he wants to change
No,
it.
no, no sensible man will, no sensible man will get the house painted
Then go for the
before the wardrobe is done.
That is what was.
So therefore, if this man has got the walls painted and you delayed it,
No, my humble service. Wardrobe has been done before. Then the change of design has come. That is where that is where the paint would have been in.
course, Yavaganta, what is the date of the quotation? 2016.
Yes.
When were the supplies made?
From 2016 onwards, it's been 2nd April,
Nodi.
8th March.
Quotation is January. The supplies were made
after
on February 2016. Then March 2016. March 2016, April 2016, May 2016. So from January to May, you've taken 5 months.
Lakshya, my humble submission, we have already finished our program. After that, they want some deviation. Then we go in again for the deviation. Then they said, no, the program is very much necessary. We have to finish it in so much of time. We try to finish that also.
Yes.
Then he makes an allegation, no, he's totally in the circle. That is where the problem took place. Our everything is built. All the material is being acknowledged by them. Like so much of material has come to the premises. ಸ್ವಲ್ಪ consideration ಮಾಡಿಕೊಳ್ಳಿ. 2 ಲಕ್ಷ ತುಂಬಾ ಕಡಿಮೆ ಆಗುತ್ತೆ.
8 months delay ಇದೆ my lord, 8 months delay ಇದೆ ಸರ್.
ಅಲ್ಲ 3 ಲಕ್ಷ sorry, as on today, even if it is capital at 6%.
Tomorrow, find out 2.5 lakhs.
To whatever the honorable court has first suggested.
2.5 lakhs.
ಅಲ್ಲ
Just ಅಲ್ಲ 9 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
9 ವರ್ಷ ಇರ್ಲಿ ಅಲ್ಲ ಈಗ
tomorrow
ಇದೇ ಮಾಡೋಣ.
To explore a settlement, list tomorrow. Bring 2.5 lakhs tomorrow and close it.
ಸ್ವಲ್ಪ reduce ಮಾಡಿ. ನಾ ಹೇಳ್ತೀನಿ tomorrow I'll come.
ಏನ್ reduce ಬೇಡ.
Tomorrow I'll bring.
Invoices
I'll bring.
3,73,000 ಇನ್ವಾಯ್ಸ್ ಇದೆ. ಅದೆಲ್ಲ ಅಕ್ನಾಲೇಜ್ ಮಾಡಿದ್ದೀರಾ? You acknowledge the receipt.
Yes, madam.
So ಇನ್ವಾಯ್ಸ್ ವ್ಯಾಲ್ಯೂ ಆದ್ರೂ ಕೊಡ್ಬೇಕು ತಾನೆ? ಇನ್ವಾಯ್ಸ್ ವ್ಯಾಲ್ಯೂ ಆದ್ರೂ ಕೊಡ್ಬೇಕಾ?
Tomorrow, Monday.
No, tomorrow.
Arrange money.
ನಾಳೆ ಬಂದು ಹೇಳ್ರಿ. ನಾಳೆ ಚೆಕ್ ತಗೊಂಡ್ಬರ್ಬೇಕು, ಬರೀ ಬಾಯ್ ಮಾತು ಹೇಳ್ಬೇಡಿ. Come with a check.
Appellant is out of session, madam. At least appellant is out of session.
Ask him to come. List tomorrow. No,
Delhi, 2 days at least, madam.
ಇಲ್ಲ ಸರ್, Monday is not RFA day ಅಲ್ಲ. Monday is all criminal day. So
I'll make him to convince my lord.
Convince him, bring a check tomorrow. Yes, list tomorrow. Tomorrow.
No, my lord, one Monday, my lord.
ನಾಳೆ ತಿಳ್ಕೊಂಬನ್ನಿ. Yes, next.
59, Somsekhar KM.
KM Somsekhar.
In this matter, my lord, Government Senior Counsel has been engaged.
How much? 2,000?
ಅಲ್ಲ, ನನಗೆ ಹುಷಾರಿಲ್ಲ ನಿನ್ನೆಯಿಂದ, ಅದಕ್ಕೆ I will not.
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. 4:30 ತನಕ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರೆ ಏನು ಹುಷಾರಿಲ್ಲ, ಮನೆಗೆ ಹೋಗ್ಬೇಕಾಯ್ತು.
ಆದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿಲ್ಲ, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಅಂತ.
Everybody has got a reason, mister. Everybody wants time. Everybody wants adjournment.
I don't want time, my lord. ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ರೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಪಾರ್ಟಿ ಎಂಗೇಜ್ ಮಾಡಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅನ್ನು ಅಡ್ಮಿಟ್ ಆಗಿ.
Take whatever time you want, but pay cost. ನಿಮ್ಮ association ಗೆ. Marco learn counsel for the appellant seeks time. The last chance list on 26th. Subject to payment of cost of rupees 2,000. Senior counsel 2,000 ಕಡಿಮೆ ಕೊಡಿ.
Serial number 60, Rajshekhar Siri.
Rajshekar Siri. Mr. Rajshekar Siri. There is no representation for the appellant and the respondent. List on so.
My lord, I appear for the respondent number 3, my lords, in this.
Vincent.
Yes, my lords.
You appear for Ms. Vincent or Manu?
No, Manu came, my lords.
There is no representation for the respondent 1 and 2. And the appellant list on so and so.
53.
Yes. In your password. ಕರೀರಿ ಯಾವ್ದು ಬಂದಿದಾರ ಮತ್ತೆ ಇನ್ನೊಂದು ಯಾವ್ದು ಒಂದು ಇದು 53 ಕರೀರಿ ಪಾಸ್ವರ್ಡ್.
Number 53.
ಅಲ್ಲ ಮುರಳಿ ಬೆಳಿಗ್ಗೆಯಿಂದ ಮಧ್ಯಾಹ್ನದಿಂದ ಒಬ್ಬರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಮಧ್ಯಾಹ್ನ ನಾನು ಇದ್ದೆ ಅಲ್ಲಿ ಕೋಟಾ ನಂಬರ್ 3 ನಲ್ಲಿ ಅಲ್ಲೊಂದು ಫೈನಲ್
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ ರೀ, ಒಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ನಾಟ್ ಇವನ್ ಒನ್ ಲಾಯರ್. ಏನಿದು ಸೂಟ್ ಏನಿದು?
Suit for declaration and injunction. My lord, this is defendant's first appeal. My lord. Suit is decreed by the trial court and holding that the plaintiff is entitled for the relief that and he is declared as the owner of the suit.
Declaration ಇದು.
ಹೌದು. Declaration and permanent injunction. Lord, suit is declared.
ಏನ್ ಕೇಸ್ ಇದು?
Lord, suit land, my lord, is an service enam land granted to the family of original defendants number 1 and 2.
Granted to the family of?
Original defendants number 1 and 2. Lingamma Matta Ramakrishna Murthy and another group, my lord.
It is granted.
It was granted.
By
the then Amaldar, my lord. In the year 1982, my lord, it was granted.
Under what act?
Service enams, my lord. KVOA Act, my lord.
KVOA.
Village officers.
Village officers.
Please, my lord.
Sorry. Is defendant number 3 yaru?
Defendant number 3, my lord, is a legatee under the will executed by Srimati Lingamma insofar as her 1/3 share is concerned out of the suitural property to an extent of 11 guntas.
Defendant number 1, defendant number 2 ಸಂಬಂಧ ಇದೆಯಾ?
Defendant number 2 and defendant number 3 ಏನು ಸಂಬಂಧ ಇಲ್ಲ. ಸಂಬಂಧ ಇಲ್ಲ. He is
defendant 1 and 2.
1 and 2 they are related.
How?
I will explain, my lord. Kindly take the paper book, my lord, or the written statements, my lord, this file, my lord. Lords may kindly turn to running page number 18, my lord, in the written statements.
ಈ book ಅಲ್ಲ?
ಆ book ಅಲ್ಲಿ first volume number 1 ನಲ್ಲಿ G3 ಅಂತ ಇದೆ. Internal page 6, my lord, of the written statements.
Yes.
Lord Venkataramanappa, my lord, was the original propositor. He had 3 children, Lord KV Venkatrayappa, Sanjivaya and Venkatagiriyappa. Lord, defendant number 2, Ramakrishna Murthy, Lord, is the son of the second son, Sanjivaya. Defendant number 1, Srimati Lingamma, is the wife of the third son, Venkatagiriyappa.
Yes.
Lord, the first son, Lord KV Venkatrayappa, since deceased, my lord, is represented by the children, that is 1, 2, 3 and 4, that is Venkatramappa, Narayan Rao, Hanumant Rao and Ramayana.
They are not parties here?
They are not parties to the suit. They have not made them as parties to the suit. Or the document, my lord, with which both of us are relying upon is the...
Those are my vendors, my lord.
Please wait. Yes.
Yes.
Both of us, my lord, are relying upon the very same document. My lords may kindly take, my lord, the exhibit P1, my lord, marked by the other side.
I plaint ಹೇಳಿ plaint ನನಗಿನ್ನ ಗೊತ್ತಾಗಿಲ್ಲ ಅದೇನು ಕೇಸ್ ಏನು ಅಂತ ಹೇಳ್ಬೇಕು.
Please. My lord, there were 4 survey numbers, my lord, in the said regrant order. All the 3 groups, my lord, what I say, KV Venkatrayappa, Sanjeevaya and Venkatgiriyappa. But it is admitted, my lord, they had 1/3 share each in all the 4 lands. Lord, such being the case, my lord, this group, my lord, the vendors of the plaintiff, they sell the suit scheduled property without our knowledge and without our consent. That was in the year 1998. Lord, we came to know about that, and when he sought to change the khata, Lord, we objected there, and the Tashildar, after hearing both the parties, passed an order that since originally, Lord, it was 1/3 share to all the 3 groups, Lord, the plaintiffs' vendors, they could not have sold the entire land measuring 32 guntas in favor of the plaintiff. So, my lord, the original order was confirmed. That is, the request made by the plaintiff, my lord, for change of kata was rejected. My lord, he preferred an appeal before the Assistant Commissioner under section 136(2). Lord, that was allowed by the Assistant Commissioner. Lord, then we preferred, my lord, 136(3) revision petition before the Deputy Commissioner, which was confirmed by the Deputy Commissioner. Against which, my lord, we preferred writ petition before this honorable court, and there was an interim order of stay granted by this honorable court. Finally, my lord, after hearing both the parties, writ petition was allowed, and then, my lord, the order of the Assistant Commissioner and the Deputy Commissioner was set aside, restoring, my lord, the order of the Tashildar, which was in conformity, my lord, with the original order of the year 1982, regranting and allotting 1/3 share to each 3 groups. Lord, while disposing of the writ petition, my lord, and on the request, my lord, a observation was made by this honorable court that the plaintiff, my lord, is entitled to exhaust civil remedy if he is so advised. On that basis, my lord, he first prefers a writ appeal before this honorable court, that is dismissed as withdrawn, and then, my lord, he files the suit.
Yes.
Then, Lord, in the suit, my lord, the LRs, my lord, are brought on. By that time, my lord, original defendants 1 and 2 had died, and the LRs are brought on record insofar as defendant number 2 is concerned, because the first defendant, my lord, had died without any issues. That is how, my lord, the will of first defendant in favor of third defendant is executed while she was alive. Lord, in the suit, my lord, we file our written statements contending on merits that all that, my lord, the plaintiffs vendors could have sold was 1/3, nothing beyond that. Lord, in spite of that,
what was the total extent? The suit property is ಯಾವ survey number?
A suit property survey number 112, my lord.
112.
32 guntas in survey number 112.
ಎಷ್ಟು?
112, 112.
ಎಷ್ಟು total extent?
Total extent ಇರೋದೇ 32 ಗುಂಟೆ ಅದರಲ್ಲಿ.
32.
ಅದರಲ್ಲಿ ಇರೋದು 32 ಗುಂಟೆ ಮಾತ್ರ.
How much is sold?
Entire 32 guntas.
To the plaintiffs.
To the plaintiff.
Is ಮಿಕ್ಕಿದ survey number?
ಮಿಕ್ಕಿದ ಸರ್ವೆ ನಂಬರ್ ಇದೆ, ಅದು what has transpired, my lord, is either of the parties, my lord, are not able to say, my lord, what has happened to the other survey numbers.
But these lands are granted.
Granted lands.
ಎಷ್ಟು total extent ಎಷ್ಟಿದೆ?
Yes, my lord.
Lord, since survey number 37 is 3 acres 35 guntas.
3 acres 35.
112 is 32 guntas. Survey number 83 is 20 gunta. My lord, so that is 83 is 1 acre 20 guntas.
And survey number 130
is 6 acres 17 guntas.
Lord, in the order, my lord, of the regrant of the Shanbog Inam lands of all these 4 survey numbers, Lord, it is clearly mentioned, my lord, as to what is the extent, my lord, all the parties are entitled to. But on the tabular column, what they have done while distributing, 2 survey number ಮಾತ್ರ ನಮಗೆ ಬರೆದಿದ್ದಾರೆ, ಇನ್ನು 2 survey number ಜಾಸ್ತಿ ಇರೋದನ್ನ ಅವರಿಗೆ ಬರೆದಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಅದೇ exhibit P1, my lord, may kindly be seen. Exhibit P1. LCR ಇದೆ, that would be better, my lord, if
Exhibit P1 ಅಂತ.
Exhibit P1. LCR ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ it may be ಬಂದಿಲ್ವಾ?
Page 50, my lords.
But
page 50.
Page?
Page 50.
Page number 50, not exhibit P1.
ಇಲ್ವಾ LCR ಇಲ್ವಾ?
LCR.
Yes.
ಅಲ್ಲಿ ಕೆಳಗಡೆ at the bottom lot of page 50, 4 survey numbers lot of Kariyobnalli village is described.
Yes.
37 survey number 3 acres 35 guntas, survey number 112 ಅದು 32 guntas ಆಗಬೇಕು 52 ಅಂತ ಇಟ್ಸ್ ಮಿಸ್ಟೇಕ್ ನೋಡಿ 32 guntas. 83 ನಲ್ಲಿ 1 acre 20 guntas ನೋಡಿ to be, and survey number 130 last 6 acres 17 guntas.
ಅದು ಗೊತ್ತಾಗುದು
ಓದಿ ಏನು ಆರ್ಡರ್ ಓದಿ. Produce the document and roll.
Order nalli peruse the documents and heard the parties. The claimants have stated that they have nothing to say other than the statement deposed before the Assistant Commissioner Bangalore on 5/10/1976. They are agreed by that. Further, it is revealed from their joint statement that survey number 37, reserve number 112, reserve number 130 is in their joint possession of KV Venkataramanappa and KV Narayan Rao and KV Ramana and KV Hanmant Rao as 1/3 of share, and other 2/3 of the share is in enjoyment of Ramkrishnappa and Lingamma. The said land is not alienated. The claimants are some mistake not in that.
Credited the company
ಅದು
price,
credited
occupancy price.
company-
as per,
company price
credited
ಅಲ್ಲ.
the occupancy price as per the rules on following lands has been regranted
The claimants-
in the favor of the claimants as per their share and the enjoyment.
As per their share and enjoyment ಅಂತ. Next page ತಾವು ನೋಡಿದ್ರೆ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಕಾಲಮ್ ಬರ್ದ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 3 acres 36 guntas, 32 guntas, 20 guntas and 7 guntas. Entire all the 4 survey numbers to that extent is disclosed in the name of the vendors of the plaintiff.
ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಹಾಕಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಆ ಸರ್ವೆ ನಂಬರ್ ಹಾಕಿಲ್ಲ, ಎಕ್ಸ್ಟೆಂಟ್ ಮಾತ್ರ ಬರೆದಿದ್ದಾರೆ. 3 acres 35 guntas, 32 guntas, 20 guntas and ಡಿವಿಷನ್ ಮಾಡಿರೋದು ಮಾತ್ರ 2 acres 7 guntas. ಲಾಸ್ಟ್ ಜಾಸ್ತಿ ಎಕ್ಸ್ಟೆಂಟ್ ಇರೋದ್ರಲ್ಲಿ ಮಾತ್ರ ಇಲ್ಲಿ ಡಿವಿಷನ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. All the survey numbers are not divided and shown. This is the mistake, my lord, of that authority. Ali next column nalli in the foregoing facts, the land in survey number 37, 112, 83 and 100 of Kariyobnalli village, Yeshwantpura Taluk, Bangalore Taluk has been regranted in favor of the claimants noted against each of the above under section 5(1) of the KV Act 1961. Subject to the condition that this order is without prejudice to the tenancy rights if any.
ಇದೇನ ಜಾಯಿಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಇದೆಯಲ್ಲ ಅದೇನದು?
ಆ ಜಾಯಿಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾವು ಮತ್ತೆ ಅವರು ಎಲ್ಲರೂ ಮಾಡಿದ್ದ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅದೆಲ್ಲಿದೆ ಅದು?
ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ಬಟ್ ದಿಸ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಬಿನ್ ರೆಕಾರ್ಡೆಡ್ ಮೆಲಾನ್ ಇನ್ 1982. Joint statement of all the parties that 1/3 of all these survey numbers is with the first group, 1/3 with the second group, 1/3 with the third group. So 2/3 melod for defendants 1 and 2, 1/3 melod for them.
ಬಟ್ ಎಲ್ಲ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲ?
ಎಲ್ಲ ಸರ್ವೆ ನಂಬರ್. That is precisely melod what is been said.
ಬಟ್ ಇಲ್ಲೇನೋ ಬೇರೆ ತರ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
ಅದೇ ಇಲ್ಲಿ ಇದು ಅಲ್ಲೊಂದು ಅದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ that is the mistake melod what is
ಆರ್ಡರ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪೋರ್ಷನ್ ಏನೋ ಇದೆ ನೋಡಿ. ಫರ್ದರ್ ಇಟ್ ಇಸ್ ರಿವೀಲ್ಡ್ ಫ್ರಮ್ ದ ಜಾಯಿಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ಸರ್ವೆ ನಂಬರ್ 37, 112 ರೀ ಸರ್ವೆ ನಂಬರ್
130 ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲೂ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. But what we are now concerned is not survey number 112 measuring 32 guntas is in the joint enjoyment of first group our 1/3 share and 2/3 of the share is in enjoyment of Ramkrishnappa and Lingamma.
ಯಾವ್ದೋ ಕಲಬುರ್ಗಿ ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ. ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್ ಟುಮಾರೋ.
Yes madam.
Just tomorrow. Yes. ಕರಿ ಕಲಬುರ್ಗಿ
Matter pertains to Kalburgi bench. For further hearing, serial number 1, BD
appearing online. For a
no
respondent.
change of mind.
ನಮ್ದೇನಿಲ್ಲ.
No change of mind.
ಹೌದೇನಿಲ್ಲ.
change of mind ಇಲ್ಲ.
ಏನಿಲ್ಲ.
Yes, ಹಂಗರ್ಕಿ ಇಲ್ಲಿದ್ದಾರೆ. BD ಹಂಗರ್ಕಿ
is not. He is not present, sir.
ಲಿಸ್ಟ್ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡ್ರಿ ನೋಡೋಣ.
Same stage can we continue? sir?
Can proceed for judgment, my lords. ಎಲ್ಲ argument ಮುಗಿದಿದೆ.
Please wait. Correct, you have argued, we know.
Yes.
Time is the best heal ಅಂತ ಏನೋ ಇದೆಯಲ್ಲ. Time is the best heal. ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ.
Yes.
ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ. Last year. Huh? 17th April ಕೊಟ್ಟಿರಿ. 17th April. List on 17th April.
17. Yes.
Yes, 17th April.
Yes.
No,
Yes, sir.
We have constraints. Yes.
Yes, yes. No.
ಆಯ್ತಾ?
ಸಾಹೇಬ್ರು ಬಂದು ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ನಾನೇ ಇಂಟರ್ಫಿಯರ್ ಆದೆ. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಅದೇ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಆಗಿದ್ರೆ ಇವರು ಯಾವ್ದು ಕನ್ಕ್ಲೂಡ್ ಆಗೋ ಥರ ಇಲ್ಲ ಇದು.